Good afternoon. Welcome to Economic Matters. Today is Wednesday, March 4th. Welcome to our 1 p.m. bill hearings. We have about 14 bills on the docket and 106 witnesses. With that said, if you are new to the committee, please know that we are here to listen to each of you in your testimony. The bill sponsors are not timed, but I would respectfully request that the legislators keep it under 3 minutes, given the number of witnesses we have. We were here till 9 p.m. last night. We don't really want to repeat that today. For those who are new, if you are testifying in a panel, except for the bill sponsor, you will be timed 2 minutes. If the clock catches you, please do sum up. Don't continue to read your script. We actually prefer you speak from the heart because it usually gets the point across better that way. Also, if you are going to be testifying orally, please don't repeat what someone has said already. You can always say me too or ditto. That works as well. With that said, let's get started. We will begin with House Bill 1166. Delegate Polakovich-Carr, if you have your panel with you, can bring them up.
There we go. Okay. Good afternoon. For the record, I'm Delegate Julie Polakovich-Carr, here to present House Bill 1166. Maryland is among the 31 states that require vehicles to display both a front and rear license plate. Unfortunately, some Maryland motorists are not complying with state law. This poses a threat to public safety as well as causes the state to lose out on toll revenues. This bill would make it easier for Maryland drivers to comply with the law by requiring vehicles sold in Maryland to have a front license plate holder installed at the time of sale or lease. First, some context. In Maryland, it is a misdemeanor to not display a front license plate, subject to a fine of up to $500. Last year, 4,000 citations were issued. And anecdotally, I feel like I'm seeing more and more vehicles that have rear Maryland plates, but not a front license plate. Front license plates serve an important public safety function. The Maryland State Police stated in their informational testimony that, quote, from a public safety perspective, the additional front plate plays a pivotal role for investigators. Officers and civilian witnesses across the state can easily identify and report vehicles suspected of involvement in criminal activities, missing persons cases, hit and run collisions, or other motor vehicle related investigations, end quote. And the state police also cited in their testimony the importance of front plates in law enforcement operations involving automated license plate readers. About 30 to 40% of the time, that automated technology is detecting the car or vehicle's front plate. Front plates are also important for collecting toll revenues on our state's toll highways and bridges, as documented in a recent report by the Maryland Transportation Authority. Although many vehicles have an easy pass, they're not required to, and sometimes that technology isn't failed proof. So in those instances, the photos of the vehicle's plates need to be used. In 2024, there were 15 million transactions for which MDTA relied on imagery of the vehicle's license plate. And in 43% of those cases, it was the front plate that was used. So without those photos, the state would have been unable to invoice 6.6 million transactions totaling $35 million in toll revenue. So clearly there's a lot of benefits to front license plates. Unfortunately, some vehicle owners are willfully breaking the law by choosing not to install a front license plate for cosmetic reasons. Other drivers are struggling to comply with the law when their new car doesn't have a front plate holder installed on it. Some cars do have an obvious place where a front plate should go, but that's not always the case. Sometimes an additional part needs to be installed. And I think that's where auto dealers should come in. Honestly, I don't think that police can ticket our way out of this problem, and I think we need to solve it proactively before vehicles are on our roads. That's what California has required for more than 20 years. This bill is based on a California law which requires licensed auto dealers to equip vehicles with a front license plate mount prior to delivering the vehicle to the new owner. And this makes it very easy for drivers to comply with the law. That was certainly my experience a few months ago when I bought a new car from a dealer in my district. They automatically installed the front plate holder before they delivered the car to me. So that meant when my permanent plates came in, it was very easy to comply with state law. And from my perspective, it was just good customer service. My guess is that there are a lot of auto dealers in Maryland that are doing the same thing because they know that it makes their customers' lives easier. For these dealers, this bill doesn't change anything. This bill is about the dealers who are allowing their customers to drive off their lot while committing a misdemeanor. And it's not just the vehicle owner who's breaking the law. Under state law, a dealer could be could be considered a principal or accessory to a customer who refuses a front license plate bracket. It's a misdemeanor, and the Motor Vehicle Administration has recently reminded dealers of their obligations, existing obligations under state law. I really view this bill as a way to help auto dealers comply with the existing law. Now, I recognize that some customers might be difficult and might refuse the front plate mount, and that's why the California bill and this bill include an opt-out mechanism. The buyer or lessee could sign a written acknowledgement, that they refused installation of a front plate, and under the bill, a copy of that signed agreement would be provided to the MVA. As I wrap up, I just want to flag that I do have several sponsor amendments forthcoming. One, to limit the bill to just the sale or lease of new vehicles, not used vehicles. Also to limit to just vehicles that are being registered in Maryland by the dealership, since some of our neighboring states do not require front license plates. Also to clarify that a broader array of mounting mechanisms would be allowed, such as like a clip-on or adhesive-based bracket, and that the amendments will also streamline the reporting requirements. So instead of being a standalone monthly report, that the dealership would provide a copy of those signed waiver forms as they are registering the vehicle and sending that paperwork to the MVA. So I'll conclude with an excerpt from the favorable testimony that was submitted by the Maryland Chiefs of Police Association and the Maryland Sheriff's Association. Quote, ensuring that vehicles are equipped at the point of sale promotes uniform compliance, eliminates confusion, and prevents situations where a lawful requirement is undermined simply because the proper mounting hardware was not installed, end quote. Thank you for your consideration.
Thank you. Are there questions for Delegate Polakovich-Carr? Seeing none, that concludes the favorable. We'll move on to unfavorable. J. Peter Kitzmiller.
Vice Chair, members of the committee, my name is Peter Kitzmiller. I'm the president of the Maryland Automobile Dealers Association. We represent 300 franchised new car and truck dealers across the state of Maryland. Here today testifying in opposition to House Bill 1166. I want to thank Delegate Carr. We met a couple times over the summer to talk about this issue, but ultimately we are still in opposition. As the delegate stated, Maryland law requires 2 tags to be on a vehicle. Compliance with the requirement, however, is a matter of enforcement for law enforcement and Motor Vehicle Administration, not automobile dealers. While some states, and she mentioned California, require written disclosure when a customer declines installation of a front license plate bracket, House Bill 1166 goes significantly farther. In addition to requiring a written disclosure, the bill would require dealers to submit monthly reports to the Motor Vehicle Administration identifying every customer who signed that disclosure. There are also practical issues. Since COVID, the way we do tags has changed dramatically in our business. A majority of the new cars that are sold go out on temporary tags. We get the hard plates. In a lot of circumstances, we simply mail those plates to the customer so they don't have to come back into the dealership. So we really don't have access to, or have any knowledge of whether or not the tag was put on or not. And the last point is, California's had this law since 2005. There has been no increase in front license plate compliance, or however you want to term it, in California. They are still basically enforcing their front license plate requirements by stop tickets and fix-it tickets in California. So at the end of the day, you know, we certainly want to help comply with the law, but this is not a function for an automobile dealer, and we would ask for an unfavorable report.
Are there questions for this witness? I guess I have a question. I'm trying to understand. We're talking about putting on a front license plate holder, is that right? And you're saying that is... No. I think the bill's talking about putting a front license plate on the vehicle. No.
Yes. Oh, that's what...
The bill says you have to affix the actual plate. I believe the bill says you have to affix the plate holder. I guess, well, here's a question. If it's the plate holder as opposed to the plate, would that change your position?
No. As a matter of course, on most vehicles, the dealer, as a matter of course, puts the front license plate bracket on the vehicle.
That's been my experience, which is why I'm trying to understand your position.
But there are a fairly, I don't want to say large, I don't know how you quantify how many it is. There are a number of customers that don't want the bracket drilled into their license plates. Most EVs, and I don't really understand I haven't gotten an explanation as to why this is. Most EVs do not have a place to practically put on the license plate bracket. And again, we are a state that doesn't have, not one of my dealers is more than 50 miles from a border. Delaware, West Virginia, Pennsylvania are single plate states.
Okay.
So over in, like, for example, on the Eastern Shore, I talked to one of my dealers, Delaware customers adamantly do not want the bracket put on the car before it's delivered.
Okay. So, but you do different things for Maryland when you do things in, when you're in Maryland, you're getting Maryland plates. When you're in Delaware, you're getting Delaware plates for them, right? So you already do things differently for people in different states.
Correct, but if I'm a dealer over in Salisbury, I'm not going to probably, as a matter of course, put the front license plate bracket on all my inventory, which I might do in Baltimore, because 30% of my customers are coming from Delaware. They don't want that on there.
Okay. I think I understand your position. That's helpful. Thank you. Are there any other questions? Yeah, Delegate Rose.
Thank you, Madam Chair. I unfortunately had to just buy a new car because I had a little fender bender. But I bought mine. I live about 5 miles from the PA line. So I want to just clarify, because I don't think I have a front bracket. They're going to mail me my tags. So I don't have a bracket because it's coming from Pennsylvania. Is that what you're saying?
No, I'm sorry. Say it again. I'm sorry.
The car I bought in Pennsylvania probably does not have a bracket. Is that what you're saying?
It's probably.
Because I don't think, now that you're saying it, I don't recall seeing one. So, okay.
Yeah.
All right, I just wanted to clarify.
Okay.
Thank you.
Thank you.
That concludes the hearing for HB 1166. We'll move on to HB 307. Delegate Shi.
I may have Denisha Rucker. Is Denisha Rucker with me? All right. Good afternoon, Madam Chair and ECM Committee. I'm Delegate Olici again here presenting HB 307, which is about the Community Reinvestment and Repair Fund alterations. HB 307 builds on the bill we passed the last year, which I also sponsored, related to the county use of cannabis sales tax revenue to ensure consistency and greater accountability of how these funds are used. For context, the Community Reinvestment and Repair Fund, also known as CRRF, was established a few years ago by this body to support communities disproportionately impacted by cannabis-related arrests in the name of war on drugs. It accounts for approximately a third, slightly more than a third, of the state's total sales and use tax revenue, and the fund is distributed proportionally to counties. So last year's bill established the guidelines on how the counties can use those funds to support communities. Mostly, the funds should be channeled to community-based initiatives and nonprofit organizations benefiting low income and those impacted by the enforcement of cannabis prohibition, and plus some admin costs. However, as we have seen from the past year when the funds were distributed, while most counties did just fine, there were some local jurisdictions that have channeled the funds to regular government agency operations that otherwise have received government funding, which deprives communities in need of this dedicated funding. So this year's bill basically is to further enhance the guidelines and make it abundantly clear what these funds should be used for and what they should not be used for, basically. So this year's bill reinforces that CRRF, the Community Reinvestment and Repair Fund, must supplement, not supplant, existing funding streams, and capping admin expenses at 15% per year. It also ensures expenditures align with the statutory intent, so the language changes from may to shall for how the funds should be appropriated. And it also requires counties to make their plans of fund distribution public for greater transparency. and also identify populations most impacted. There is no opposition to the bill. There is an amendment that we have already submitted to take out the requirement that the Comptroller's Office must administer the fund in consultation with the Office of Social Equity. So that language is out. And we are also working on a couple of potential amendments as proposed by MACO about identifying geographic areas because of the difficulty of doing that. And also the Department of Social and Economic Mobility's potential amendment about the funding for administrative overhead. So with that, I urge a favorable report and turn to my witness. Thank you.
Thank you, Madam Chair and honorable members of the committee. My name is Dinesha Rucker. I'm here on behalf of Maryland Legal Aid. Throughout our 12 offices, Maryland Legal Aid staff see the disproportionate impacts of cannabis criminalization on every low-income community throughout Maryland. Although Maryland has legalized cannabis and pardon and seal those records, the destabilizing impacts of decades of surveillance, over-policing, arrests, prosecutions, and incarceration still vibrate throughout those communities. The Community Reinvestment and Repair Fund was established by this body as a tool to redress this reality through reinvestment and repair. This bill is how Maryland ensures that this actually happens. House Bill 307 mandates specific purposes that counties must utilize their funds for, ensuring that impacted communities receive the benefit of the fund. Additionally, the bills narrowly define stakeholder participation requirement in county planning. It centers impacted persons, ensuring a community-driven approach where impacted voices are in the room. It ensures transparency and accountability by requiring a publicly available county plan. Maryland's low-income communities, especially those of color, have experienced chronic disinvestment. Although this is not solely solved by the fund, it's certainly a crucial step in addressing cyclical disinvestment. This step can be taken only if the funds are used for their intended purpose to redress racist and discriminatory policies and are used as a reinvestment tool for those communities that have been long over-policed, over-criminalized, and underserved. This bill is how we ensure that the communities receive the benefit of this fund. Maryland Legal Aid urges a favorable report on House Bill 0307. Thank you.
Thank you. Are there any questions for this panel? Seeing none, we'll move on to favorable with amendments, and we have Carrington Anderson. Thank you.
Thank you, Madam Vice Chair, members of the committee. My name is Carrington Anderson, here on behalf of the Maryland Association of Counties in support of House Bill 307 with amendments. I do want to thank the sponsor for bringing the bill, and I think counties do support the intent and the goal of the bill. There's a few pieces that we're working out with both the House and the Senate sponsor, and I think we're close there. I do think some of the county concerns is a lack of clarity. There are some counties that still have not been able to spend this money locally, and that because of definitions like low income and disproportionately impacted. The Office of Social Equity is saying some of these jurisdictions haven't met those definitions. So I think some counties have asked for clarity from the Office of Social Equity and haven't gotten that clarity. The Office of Social Equity was supposed to have regulations out in October, which were supposed to help some of that guidance, and those regulations still aren't out. So I think there is some concern with passing new restrictions and for more requirements when some of those issues still haven't been addressed locally. That being said, I do think some of our concerns are almost addressed, almost there, and do appreciate working with both sponsors. Thank you.
Thank you. Are there any questions for this witness? Okay, please keep working with the sponsor.
Will do. Thank you.
That concludes the hearing on House Bill 307. We're going to move on to House Bill 1100. Delegate Pruski. And I have three favorable witnesses. Are they your panel?
Yes, is Alex here?
That's Alex Austin, Rob Garagiola too.
Yep.
No one else better sneak up there.
Thank you, Madam Vice Chair. I'm just going to get started. I know we have a lot of witnesses. Delegate Andrew Pruski, everyone here, for HB 1100 Telecommunications Infrastructure Protections. HB 1100 requires a junk dealer, scrap metal processor, or antique dealer residing in the state of Maryland to register a complete description of purchased telecommunications equipment with local law enforcement, restrict the authorized payment method for purchases of telecommunication equipment by these dealers and processors, and subject violators of these prohibitions to business license revocation and criminal penalties. The bill basically prohibits a person from recklessly or willfully and maliciously damaging telecommunication infrastructure and establishing that criminal penalty. Finally, the bill adds telecommunication equipment to an existing definition in the law, junk or scrap metal used in the provisions that address licensing, record keeping, and procedural requirements for junk dealers and scrap metal processors. So what do we mean? Telecommunication equipment means an item or individual knows of, reasonably should know, to be ordinarily used to belong to a telephone, telegraph, internet, or wireless communication company. In recent years, there's been a significant rise in theft of copper and engineering equipment, as well as the destruction of these telecommunication and broadband assets. The impact of these incidents are significant and should definitely raise concern. Not only does it disrupt day-to-day communication, but just imagine if somebody's trying to make a 911 call and the equipment doesn't work. That is a safety issue. This bill adds telecommunication infrastructure and equipment to the state existing criminal code governing vandalism of gas, water, and electrical equipment. It also updates the regulations requiring scrap metal dealers to apply to the telecom equipment as they already do not in these types of materials. This is not an original idea. Other states have done it. When you look at Kentucky, California, Texas, Minnesota, West Virginia, Hawaii, they've already led this path in making sure that these infrastructure items are protected. I do want to thank and recognize that there's been some opposition to the bill. You've seen it in your floor system. I've been working with them on amendments to try and find some favorable ground. I am asking for a favorable report for HB 1100, and I do have some witnesses here today that will help explain more on why this bill is important. Thank you.
All right. Madam Vice Chair and members of the committee, Rob Gergil with Compass Advocacy, here on behalf of CTIA, the Wireless Trade Association, in support of House Bill 1100. I want to thank Delegate Pruski for sponsoring the legislation. I think he highlighted kind of a lot of the main points that I was going to emphasize. This is a problem that is occurring nationally, but is also occurring in Maryland. I think we had about 16,000 incidents reported last year throughout the country. As Delegate Pruski mentioned, a number of states have enacted similar legislation, so we're not treading on new ground. Because of the use in our everyday lives of telecommunications, if something does happen, that's going to impact folks. And we're using it for telehealth, we're using it for commerce, we're using it for a range of reasons. And it's very important to kind of have telecom equipment in the same area as other types of theft or vandalism are occurring with other types of items in the existing Maryland code. I'll also add that we've had some conversations with the scrap metal processors. We've begun maybe working on some amendments. We're actually going to have another conversation with the Senate cross-file and Delegate Pruski again this Friday. I think we're close to getting to some resolution that may not make everyone perfectly happy, but can make progress in dealing with this issue. And so I'm very hopeful that we'll be able to accomplish that. And with that, would ask for a favorable committee report.
Good afternoon, Madam Vice Chair, members of the committee. Alexander Austin, President and CEO of the Prince George's Chamber of Commerce. We represent 800 businesses within Prince George's County and the region. We're in support of House Bill 1100. And as you mentioned before, the bill aims to strengthen protections for telecommunications equipment and infrastructure. And by influencing and deterring theft and miscellaneous damage to our infrastructure, it will, I think, deter infrastructure harm, financial harm to our members. Reliable telecommunication service is essential for our business community and Prince George's County. It supports things like, credit card processing, logistics dispatch. We talked about public safety concerns. And one of those things that we think about is, if we do have a service outage, how are we going to respond? If this causes financial harm for employers and the residents, that is going to be catastrophic for our county, region, and ecosystem. And we would like to, by definition, by including telecommunication equipment into the focus area, we think that we can, one, continue to provide support, the telecommunications infrastructure that we need for our business community and for our residents. And with that, we encourage a favorable support.
Thank you for your testimony. Are there any questions for this panel? Seeing none, that concludes the hearing on House Bill 1100. We're now moving on to House Bill 1120. Delegate Rogers. Your intern's going to do it. And is David Dragix, that's your witness, is that right? Yes, sir. All right, please come on up. You can state your name for the record and begin whenever you're ready.
My name is Joy Floyd. Good afternoon, Delegate Valderrama and the members of the House Economic Matters Committee and members of the House Health Committee. I am Joy Floyd, a fellow for Delegate Rogers in the Veterans Caucus, giving testimony in favor of House Bill 1120. I respectfully request a favorable report of House Bill 1120. The purpose of this bill is to explicitly authorize the foreign service member or a foreign service member's spouse who relocates to the state due to an assignment or detail to the state and holds a license issued by another jurisdiction to practice under that license for the duration of the assignment or detail within Maryland, if the individual provides specified documentation and satisfies other criteria. This portability provides tremendous benefits to our foreign service members and for their families. If a foreign service member or spouse is authorized to practice a bill under the bill's provisions, the individual may practice only in the discipline and scope of practice allowed by the license and in other jurisdiction, and in the licensing authority in the state may not require other license unless the individual seeks rights to do so. Practice of the authorized discipline or scope of practice. This bill takes great strides in making Maryland more welcoming for our foreign service members and their families. Now, while we have tremendous support from many departments, boards, and advocates, there have been discussions with some of the health boards to discuss proposed amendments. The amendments are reprinted and attached to my testimony. I respectfully submit a favorable report of House Bill 1120.
Excellent, thank you. Mr. Dragix.
Vice Chair Charkoudian and members of this committee, thank you for the opportunity to testify in favor of Delegate Rogers' bill. I'm Dave Dragix, retired Army Colonel and the Legislative Director for the Maryland Military Coalition. This bill will make it much easier for members of the Foreign Service or their spouses who have a license issued by another jurisdiction and who have relocated to Maryland on assignment or detail to practice using that specific license as long as certain conditions are met and as long as they are assigned here. In addition, if the licensee is able to practice in multiple jurisdictions through an interstate compact, the provisions of that compact apply. In short, this bill eases the burden of transferring a license for members of the Foreign Service or their spouses. The Maryland Military Coalition believes that this bill is proactive. It's a common sense solution that benefits members of the Foreign Service and their spouses who are nonpartisan, professional diplomats, and specialists representing our nation around the world. In particular, it will help the spouses obtain employment more quickly upon relocation. This bill is recognition of the service of these dedicated individuals. For these reasons, the Maryland Military Coalition strongly supports HB 1120 and asks for a favorable report from the Economics Matter Committee. We would like to thank Delegate Rogers for sponsoring this important legislation and appreciate his leadership on this issue.
Thank you. Are there any questions for this panel? I think Delegate Rogers avoided the hard questions by sending his intern up. I see what you do. You did an excellent job, Joy. Thank you for your testimony. We'll now move on to favorable with amendments. Daniel Doherty. Is Daniel Doherty here? Going once? Okay. Well, I think we have testimony on record, so you can follow up with them. That concludes the hearing on House Bill 1120. 1180. No, 1120. We're now moving on to House Bill 1180. It's Delegate Chi. You ready?
Yeah, I know we should limit how many bills I talk about.
What's that? Yeah, we're going to put a bill limit on now that we're seeing how much Delegate Chi is getting up there.
All right. Okay. Ooh. Okay. Actually, I have several members for my panel, if I may bring them up. If you
I see a Lawrence Frank and a Craig Maloney. Is that?
Yeah, Eric Cavalier and.
Eric is the virtual?
I'm sorry, that's right. Lawrence Frank and.
Is a Lawrence and a Craig? Is Lawrence Frank here? Craig Maloney? Okay.
All right,
Well,
I'll
if you just
start.
want to go, and then do we have Eric on? Yeah, Eric is ready virtually.
Okay, all right. Okay, good afternoon again, Madam Chair and members of ECM. I am Delegate Lily Chi here to present HB 1180, which addresses a gap in how counties verify an architect's credentials and how the State Board of Architects adjudicates violations. Basically, this bill would make our current law more enforceable and stricter. There have been incidents of individuals fraudulently representing themselves as licensed architects or use stolen and misrepresented credentials or continue to interact with the permitting authorities despite disciplinary actions. This legislation was requested by the Maryland chapter of the American Institute of Architects to protect the integrity of the profession and to protect customers and ensure fair market play. There are 2 sponsor amendments to the bill. So as amended, the bill strengthens the Board of Architects, which is part of the Department of Labor, enforcement authority against those who misuse or forge an architect's credentials by changing the language from the current law that says may to shall. For example, the board will be able to now investigate wrongdoings and issue penalties. And the board may establish an electronic portal to allow anonymous reporting of a suspected violation of this act. And second, it requires the board to notify counties when a license is revoked or suspended. It also requires counties to verify an architect's certified credentials before accepting any sealed documents or approve any plans. These changes close the loophole in our current law to ensure county permitting systems work together with state oversight to safeguard public safety, consumer interests, and prevent fraud. This legislation brings Maryland in line with several other states in preventing fraud and enforce our current spirit of the law. So with that, I will turn it to my panel. Would you like to go first?
Sure.
Okay. Yeah, go ahead.
Hi, Chair Valderrama, Vice Chair Charkoudian, and members of the committee. I'm Larry Frank. I'm here on behalf of AI Maryland, representing 2,000 architects across the state. We believe this bill is needed and request your support for House Bill 1180. This bill strengthens the State Board of Architects' authority when persons falsely represent themselves as licensed architects. It clearly adds misrepresentation of licensure as grounds for discipline. This bill proactively protects the public from fraudulent practice through notification of a licensed professional when plans are filed for permit. Our written testimony addresses how this issue is handled in other jurisdictions. I'd like to walk you through the permit submission process. When I was first licensed, we submitted actual paper copies of documents. These drawings were hand-stamped and wet-signed, and we physically carried these plans to the permit review office and handed them over the counter. Now, when I seal documents, my seal and signature is applied electronically to the documents digitally and saved as a PDF and uploaded to an online portal, often by a third-party expediter. For example, last week my client submitted permit documents for a project on our behalf. In this situation, there is no human interaction and no verification. There's ample opportunity for a bad actor to capture that seal and signature. One of the sponsor amendments adds specificity to this process, whereby the jurisdiction contacts the design architect, not just the person who submitted the drawings, to confirm that the architect is aware of the documents that were submitted and completed under their supervision. This process provides a higher level of public protection against possible fraudulent submission of documents to construct a project. This is why we ask for your support in a favorable vote. Thank you.
Okay. Chair and Vice Chair and members of the committee, I'm the real Craig Maloney. I'm an architect with CEM Design Architects in Rockville. A few years ago, I received a call from a structural engineer friend of mine asking if I designed a new store in a shopping mall. I replied that I had not recently. He proceeded to tell me that he received a call from a county code official about a retaining wall project bearing his signature and professional engineer seal that had been submitted for a building permit. The structural engineer told the code official that he did not design the retaining wall. The plans had been submitted by a building contractor who apparently copied the professional credentials and affixed them to his own drawings. The code official ran a check of all of the permit applications submitted by this contractor. He found plans for a residence that had been submitted using the engineer's signature and seal, and designs for a store submitted using my signature and seal. I never would have known that my professional credentials were being fraudulently used, but for the coincidence that the code official called a friend of mine. This is a public safety issue because buildings are being built without proper design and engineering, and I incur liability because my signature and seal are affixed to a set of plans. I contacted the Maryland Board of Architects to report the problem. I found that there is currently no way to track the use of professional credentials and no penalty for someone caught fraudulently doing so. This bill changes that. It establishes a simple requirement that the code official has to verify that the plans submitted for permit were in fact created by the professional who signed and sealed them. It also establishes penalties for fraudulent use of professional credentials. Thank you for the opportunities to submit testimony on this important issue.
Thank you so much. I'm looking around. I don't see any questions for you, Delegate Chi, or your panel. Thank you kindly for the testimony. I don't see, oh, we have one virtual favorable, Eric Catalier.
Sorry, okay, there we go.
You may begin.
Chair Valderrama, Vice Chair Charkoudian, Delegate Chi, members of the committee. My name is Eric Catalier. I'm a registered architect in the state of Maryland and a member of the American Institute of Architects and have been so since 2010. I'm a resident of Salisbury and continue to work and currently work for Rao Incorporated in Easton. I've previously worked for 2 other firms in Salisbury as well. I'm here today to support House Bill 1180. I helped add language to the bill to allow for anonymous reporting. I agree that it is important to safeguard the profession of architecture against those who try to shortcut or ignore the oversight of the State Board of Architects. In doing so, they put those who occupy their buildings at risk. The guiding principle of architectural registration in Maryland and across the country is the health, safety, and welfare of the occupants of our buildings. As professional architects, we want to design beautiful buildings. However, we are also held to several state, local, national, and international codes and standards. We need to ensure that those people who are designing buildings in Maryland are trained and capable of implementing not only good design, but safe design. Unfortunately, as in all industries, there are bad actors. In order to root out these bad actors, the system calls on its members to identify and report them. Our current system requires that those who submit a report must provide personal and professional information to be publicly attached to each accusation of wrongdoing. Based on my experience and that of other architects, I can attest that this process has given us pause. I've had to consider the repercussions that might fall back on me or my firm. I have to expect that those who operate unethically and unprofessionally will fight back in the same manner. We all live and work in tight-knit communities in Maryland, and if you've spent time on the Eastern Shore, you know this to be especially true. I worked with Senator Kagan in her office to provide the language for this bill to create an anonymous whistleblower reporting system. This system would empower anyone to report potentially unethical or illegal activities related to our industry. This would simplify the online reporting system and give the Board of Architects a better chance to protect both the integrity of our profession and the safety of the general public. Thank you so much for your time and consideration.
Thank you. I don't see any questions for you or the panel or Delegate Chi. Thank you so much for your testimony this afternoon. That concludes the bill hearing on House Bill 1180. We'll now move on to House Bill 1214. Delegate Ampry.
Yes, yes. I think Bill's he's in judiciary right now.
I promise, Madam Chair, this is hopefully one of my quick bills for the day. All right, for the record, Delegate Marlon Ampry here in support of House Bill 1214, Vehicle Manufacturers and Dealer Association Administrative Hearings. This bill authorizes vehicle dealer associations to request a hearing with the Maryland Motor Vehicle Association, meaning a dealer association on behalf of itself, a vehicle dealer, or a group of vehicle dealers can bring suit to recover damages and reasonable attorney fees or request an administrative hearing on certain matters. The bill will allow vehicle dealer associations to request hearings to resolve disputes between a dealer, dealer association, or designated dealer successor, and a manufacturer, distributor, or factory branch. It also permits vehicle dealer associations to request a hearing from the MVA to seek clarity or explanation of any provisions of applicable law, allowing for the associations to better align their business practices with current law and promote fair practice. This opportunity to request a hearing does not apply to a dispute involving a manufacturer, distributor, or factory branch that does not have at least one franchise dealer in the state. And with that said, I ask for a favorable report on House Bill 1214. I will leave it to my panel to provide more context, and they can answer any more detailed questions that you may have on the bill.
Madam Chair, members of the committee, my name is Peter Kitzmiller. I'm the president of the Maryland Automobile Dealers Association here today in support of House Bill 1214. With this bill, the committee heard this bill 2 years ago and passed it, but simply what this bill does, it provides that a statewide dealer association may bring an action before the Office of Administrative Hearing to enforce violations of Maryland's motor vehicle franchise and dealer licensing laws. The bill creates a practical enforcement mechanism for the laws that already exist. We believe this mechanism will reduce the need to return to the General Assembly each year to clarify dealer franchise laws, and allowing an administrative law judge to address these issues to help resolve questions is much more efficient than coming to this committee every other year. I want to be clear about this bill. There's some things it does not do. It does not create any new dealer rights. It does not create any new causes of action. The bill does not allow the dealer association to collect damages. It simply allows us to seek injunctive relief with the administrative law judge. There are 10 other states that currently have dealer associations standing. In none of those states have we seen an increase in litigation. And I think it's telling that the opponents of this legislation don't mention problems they're having in those other states because they just don't exist. Manufacturers count on the reality that dealers are very reluctant because of the entwined business relationship they have with their individual manufacturers to file a complaint even when a manufacturer's policy violates Maryland franchise law. This bill will simply allow the association to step into the shoes of a dealer and seek, again, injunctive or declaratory relief on what the law actually says. And for those reasons, we'd ask for a favorable report.
Thank you, Madam Chair, members of the committee. Bill Castelli on behalf of the auto dealers. We are in support of the bill and thank the sponsor for the legislation again. I did want to address one of the concerns that was expressed the last time this bill was before the committee, and that is the expansion of standing, legal standing to the association. And Maryland has done that in many other statutes since 1978 with the Environmental Standing Act, expanding standing to associations. In the 90s and 2000s, the legislature expanded standing to community associations for in certain county nuisance law situations. And as recently as 2010 with the Miscellaneous Environmental Protection and Proceedings Act, it extended federal standing, which includes associations, to many permit decisions. So this is not a new concept. It is not a unique concept in Maryland law. As Peter said, there's 10 states that already permit it. Damages are not included in the bill. That was actually something that was taken out of the bill back in 2024 by this committee. It just allows the administrative law judge to call the balls and strikes in terms of whether someone is complying with the law. So we think that this bill is a good bill. We don't think it is going to result in any kind of significant litigation. These dealer associations are not well resourced enough to just file lawsuits left and right. So it's really to clarify actions of manufacturers and dealers. So for those reasons, we encourage a favorable report.
Thank you. I'm looking. I don't see any questions for you, Delegate Embry, or your panelists. Thank you very much. We do. Oh, I'm sorry. Delegate Pippy has a question.
Just real quick, I don't know, either Delegate or Kitzmiller, can you just give an example of why this would be necessary, just for the good of the order?
Yes, Delegate. So I'll give you a perfect example. About 10 years ago, there was a trend in the automobile business where certain highline vehicles like Land Rovers, Porsches, those kind of vehicles, a customer would come into a Maryland dealership, buy the vehicle, we would register that at a Maryland address and collect the taxes, but ultimately that vehicle would be exported to Eastern Europe, to Russia or to some Eastern European country because it was still cheaper, I guess. And so the manufacturers, that's a significant problem for them, and it absolutely is. It messes the warranty up. So they had a concern about these vehicles being exported. And so what they would do, they'd come to the dealer, the Porsche dealer, and say, we're going to charge you back all the profits you made on that Porsche deal because it got exported, and we're not going to send you any more of those vehicles for a certain period of time. We came to the General Assembly, we worked with the manufacturers and came up with a law that said that the manufacturers cannot charge a dealer back unless at the time of the sale the dealer knew or should have known that the vehicle was going to be exported. And for example, there are people that get on a list that export vehicles all the time. If we sold a car to one of those individuals, didn't check the list, then yes, we would get charged back. But absent that, if we registered the car to somebody in Ocean City and collected the tax, then the law would not allow us to be charged back. A month after session ended, Porsche North America sent a letter to every one of my Porsche dealers telling them, you basically get one free one, and then after that, we're going to charge you back for every one after that. I sent a letter to Porsche, outlining how the law had changed, never heard a response. But an individual Porsche dealer is not going the juice is not worth the squeeze for them to proceed and file a complaint with Porsche over one or two car deals. But it violates the law that you all passed, and that's what this bill would allow us to do.
Oh, there we go. All right, so in a nutshell, what you said is that it's just enables multiple dealers to kind of get together if there's a kind of a global issue that needs to be addressed rather than an individual dealer. All right, fair enough. Thank you very much. Thank you, Madam Chair.
I don't see any further questions. Thank you very much, Delegate, and your panelists. We do have opposition. I'm calling on Bill Kress.
Good afternoon, Madam Chair, members of the committee. Bill Kress here today on behalf of the Alliance for Automotive Innovation in opposition to the bill. So why did the proponents want this bill? It's certainly not because they can't afford legal counsel. The top 7 dealers in the state of Maryland make over $1 billion a year in revenue. What they gain out of this legislation is to have the association act as a shield in a proceeding. Typically, in a legal case, you have to have standing. You have to be an aggrieved party, or you have to have privity of contract in order to bring an action. In this case, there is no privity of contract. The Dealers Association isn't part of the contractual agreement of the franchise agreement. They're not an aggrieved party. When we have these proceedings, we have no ability to get discovery from the actual aggrieved party below the association. And so that presents a unique problem for us. Beyond that, this bill has quite a bit of drafting issues and issues that really haven't been contemplated. In particular, the right to an appeal. So for an appeal under the APA, the Administrative Procedures Act, you have to be an aggrieved party. That's not contemplated in this bill. If you were to pass this bill, you'd have to look at language within the APA. Going beyond that, you have issues of dealers who may not be in line with the association. There's no fiduciary responsibility on the Dealers Association to protect all of the dealers. And so that's not addressed. You've heard that this has been done in other states. That may be the case. But this needs to apply to the Maryland procedures. Under the MBA hearing, you get interrogatories from the aggrieved party. In this case, it would be the Dealers Association standing in the shoes of the dealers. We can't actually get to the aggrieved party. So for those reasons, we'd ask for an unfavorable report.
Delegate Ahrens.
Yep. Thank you, Madam Chair. I'm reading some of your testimony, and this one part's kind of confusing. It says, by allowing multiple parties the option to recover the same damages, this bill is likely to lead to further confusion and litigation instead of following and streamlining it. Can you help me with what that means?
Yeah, so I did hear the proponents say the bill is limited to injunctive and declaratory relief. I don't see that in the legislation. Perhaps I'm missing it. But anytime you have a case where it's the association acting on behalf of the dealers, there are a couple of issues that happen. One is the issue of whether or not there's estoppel or latches. Legal terms meaning this issue's been decided by the association. You can have dealers who are not in line with that decision, who may be closed out from bringing additional actions. Again, referencing back the fiduciary duties that should be placed upon the association, they should be protecting all of their dealers, making sure they're all aligned. There's nothing in this legislation that does that. So I mean, that's some of the issues. I don't expect that there'll be monetary damages awarded, but the bill isn't drafted in that manner. At least I don't see that language.
Okay, thank you.
I don't see any further questions, Mr. Kress. Thank you very much
Thank you,
for your
Madam Chair.
testimony. And seeing no other witnesses for this bill, that concludes the bill hearing on House Bill 1214. We'll now move on to House Bill 1246. Is Delegate Lewis here?
Thank you, Madam Chair. I'd like to bring up my panel. Thank you. My panel is, my panel knows who they are, so they should come up.
So I will say, Delegate Lewis, we don't have anyone signed up for you except for a virtual.
Is that right? Okay. Well, thank you, Madam Chair. If they're there in cyberspace, that's wonderful. Thank you so much. I'll get started. I'm Delegate Robin Lewis, here on behalf of House Bill 1246. That's the Maryland Department of Health Employment Training and Opportunity Database. This is a really simple bill. This is a bill that will protect and advance affordability, opportunity, and accountability in our state. This bill will simply require the Maryland Department of Health to create a database of employment and training opportunities to help Marylanders currently receiving or eligible for Medicaid and SNAP benefits to access training and job openings. Why is this important? We know that the federal legislation, H.R. 1, which is referred to by some people as the big, beautiful bill, and by others, sometimes referred to by a number of nicknames that I won't repeat. That bill will cut Medicaid and SNAP funding. As you know, Medicaid is a jointly funded federal and state public health insurance program. The federal government contributes to the premiums, and so does the state. Here in Maryland, the Medicaid program covers over 1 million people. Those are our constituents, our friends, family, our neighbors who need and deserve access to health care and that publicly funded health insurance. SNAP, as you know, is an acronym for the Supplemental Nutrition Program, the Supplemental Nutrition Assistance Program. That is a federally funded food security program, a national food security program. Any changes in eligibility to Medicaid or cuts to Medicaid funding from the federal level, and any cuts to SNAP at the federal level will affect Marylanders. People are going to suffer because of the cuts of H.R. 1. We have an obligation and a duty in the state of Maryland to protect our people who depend on those much-needed social safety net programs. So how does this bill work? It requires the Maryland Department of Health to collaborate with other state agencies like the Department of Labor or the Department of Commerce to pull together a list of job training opportunities, employment openings, and other services so that folks who will be forced to to fulfill work requirements under H.R. 1 can do so more easily. So although we can't do anything to stop the rolling suffering that will come from H.R. 1, we can certainly minimize it. It's our duty to do so, and this bill is one step in that effort. With that, I'll end and ask a favorable report. Thank you.
Thank you. We have a virtual Jesse Haviland.
Good afternoon, Chair Valderrama, Vice Chair Charkoudian, and members of the Economic Matters Committee. Thank you for the opportunity to testify on HB 1246. I would especially like to thank Delegate Lewis for sponsoring this bill. On behalf of the Maryland Healthcare for All Coalition, we represent a broad affiliation of hundreds of Maryland's faith, labor, healthcare, and business leaders who are dedicated to ensuring every Maryland resident has access to quality, affordable healthcare. We appreciate the committee's proactive role in championing policies that protect and extend vital health coverage. Maryland has achieved remarkable progress in expanding affordable healthcare access. Since the implementation of the ACA, our uninsured rate has been cut in half from 13% to just 6%, a milestone driven largely by the successful expansion of adult Medicaid. The stability of our healthcare system is now at risk due to the passage of H.R. 1, creating administrative hurdles that have historically led to significant loss of coverage for eligible residents. HB 1246 offers a critical lifeline by establishing a comprehensive employee training and opportunity database. This tool will directly assist Marylanders in navigating the new federal mandates, connecting them with vocational and training programs necessary to satisfy work requirements and secure their Medicaid eligibility. Maryland's commitment, maintaining broad insurance coverage across Maryland is a collective benefit. When residents lose coverage, they're forced to rely on high-cost emergency room visits, and these uncompensated costs are eventually passed down to the public, driving up insurance premiums for everyone. Maryland's commitment to healthcare expansion has already proven its economic value, delivering $460 million in systemic savings. HB 1246 would help protect this progress. None of us can afford for Marylanders to lose coverage. We urge a favorable report for HB 1246. Thank you for consideration.
Delegate Chi.
Thank you, Madam Chair, and Great to see our good delegate.
Great to see you.
Thank you for your compassion throughout all of your policy making. As reflected in this bill, and I'm looking at Department of Human Services letter, which is a different, similar agency in providing services to our communities in favor of this idea. I can certainly see the great value for something like this. So what did the Department of Health actually, how did they respond? I'm just curious, because they didn't send any letters.
That's a great question. My understanding is that they are in favor of the bill. So if there's no letter even of information, to me, no news is good news.
Good.
So they certainly have the capacity to build the database, to collaborate with other agencies, and then make the information publicly available on their websites. I'm glad to know that they're on. I consider them at the table. And if I'm wrong about that, I'm sure we'll hear from them.
Great, thank you.
Thank you.
I don't see any additional questions. Delegate Lewis, thank you very much.
Thank you, Madam Chair.
And seeing no additional witnesses, that concludes the bill hearing on House Bill 1246. We'll now move on to House Bill 1351. Delegates Ampry.
Yes, let me go check to see if
Y'all good, Delegate Ampry?
I found some of them. Yes, all right, here we go. All right.
Michelle McCutcheon. Will Underblighton.
You're not part of this.
Huh? What was this one? 1351?
Yeah, but he'll come.
Oh, okay. Delegate Ampry.
You ready? I'm sorry. I was making sure I got the right panel. I don't want to have to, you have to figure out who's who and all that. I'm trying to lighten your load. I'm so sorry, Madam Chair. For the record, Delegate Marlon Ampry here in support of House Bill 1351. You may remember this bill last year. We passed a version of this bill in which we are trying to address the issue around ensuring that when disasters happen, that individuals have the protection that they have as consumers to ensure they're not being taken advantage of. So what this bill does, it enables governing bodies to impose limitations on in-person solicitation of a victim of a disaster by a contractor offering disaster mitigation services, including limitations on hours and so forth. The bill clearly defines what a disaster mitigating service is. And the service to include boarding up windows, doors, securing a building, demolishing a structure, prevent further damage, et cetera. As I explained last year, trying to keep this testimony short and allow my panel to have some time, there are issues that happen across my district. We actually, unfortunately, had some historic fires that have happened literally blocks away from my home. We've also had historic fires on Keswick Road where we've seen entire homes lost. And unfortunately, this time we actually lost a beautiful couple that unfortunately passed away. But ultimately, one of the issues that we're seeing is that after these disasters happen, people are being taken advantage of with certain contracts around how to protect their home from further damage. So what this bill intends to do is reduce predatory business, protect victims of the disaster, and empower victims to make informed decisions when choosing disaster mitigation service, and ensuring they have a pathway to make sure what the bill does, it allows them to be able to rescind the contract after a certain amount of time so that they can ensure that the contract is fair and balanced. I know that last year we had a lot of conversation, and some of my colleagues, I think we had a great bipartisan conversation. I think we addressed many of those issues that we had with the bill last year. There are amendments to this bill, some of which ensure that within 5 days of a homeowner's enter the contract, they will only be liable to pay an amount that is fair and reasonable value for the necessary work performed under the home improvement contract prior to the cancellation. That it is fraudulent if any person other than an insurer that acts to negotiate and adjust a claim on behalf of an insured individual cannot offer payment for a referral or contractor or service company. Home improvement is also to include tree service removal or water remediation services of a building or part of it to restore, clean, or sanitize a property for a habitable condition. We know that when a disaster happens, it's not necessarily just the home that's affected. Trees fall, plumbing comes up, your basement gets flooded, we'll make sure that all that is covered. But again, requesting a favorable report on House Bill 1351, and I have a panel here that can provide more context to what we're trying to achieve with this bill and how we can ensure that we are keeping communities safe after experiencing such horrible events. And I guess I'll first have my councilwoman, Odette Ramos from the great city of Baltimore.
Thank you, Madam Chair, members of the committee. Thank you, Delegate. I'm Odette Ramos. I represent the 14th District in Baltimore City, City Council. Delegate and I were there that night that we lost 2 of our constituents in a fire. And we were also there when we saw a deluge of contractors come to the area to promise that they will take care of the homes and secure the homes. I even had a constituent who was literally crying in my arms because she had just gotten out of the house, barely able to save her mother, her dog, her children, her husband, when a disaster mitigation contractor came up to her, tapped her on the shoulder and said, "Here, here," while she's crying on my shoulder, okay? So what we're asking to do here is to allow for jurisdictions, which we have already done in Baltimore City, to place limits on, for public safety, how far in that people can be. We put a bill in to have an emergency scene established so that nobody other than first responders and those designated by the chief can actually enter. So it gives residents an opportunity to just get a sense of what's happening, call their insurance companies, talk with somebody who may know what's going on before having to make a decision about whether or not to contract with one of these companies. So this bill would allow for other jurisdictions to also do that. This bill before you also makes sure that we're codifying what a disaster mitigation service is and that they are regulated under the Home Improvement Commission so that there can be complaints, there can be enforcement, et cetera. Because we have so many times where I have constituents who've signed these contracts, didn't really know what was going on, and then end up with a large bill. And it's not fair to our residents to be put in this situation. So I would encourage your favorable report, and thank you very much, Madam Chair.
Come down this way. Let's go this way. Start.
Go ahead.
Madam Chair, my name is Neil Charkatz. I'm a licensed public insurance adjuster practicing in the state of Maryland. I respectfully submit this testimony in strong support of House Bill 1351, including the amendments proposed by the APCIA. Insurance policies commonly require homeowners as a condition of coverage to take prompt and reasonable measures to protect their property from further damage following a loss. In many cases, this necessitates engaging an emergency mitigation vendor or a similar contractor immediately after a catastrophic event. There exists a regulatory gap in Maryland that allows vendors performing board-up services, demolition, or debris removal, temporary roofing, and other stabilization or mitigation services to operate outside of the oversight of the MHIC. Unlike licensed home improvement contractors, these vendors are not subject to the same requirements, contractual safeguards, or disciplinary oversight, despite performing construction-related services on residential structures. In the course of adjusting claims throughout Maryland, we routinely encounter situations in which work is performed under the guise of protecting the property from further damage, yet the scope and cost of that work appear disproportionate to the actual needs of the property. These practices can materially inflate insurance claims and provide little to no corresponding benefit to the homeowner while directly eroding available policy limits. Every dollar unnecessarily spent on the front end of mitigation reduces funds available to reconstruct the home. In many instances, this leaves homeowners financially disadvantaged when it comes time to rebuild. House Bill 1351 addresses this regulatory gap by ensuring that vendors performing disaster mitigation services and related residential services are held to the same licensing standards and consumer protection requirements as other home improvement contractors operating in Maryland. There's no policy justification for allowing companies performing these types of construction-related services on residential properties to operate outside the regulatory framework.
Chair, Vice Chair, and members of the committee, my name is Alexis Snyder, and I serve as head of rapid response at Thomasville Restoration here in Maryland. In my role, I work directly with homeowners in the immediate aftermath of fires, storms, and other property losses. These are moments when families are under significant stress and often forced to make quick decisions about their home and finances. For this reason, we support House Bill 1351 with amendments. At its core, this bill helps establish clear accountability and oversight in the industry that frequently operates during emergency situations. When homeowners are vulnerable, transparency and fair practices matter even more. The provisions requiring payment to reflect fair and reasonable value of work actually performed, along with safeguards around deductible payments and referral incentives, help protect consumers and preserve the integrity of the insurance claims process. Expanding oversight to services like water mitigation is also important, as these services often occur immediately following disasters and can unfortunately attract opportunistic actors. Responsible restoration companies already operate this way. This legislation is simply ensuring that these standards apply across the industry. For these reasons, Thomasville Restoration strongly supports House Bill 1351 with amendments, and we appreciate the committee's consideration. Thank you.
You're here for questions. Correct. Yeah, who's here for Bob? Is you in? I got another person.
Miss, you can come up as well.
Yeah.
You want to step back?
Yeah. Yeah. I think he's no, stay here, John. Go ahead.
Good afternoon, members of the committee. My name is Nancy Egan with American Property Casualty Insurance Association. We write approximately 71% of the insurance written in the private market here in Maryland. You've heard the issues that we face when there is a catastrophic loss or even a fire, which happened down in Hamden 2 years ago. We have been working with the entire group about amendments to the bill. They are in your packet, and if you look at each section, the one section was about the fair and reasonable language, if there should be canceled after 5 days. We've also added 2 other contract groups to add to the list. One was tree services. In large catastrophes such as a hurricane, you see a lot of tree companies coming in and it's charging exorbitant prices to remove trees, so we thought that it would be important to include them in the list of contractors subject to this bill. In addition, there's some language about the clauses under the insurance section. I have been spoken with the public adjusters, and the intent of that is not to permit contractors to provide policyholders with a fee for referral services. We see that a lot with roofers throughout the industry, where they come in and say, I'm going to give you a bonus if you refer me to another one, where I'm going to replace their roof, et cetera. Our intent was not to include all contractors' referrals. That was not the intent of that section. And I'm here to answer any questions. Thank you.
Madam Chair, members of the committee, Robert Etton on behalf of the American Property Casualty Insurers Association. I just want to support the prior testimony that you've had. I mean, this is a very serious concern, we think, for homeowners as well as for the insurance companies that are there to protect them and make sure that that their houses are well maintained, to make sure that if they have had damage and they're going to have a claim, that they have the right people come to do it, that they don't have the pressure of having, my house was damaged tonight, and then at 4 a.m. and at 6 a.m. somebody's knocking on their door with a contract for them to sign. I mean, that's the problem. So this bill builds in protections. It doesn't say the companies that are impacted can't contract. It just builds in additional protections for homeowners that are in this particular situation. And I know that you're going to hear from the opposition about the bill. We've had discussions with them, but I don't think this bill has a huge impact. What the bill says is you got to make certain disclosures. You have to have a certain waiting period. A homeowner has a right to rescind, but this isn't all about the insurer. It's about making sure that the homeowner is adequately protected, and that's why we support the bill. Thank you.
Is your,
He's here for any
okay.
questions, any further questions?
okay, we'll start with Delegate Adams.
Thank you, Chair. Thank you, Chair. So I'm not remembering the bill specifically from last year, but what I will say is I'm licensed MHIC, so I hold the license as a contractor. I don't do disaster mitigation services, so I will say that. If you're the insurance industry and you're seeking to get mitigation done quickly, how do you wash with MHIC's requirements of a 3-day door-to-door sales act component? So when you're entering into a contract at somebody's residence, okay, and they say, okay, yes, you can do the work, under the MHIC law, you have to wait 3 days. It's a cooling off period, a period of time for which a buyer can say, no, I'm not interested and I'll cancel the contract. So how do you wash that against the industry perspective as insurers that you want to get the property secured and mitigated as soon as possible, especially like for water damage? So Bob or Nancy?
I'll let the insurance.
I need to check that for you. I'm not sure, and I would have to find that out for you to clarify that.
Well, let me restate the question because I think it's essential, and it goes to some of the testimony that you seem to be concerned about, which is that, you know, contractors who do this sort of work, I mean, you just can't let disaster happen and let it sit for a handful of days while a contractor should be doing the mitigation work. So for water damage, it could be as simple as doing demolition to drywall, you know, flooring, cabinets, say, insulation, and then you have to go back through and use dehumidifiers, et cetera, et cetera. Well, I mean, I'll get into a second question, but I would like to answer on this one because the insurance companies should not be saying they're okay with the wait period of 3 days because that's what it's required if you're saying that contractors who do this work need to be MHIC licensed. So you're either for the 3 days or you're against it, that's what I'm saying.
Yeah.
So specifically, the language that is in this bill is going to address a fair and reasonable cost because emergency services do have to be conducted. So I don't think that they run the same as the MHIC cool-off period. That 5-day right of rescission is because a lot of contractors are signing for reconstruction in the middle of emergency service. So it's allowing that person to get the emergency services that they need without having to worry about being locked into a reconstruction contract that's so far down the road.
No, this has to do with does the bill not require these companies to be licensed under MHIC?
Yes.
Is that the bill?
Yeah.
Okay, so my point stands, and we can carry this offline. I don't care whether or not we continue the conversation so we can get the answer.
Yep.
But this is not the same thing as saying I'm going door to door because I've decided you need to put a new roof on the house. I mean, that could take, 30 days to make a decision. It could take 3 years to make that decision. But if you're doing it door to door in that setting, once you enter into a contract with the homeowner, by law, you have to wait the 3 days. That's part of that MHIC. So that's the first question. We'll get that later. The second question, and again to the insurance companies, my understanding is if you're here today, that means that you've got property owners that have policies and that those policies speak to what happens and what the responsibilities as a property owner is to get work done. And is it not so that the insurance companies establish routines for this sort of thing, meaning that a homeowner can sign a authorization to repair form? So they're not entering into a contract, but they are saying to the insurance company that the insurance company can stand in the place of me as a property owner to see that the work gets done. So there's no contract, there's no exchange of money to me as a property owner, but yet the insurance company has established the routine that allows for a direct relationship with the insurance company and the contractor to do this work. And how do you wash the door-to-door sales act and other parts of MHIC when I know this is standard operating procedure for the insurance industry?
As I said, I want to investigate that further for you because I am aware that when claims are reported that they will provide for mitigation services to come in. So let me find that out for you and try and find out because obviously, I'm not a claim adjuster, and I want to make sure that we have that correct for you.
Well, that's sort of the problem with the claim adjusters, because what I can tell you is if I had we had a long day yesterday. I want to get to a couple, I mean, I'm in the industry of generally
Right.
understanding what MHIC requires, which is a lot, right? It's a lot. And so if I'm the homeowner and I have a disaster, I'm probably not at the front door waiting for contractors to come see me. What I am doing is calling the insurance company and reporting the claim. And my testimony is that that almost always results in either an expedited service with the insurance company that has a relationship with some of these contractors, and frankly, more importantly, keeps the property owner out of the middle of having to adjust and/or resolve the problem, because the homeowner is not the expert. The insurance company in this setting is the expert. And the adjusters, at best, can be slow to the call to get things done. So again, if we're passing the bill for the purpose of assisting homeowners during a disaster like this, I'm not sure that this bill gets to what it is that industry is set up, and I'm not sure that the concern that you're relaying, which I am concerned about, having a disaster and have people show up is a little bit disconcerting, but I don't believe that's the vast majority of the work that occurs when it comes to like my hot water heater broke, and 200 gallons of water came through my walls and floors. So do you understand my question, or should we just
Look, I understand your question, Delegate, and you raise a fair consideration that we can talk about offline in the subcommittee. And I think at the end of the day, portions of this bill allow for local jurisdictions to figure out how they want to put in emergency spaces to make sure that those who cross that tape are the people who should be crossing that tape. And as you just mentioned earlier, when a disaster happens, you call your insurance company. This bill doesn't stop you from calling your insurance company and allowing your insurance company to help you find the people to come mitigate immediately. The goal of this bill is to ensure that there's not like a situation where people hear about a disaster and 20 trucks pull up on the scene just trying to go get a new contract. That's what we don't want. So, but we can talk. Let's talk offline.
So you're sitting next to a resident expert about MHIC, and we can
we can talk about we can have a shoulder to shoulder conversation.
Delegate Turner.
Okay, Delegate Howard kind of got me on board here, but Delegate Amber, just walk me through I don't want no long day, okay?
No, I'm gonna be quick.
Okay, be quick. I'm trying to understand this bill. What is this bill trying to do? You got regulation prohibit, okay?
So I'll be as quick
Be
as possible.
brief, tell me what exactly does this bill do?
Yeah, I'll be as quick as possible. So what the bill does, it puts in certain regulations and rules so that anytime there's a disaster that happens at your home, when that happens, you don't have people that will come and try to take advantage of you with expensive or bad contracts. So this puts in rules and regulations to make sure that when the disaster happens, that the homeowner is not taken advantage of. And what we're just putting in is some rules and regulations on timing, the contract, the cost, et cetera, to make sure. But I would be happy to talk to you further. I can walk it through again with you later if you need time.
I sure appreciate it,
Sure.
because
Yes,
I'm
ma'am.
just a little confused, and I tried to follow Delegate over here, who's really making me understand exactly what, and I got understand some of the points that he is saying, but I'm still a little confused, and I want to be correct.
We'll get it together later, Delegate.
I appreciate it.
All
Thank you very much.
Seeing no further questions, thank you, Delegate Ampry and your panel. We'll move on to more favorables. Carrington Anderson, Jen Gillis, William Caraberis, Chris Logsden. And Jeff Lake.
Was I called, Madam Chair? Just said, I wanted to be up here with my client. Okay.
You may begin, someone.
I can go ahead and start.
Thank you, Madam Chair, members of the committee. Carrington Anderson here on behalf of the Maryland Association of Counties in support of House Bill 1351. I do want to thank the delegate for bringing the bill. We think that this provides a really good local option to address these practices locally. It doesn't mandate counties to do this. It allows them to do it if they're seeing this problem locally to address these practices. So we think this is a meaningful tool and thank the sponsor for the bill. Thank you very much.
Hi, my name is Chris Logston. I'm a Maryland public adjuster in the state of Maryland. I've been in business for 25 years. And basically, what the delegate said earlier is my concern about the 5 days cooling off, because mitigation is the first step in any loss, and it has to be taken care of, or you run the risk of having the insurance company being able to deny that part of the claim. Also, it also has to be done to protect anybody from theft, because if you have a theft claim, because you didn't protect the property and you had time to cool off, most mitigation takes 3 to 4 days. So they come in, they do water extraction, they do roof tarping, they board up homes and secure the property. So on that note, I would say that the 5 days is too long, because most of mitigation is done within 3 to 4 days. Thank you.
My name is Jeff Lake, and I'm the owner of Woodmore Cleaners. We've been in business since 1979 and the restoration business for nearly as long. When a fire strikes, the immediate focus is in extinguishing the flames and ensuring everyone's safety. But once the smoke clears, the real battle begins. What many people don't realize is that some of the most significant damage isn't always structural. It's woven into the fabric of a home or business. Textiles, which is my expertise, clothing, upholstery, drapery, bedding, shoes, purses, and specialty items act like sponges during a fire. They absorb smoke, soot, acidic residues, and odor particulars within minutes. And from that moment forward, time is not of a luxury. It is the deciding factor between restoration and replacement. Soot and smoke residues are highly corrosive. Within hours, they begin breaking down fabrics, color fades, whites, yellow. Synthetic fabrics can permanently bond with oily residues. Natural fibers like cotton, wool, silk will weaken and deteriorate. The longer the contaminants sit, the deeper they penetrate and the harder they are to remove. That's why professional fire restoration textile cleaning must begin immediately. Speed matters for another reason: cost control. Rapid inventory, pack out, and cleaning can significantly reduce insurance claims. The faster textiles are removed from the contaminated environment and process, the higher the salvage rate. What can become a total loss often can be fully restored and handled quickly and correctly. Beyond the financial impact, there's an emotional one. Fires don't just damage property, they disrupt lives. Family heirlooms, wedding dresses, baby blankets, custom draperies, uniforms. These items carry memories. Swift textile restoration can mean the difference between preserving a lifetime of moments and losing them forever. In fire restoration, every hour counts. Delays allow soot to set, odors to embed, fibers to degrade, costs to escalate. But quick professional intervention performs loss into recovery. So when we talk about fire restoration, we must remember it's not just about rebuilding walls. It's about restoring comfort, safety, health, and history. And that restoration begins with immediate expert textile cleaning. Thank you.
Good morning, Chair and Vice Chair and committee members. My name is William Joseph Carabaris. I'm the owner of Platinum Emergency Services and co-owner of Carabaris Restoration. I've been in the business for 28 years. Let me walk you through how it happens. You have a fire or flood, you call your insurance company, whether someone solicits the customer or whether you're called out by the insurance company, you have the same contract. The contract is an assignment of benefits. You go out to the property, you perform your emergency services, whatever's needed, whether it's sucking 5 feet of water out of the basement, whether it's boarding up some windows, putting tarps on a roof. These things happen right away. Most of my services are done within the first 24 hours of the incident. The homeowner signs a authorization. We send photos, pictures, measurements, all details of everything that we've done to the insurance company, and they pay us directly. I'm not sure where the Home Improvement Commission has ever been involved in mitigation. I had an off-the-record conversation with the director of the Maryland Home Improvement Commission, and he does not agree with any of this, with this bill. He also told me that he wasn't allowed to come here and testify, so somebody's cuffing his hands. That's for the record for everybody to hear it, okay? I had multiple conversations with him, and there's no right way to handle this. It's not, a mitigation is you go into someone's home, they have memorabilia, they have photos, they have this, they have that, they have urns. These things need to be salvaged. This isn't home improvement, right? This is packing out furniture. This is mitigation is a big ordeal. It's not just boarding up a house. You're saving a lot of people's memories. And, to try to, you're in a recovery zone, so you go into these properties and you're doing all these things, and the insurance company pays you for it. They're not going to overpay you. The insurance company barely wants to pay you what they owe you, let alone overpay you. And that's how it works.
Good afternoon. My name is Jen Gillis with Environmental Contracting Solutions. I am a family-owned insurance restoration contractor that has been in business for 23 years. We specialize in rebuilding homes that have suffered significant damage from fire, flooding, and storms. We provide emergency board-ups, tarps, mitigation, and full structural reconstruction, working directly with insurance carriers to restore property safely in compliance with building codes. Insurance carriers require detailed documentation, scope approvals, and compliance with industry standards. Scopes of work are reviewed by adjusters, and pricing is standardized through insurance estimating software. Projects are documented, approved, and funded through established insurance claim processes. Disaster restoration is not traditional home improvement work. It is emergency response work. When a family's home has just burned or flooded, immediate action is required to secure the structure, prevent further damage, mold growth, safety hazards, and begin stabilization. Delays can dramatically increase repair costs, health risks, worsen damage, and prolong displacement. In many disaster situations, homeowners don't know where to start. They are overwhelmed, stressed, displaced, and dealing with the insurance company. That is why we provide them with immediate response and guide them through the insurance and rebuilding process. Homeowners need access to reputable licensed contractors without added confusion or delay. Thank you for your time.
Thank you. Are there any questions? Seeing no questions, thank you very much, all of you, for your testimony this afternoon. I'm now going to call on Bruce Bariano, Landon Carabaris, Jeffrey Good, Michelle McCutcheon.
Good afternoon, Madam Chair, members of the committee. For the record, Bruce Bariano. I'm here on behalf of Platinum Emergency Services. You just heard from my client, Will Calabaris. The problem with this legislation is several-fold. What respectfully has not been conveyed and explained to the committee is that the overwhelming majority, 80 and 90% of these very unfortunate disasters are covered by insurance, because people have to have insurance if they have a mortgage on their house. They're required to. So what my client does, he comes on the situation, he has a written contract, he asks the person, do they have insurance? If they have insurance, he calls the insurance company, even if it's the middle of the night, tells them about it, gets a claim number, and this is the contract he uses is an assignment so that he can work with the person's insurance company in resolving the matter, which is going to be paid by the insurance company, not by the person in the home if they have insurance. So those portions of the bill that relate to the 5 days and turning back, they're totally inapplicable if someone has insurance, because Mr. Carabaris and others here, they're working immediately and directly with the insurance companies. And they're paid by the insurance companies, not paid. That's why you have insurance. If you have a mortgage, you're forced to have that insurance. So the whole thrust of the bill is just not what goes on. Secondly, the language in the back of the bill, which would allow other government bodies to have local authority, would be a disaster.
We have filed a lawsuit in Baltimore City against Baltimore City's bill that was passed. It's pending in the circuit court in Baltimore City as a violation of the law, violation of commercial free speech. This language would interfere with that lawsuit, which is very legitimate, and I'll be happy to answer any questions. I'm sorry, my time's up.
Anyone can go.
Chair and members of the committee, my name is Michelle, and I am also a Baltimore City firefighter. I've spent my career responding to emergencies and helping families during some of the worst moments of their lives. Recently, I experienced that same situation personally. A few years ago, there was a fire next to my home that caused damage to my property. And just 2 weeks ago, I had a pipe burst in my house that required immediate emergency mitigation. In both situations, mitigation companies responded quickly. They boarded up and secured my property, set water mitigation equipment, and prevented further damage. I signed and authorized for the work. The service were performed immediately, and the companies worked directly with my insurance carrier for payment. There were no issues, there was no confusion. The system worked the way that it should during an emergency. As a firefighter, I know that time is everything. When water is flowing or a structure is exposed after a fire damage gets worse by the hour. Any change that adds delays, extra waiting periods, or restrictions on how emergency mitigation companies can respond could slow down the process of stabilizing a home. Emergency mitigation is not the same as traditional home improvement. This is immediate stabilization work that prevents greater damage and keeps families safe. In my case, if there had been delays in boarding up my home or setting equipment, the damage would have been significantly worse. I understand the goal of protecting homeowners, but from my personal experience, the current system worked. I am concerned that House Bill 1351 could unintentionally impact response times and make it harder for emergency mitigation professionals to do their job when homeowners need them most. Thank you.
My name is Jeffrey Gould. I'm a public insurance adjuster, and this bill does not directly affect me, but it could affect my clients, which is why I'm here. I'm in favor of the licensing and regulation of disaster and emergency service industry companies, including many of the provisions in HB 1351 and many of the amendments from the APCIA that I heard today. We did speak in the hallway a little bit, and there's some minor tweaks that could be made. Instead of regulating the entire industry and punishing the entire industry, I rather see general regulation and then the ability for the government entity that's doing the regulation to punish those bad actors and not punish the entire industry. There are many, many people in this disaster mitigation industry that do the job right, do it well, but like every industry, there's always going to be a few bad actors. I just want to bring up a few things that I haven't heard so far today. You would be amazed how many people at the time of the fire have no idea who their insurance company is. It may take them a day or two to find out. They can't wait a day or two to call the insurance company and get their house mitigated. In fact, every policy has a requirement that they mitigate damages right away. Any delay could cause them to be in violation of their policy and could allow for damages that insurance companies may not pay for. I'm against the 5-day right of rescission, as in most cases, in every case, the mitigation is completed before 5 days is over. So you're asking somebody, giving somebody the right to rescind a contract for work already completed. I'm against allowing the 24 jurisdictions in Maryland to have their own rules. If you have 24 sets of rules, it's going to complicate the system that, as you've heard many times today, works. And I'm against having to come up with an estimate. It's unlike regular construction where you have time to go through and prepare an estimate. Mitigation and water damage, it takes days to find where it went. You can't do an estimate on the spot. Thank you.
You can use the mic right in front of you.
Good afternoon. My name is Landon Carabaris. I'm a Maryland resident and co-owner of Disaster Mitigation Company that helps homeowners after fires, floods, and other emergencies. When someone's home catches on fire or floods, they're not thinking about contracts or the regulations. They're thinking about protecting their home, belongings, and family. In those moments, minutes matter. The faster professionals can secure the property and remove water, the less damage the homeowner suffers. Allowing counties to restrict in-person contact after the disaster may sound reasonable, but in practice, it slows down responses and makes it harder for homeowners to get the help when they need it most. Many families do not know who to call after a disaster. Often, the first qualified professional they meet is the one who helps them secure their home and start the recovery process right away. The people who will be harmed most by this bill are homeowners who are already going through the worst days of their lives. Maryland should focus on stopping bad actors in the industry without slowing down emergency responses for everyone else. Responsible mitigation companies help families recover quickly and prevent further damage. For these reasons, I respectfully ask for the committee for an unfavorable report on House Bill 1351. Thank you for your time and consideration.
Thank you. Delegate Ahrens?
Thank you, Madam Chair. Mr. Buriano, I think you mentioned something, and I've seen it a couple places, about the Baltimore City lawsuit. Can you expound upon that a little bit?
Yes. Baltimore City passed legislation applicable in Baltimore City to basically preclude our clients from going on the scene at all and putting the fire marshal in charge of when you could do it, and we could not go on the property for several days. There were other provisions as well in the bill. I testified, I spoke against it. It was all ignored. It was stimulated by Councilwoman Ramos, who testified here today. Some misinformation spread throughout the legislative process in that matter. So when my client hired a law firm, Tim Maloney, former member of this legislature, suit is pending in Baltimore City to challenge the constitutionality of what was done on two grounds, very basically. Violation of commercial free speech, and there's very strong case law on that. And secondly, preemption. The state, over the past years, through the Home Improvement Commission as well as MIA, has occupied the field of legislating in this area. And there is a very strong, valid, implied preemption argument in the law, lawyers know about it, that precludes people from legislating in areas that have been preoccupied by another official body, in this case, the state legislature. State legislature has been legislating in this area for a while. I think it would be so injurious to everybody to allow the counties to, as this bill allows, the counties to do something. I personally feel this language is in here. I just personally feel that way. It's in here to interfere with that lawsuit and try and negate that lawsuit. And I also sent around a council letter to Councilwoman Ramos to stop interfering with my client's right to
So they were
perform
prevented
contracts.
from mitigating the issue.
Excuse me?
They were prevented from coming in and mitigating the issue. They had to wait. They had to get another permission.
That's correct. That is correct. Okay. And so that legislation that lawsuit's pending, and this bill would try to supersede it in that part of the bill.
Okay, thanks.
Thank you.
Sure. So Bruce, let me just follow up on that. MHIC is a license structure, and currently disaster mitigation services are not included in their provisions. And so the bill, I just want to make sure we're on the bill on this subject. The bill is trying to bring these companies into the MHIC. And the first question is that the problem with that is there are provisions of that bill that are not workable for the industry generally. I mean, to wait the number of days for the Door-to-Door Sales Act to apply is to say that you have damage that has to be fixed immediately, but yet you can't do it. And I'm assuming that's your primary concern with this legislation.
Well, as I said, Delegate, and I'm not trying to be disrespectful to the sponsor, I really am not. If you read this bill and you understand, this bill does not reflect at all the process where people who unfortunately are victims of disasters have home insurance. And my clients go directly to them and say, do you have home insurance? And most of them do, 80 to 90% of them do. And then they immediately go to the insurance company and deal with the insurance company and get payment from the insurance company. None of that procedure or that process is reflected in this bill at all.
Okay, so what you're saying is
the bill is just not targeted at the right place.
You're saying that because the compensation comes from the insurance company and the agreement happens through the insurance company and the contractor, that the owner's not responsible for nor has to worry about paying for it, which is...
That's correct. The provision's in here, whether it's 5 days or rescission, I mean...
All right, clarifying question. Do these disaster mitigation companies do more than just disaster mitigation? In other words, after they're done doing the demolition of the cabinets, doing the demolition of the drywall, getting rid of the flooring, is their job done? Do they walk off the job and then do the owners then go out, or do the insurance companies go out and hire drywall contractor, electrical contractor?
That is my understanding.
Because those industries are regulated, and if anybody's going in and doing that work and begins like up and down the line from disaster mitigation through to completion,
right?
That's a general contractor. That's not the same thing, and so a general contractor would be subject to that.
Right. Go ahead.
Would be my understanding.
Well, in both of my incidents with everything going through the insurance company, the restoration company, they came out, they handled the sealing up of the outside of the house once everything was exposed to protect from further damage. They mitigated the water, they came in and did everything. They had nothing to do, nor did they ever mention anything in reference to repairing the house. I literally am still in the process of now having the rest of my house torn out because everything had to be dried. It was the walls, the floors, and within that process, I have to find my own contractor, or either I can accept one through the insurance.
But you weren't under duress. At that point, those contractors had to be licensed under MHIC. Last question, and MHIC is a simple construct. It is when a homeowner decides they want to get a roof replaced, they want to get work done that's under the list of different items, that we as a state have decided we're going to protect the homeowner if the work doesn't get done or it gets done incorrectly. This scenario, the work's being done, frankly, before they're getting paid, so you don't have to worry about the monetary aspect to it. And the demolition work that's happening, it's not as if you're questioning whether or not the work was completed structurally sound or correct in construction practices, because you're just then trying to get the house and the areas that have to be demolished, and the mitigation occurring. So while I'm not interested in getting into a conversation about what a commissioner does or doesn't say, I think it's a pretty plain conversation that this bill, while I understand why it's here, isn't here to protect the homeowner from a monetary loss because they paid for something they didn't get, and nor is it protecting the homeowner from a structural or some deficiency that a contractor could latently have happen on a job. For example, they replaced the roof and the roof was done incorrectly. And so isn't that so? Sure, go, you can answer. I think I'm.
I just want to go back to your earlier question and confirm that a mitigation contract is completely separate from a rebuild contract.
Yeah.
In Maryland, the rebuild contract does come under the MHIC. It requires a specific dollar amount, a start date, a finish date, and other requirements. The emergency services contract does not have any of that, so it cannot qualify as a legitimate contract in Maryland.
Thank you, Madam Chair. I had two questions. The first one, I'm trying to follow you, Mr. Buriano, okay? What's the time limit? You said when a disaster down in Baltimore to happen, okay? What's the time limit? You said you should hold the paper up. You said, here's the insurance paper. Okay. When this disaster happened, you don't go the same day. Do you go, how many days between? I got three different things here. First, 5 days is too long, or you need to do it in the 3 days. How many days did you say?
Delegate, first of all, it depends upon what the disaster is.
Okay.
Is it a fire? Is it maybe a tree that fell on the building, on the home? Is it a bursted pipe? Is it a flood? What the situation is. Emergency services come on the scene to contain the situation, depending upon what it is, whether it's a fire or what have you. But the minute the scene is, from that emergency standpoint, covered, my clients come on the scene.
On the scene.
On the scene. They physically come on the scene. They do talk to the owner of the property and ask, do you have insurance? If you do have insurance, who is your insurance company?
Bruce, can you talk into the microphone?
Oh, I'm sorry. I apologize. They ask, who is your insurance company? They then call the insurance company. It could be in the middle of the night. I mean, these things never happen between 9 and 5. And then they get the claim number and the authorization from the insurance company. They then have the person sign this contract so that they can proceed forward with the insurance company. Ready? They acknowledge in here, I have insurance, the name of the insurance company, and I allow you, mitigation, disaster recovery, to work with my insurance company, which they do, and then act immediately. And whatever monies are paid by the insurance company to my client. There is no further money paid by the owner of the policy unless there is some exception or something peculiar in there. So that part of this bill just does not reflect what the overwhelming majority of situations occur, 80 to 90%. Either people either do a mortgage requirement or just their own common sense, respectfully, they have homeowners insurance. So that's why I'm saying that the whole approach of this bill does not take into account the whole scene, no pun intended, and the realities of the whole situation, and that most of the people, unfortunately, that are subject to this have insurance.
Okay. Just one little, I'll be short. Okay. The firefighter that's up here?
Yes, ma'am.
Okay. Can you just tell me what was the process for the, when you have a fire in the house disaster? What's your process that you go through?
When we have a fire call and we respond, as we're actively firefighting, the street don't only get blocked off by the police, we also take the streets off.
Okay.
Once we take the streets off, nobody other than emergency personnel, meaning fire and EMS and the police, are allowed within the parameter of the tape.
Okay.
Not even restoration companies. On the scene, you may have restoration companies respond, you may have neighborhood services respond. They all have to stay outside of the perimeter until it's secured that everything with the fire has been deemed safe. BG&E, everybody. Once BG&E arrive, they cut everything off. The fire's put out. Once the fire's put out, we have to go in, take the residents in the home to let them see what was done to the home. Once we take them in the home, then it's time for us to get ready to start packing up. Once we're ready to start packing up, we'll remove the tape, and then neighborhood services and everybody else can talk to them. Okay. Fire department, we put plastic up to the windows that we break. We don't do board up. We call for board up companies. Otherwise, it can be done privately with whoever they select. It's no different than like a car accident. Just because a tow truck show up on the scene, I don't have to accept their service. I can call who I want to move my car. It's the same with any other company when it comes to using insurance.
Are you good, Delegate Turner?
Thank you.
Okay.
Thank you, Madam Chair. In my district in Baltimore County, I witnessed a situation that really stayed with me. There was a fire at a local business, and while firefighters were still working to put out the fire, several contractors had already arrived. I got a call, and I was at the scene as well. On the corner, they were approaching the owner, asking him to sign documents and claiming they were the legitimate ones who could do the job. At one point, there was even verbal fighting. They were yelling at each other. The owner had just experienced a disaster, very limited English. Firefighters were still battling the fire. And in that chaotic moment, he could hardly understand what people are asking him to sign. My question is simple. Should someone who has just experienced a disaster be pressured into signing a contract on the spot, or should they have clear protections and time to make a thoughtful decision? And please, I mean, whoever did the job, they did a wonderful job, the boarding and everything. I truly appreciate that. Could the panel say, why do you think the industry should not be regulated? It was a very, very chaotic situation that I witnessed.
Delegate, the industry is regulated. Unfortunately, and I'm not making an excuse, I said it yesterday in another subject area, and throughout everything, you're going to have bad actors. And that's wrong. I'm very sympathetic to this situation, I really am. All I was trying to explain, which is why I signed up favorable with amendments, is the whole thrust and approach of this bill does not reflect the reality that the majority of the people that experience this situation have insurance. And we deal with the insurance company. So there's no pressure for them to pay. There's no need for rescission. You're going to have bad actors, but I know my client and the other people that are here, they do it right. And if you have insurance, they'll immediately call the insurance company, as I said, verify, get the claim number, and then the contract is just authorizing the insurance company's policyholder authorizing the mitigation adjuster person to then deal with the insurance company, do the work that's needed for mitigation, not putting on a new roof, for the mitigation, and then getting paid by the insurance company.
Okay, I'll follow up offline with you and the bill sponsor.
Thank you very
much. Thank you.
Seeing no further questions, thank you very much,
Thank you
all of
very much,
for your
Madam Chair.
testimony. Seeing no other witnesses, that concludes the bill hearing on House Bill 1351. Colleagues, we're going to do a little jumping around here, and we're going to move to House Bill 1303, also Delegate Amprey.
Sorry, I'm like such a shop over here. I'm gonna hide. That was the joke yesterday.
I think this is the one that everybody came for, I think. I don't know. At this point, I don't know. Today's been a whirlwind. All right. Good afternoon, Chair Valderrama, Vice Chair Charkoudian, members of the committee. It is an honor to be before you again with our favorite bill of every year, House Bill 1303, Alcoholic Beverages Modernization Act. asking for a favorable report on this bill, and I'm going to quickly, as best as I can, walk through what this bill does and what it doesn't do. But the first thing that I just want to make clear on this bill is that I've heard you. I've talked to many of you after these hearings. I've talked to people in the industry, and what I ask for you all today is please hear out what the bill actually does and doesn't do. Listen to the actual the testimony today. Have an open mind as to what we are trying to do here. And hear out some of the elements and amendments and changes and tweaks that we've made to ensure that I think we can really build a fair and equitable ecosystem. So I'm asking that you all really hear out what we're going to lay out today. So House Bill 1303 modernizes Maryland's alcoholic beverage laws by creating a clear, regulated pathway for certain grocery stores and retailers to sell beer and wine through a Class A license. The bill brings Maryland into the 21st century. 47 states already allow beer and wine sales in grocery stores, including our neighbors, which you'll hear more about from some of my colleagues on the panel, which includes Pennsylvania, Virginia, Washington, D.C., and Maryland is being left behind. At the core, this bill is about convenience, it's about choice, it's about safety, and it's also about expansion. So on the convenience piece, we understand the realities as a young father, when I have my girls and I'm having to go running errands and I can only go to certain places and spaces and have a little amount of time, being able to do things in a one-stop shop is really important. I think about some of my constituents who don't even have a car, who don't even have meaningful transportation. They can only afford that one Uber to the grocery store and back, or that one train ride and back at a limited time. They need to be able to have the convenience to be able to purchase beer and wine in a more quicker fashion. It's also about choice. People deserve to have the choice to purchase things where they please. And this is also about safety. I know that we all represent different communities and we have different setups in how we normally shop and live. But unfortunately, in some communities, such as the ones that I serve in West Baltimore, some of the ones that I've been able to experience and see in parts of Prince George's County with some of my colleagues, the reality is that some of the places where you can only get some of these adult beverages are places that aren't well lit. They're not necessarily safe in the sense of literally when you walk into the store, you have to buzz through two rooms and talk to a person through bulletproof glass, right? So it's about people having the choice and the dignity to be able to purchase these items in safety. The last thing we're also going to talk about today is expansion, right? Creating expansion and opportunity for more grocery stores to come into our communities. We know grocery stores already operate on really thin margins. So allowing these grocery stores to be able to sell beer and wine will allow them to have a little bit more to be able to stand themselves up in new communities where they're trying to put themselves in place. But the other part of expansion, which we talked about last year, is expanding our beer and wine industry here in Maryland. The reality is that we are somewhat shooting ourselves in the foot. When we only allow local stores to be able to sell beer, wine, and alcohol, we're not allowing our Maryland-made beer and wine to get out of the state and export itself. If people are able to contract with retailers to have national and international footprints, we're going to allow our beer and wine industries here to grow 10, 20-fold, which would create more jobs and opportunities. I want to be able to shop when I go travel overseas or when I travel around the nation and see that amazing Maryland-made beer and wine in a store that they built a contract with here in the state. Right now, it's difficult for us to do that because of our archaic laws. House Bill 1303 does not eliminate or devalue existing license holders. I'll repeat that one more time. House Bill 1303 does not eliminate or devalue existing license holders. Grocery stores must, and through amendments, we've also added more layers to this to make it a must, purchase an existing Class A license or apply through normal licensing processes if a purchase is declined. We're open to amend this bill so that the license will only be acquired through a transfer, meaning there's no new licenses being added to the ecosystem. We're not talking about creating more competition. We're literally just changing the name on the door. Literally, if you are a store and you say, hey, I've had my time doing this business for a long time, my family doesn't want to do it anymore, here's an opportunity for me to be able to sell my license, I can sell it to a retail establishment grocery store. So there's no new competition. All we're doing is saying you have to license transfer. And in reality, when that happens, you're actually losing a liquor sale, right? So the other stores that remain open and say, hey, I'm gonna stay in the game, I'm gonna stay selling, I wanna keep my license, they now have a better case to sell spirits because we're only allowing beer and wine going to the grocery stores. So they will still have the monopoly of being our only store where you can buy liquor and spirits. The bill currently operates on a one-to-one license acquisition, but we remain open to discussions about requiring multiple license acquisitions for larger stores if that helps balance the market, meaning that instead of having a one-to-one license, let's say a larger store wants to open up a beer and wine sales, we would say, hey, you have to acquire 3 licenses for this store to be able to run and function, which again, we're not adding more licenses to the market. We're actually reducing and shrinking through fair, equitable purchases and ensuring that we have a better ecosystem for a thriving ecosystem of individuals being able to purchase their beer and wine in various places. But we also impose local controls. So local licensing boards shall limit the issuance of licenses to 1 or more geographic areas it considers appropriate to lessen the impact of Class A license density within the jurisdiction. So there's not going to be all these stores. It's not going to happen when we pass this bill. All these stores are now going to be selling beer and wine. Local control will still exist to make sure that it's balanced and fair. We're going to limit floor space. A grocery store may not dedicate more than 150 square feet of public floor space to the sale of beer and wine. Another amendment that we've added. Okay, the reality is we don't want to see a grocery store just become a big old beer and wine shop with a few apples in the corner and get this type of license. No, we're going to limit the amount of square footage you can sell these beer and wine items inside the grocery store. This is about quick convenience. It's not about creating a new market. By imposing this, it's going to be a fair and equitable way to make sure that people can compete. These are store and size distance requirements. These remain in place to prevent disruption to existing businesses and ensure thoughtful placement. So what you're going to see in the bill is that we have distance requirements about where you can get the license from to make sure that we're not going to have a situation where a grocery store is going to now have a beer and wine license right next door to a store to a currently locally owned beer and wine shop. Again, we thought about every way we can make this an equitable and fair process. Grocery stores, as I said earlier, grocery stores may only sell beer and wine, while package stores will still retain exclusive rights to liquor and broaden product selection. And the key thing I want to talk about that we talked about last year briefly is that, a lot of the opponents you're going to hear today are going to talk about, like, when this happens, all these stores are going to go away, everyone's going to lose their business. It's just not true. The reality is this ecosystem already exists in multiple other states. There's other places where they have both and they coexist and they're doing just fine. But you know what the greatest example, as I said last year, is? It's already happening right here in Maryland. Right? You can go down the street and buy beer, wine, and liquor from the Walgreens down the street. And I see a multitude of liquor stores that are still here thriving. I think about back home in Baltimore City. My favorite place to go buy my beer, wine, and alcohol is the Wine Source. Literally, the best in the city. If you're ever in Baltimore, stop by the Wine Source. It's great, right? Across the street is another liquor store, and they compete against each other just fine. But 3 blocks down the road, there's a Royal Farms that has a grandfathered beer and wine license. Literally 3 blocks away. But guess what? The Wine Source is still, every time I walk in there, I got to wait in the line. They're doing just fine. So the reality is the ecosystem already exists here in Maryland. It's just, this law is just about making it fair and making sure that we can expand it a bit and making sure that everyone has access to that convenience. You're also going to hear today from the opponents about other states that have recently implemented this law and how stores have gone away. But the reality is what I just told you a moment ago, that when the licenses transfers happens, guess what? That store is going to close, right? But they're not closing because they didn't get fair value for their actual purchase. They were bought out with a fair price. So that store is no longer open, but they didn't close because they couldn't compete. They closed because they sold their license. So when you see the numbers of other states where all these stores closed, it's because they sold their license. It's not because they lost in the competition, right? So here in Maryland, the way we would set up this bill, the way this bill is set up, it would be strictly a license transfer. So House Bill 1303 strikes the right balance of modernization, fairness, consumer convenience, and strong regulations. This is a careful, structured, limited expansion, not deregulation. And the last thing I'll say is we have tons of other amendments that we have on the table that we're ready to offer around certain taxes and fees that we can then place on these new license holders that are big, and we can create more opportunities to get more food to those who need it. We have other amendments that you'll hear about later in order to make sure that we can make this as fair as possible. All I'm asking is that our opponents and those who are concerned come to the table and figure out a way where we can make this happen, because our consumers, when I talk to my constituents, they want it. From my wife to her friends to everybody I talk to, everybody wants the convenience of being able to buy their beer and wine at a grocery store. And with that said, I'm sorry that went a little longer than I wanted it to. I respectfully urge favorable report on House Bill 1303. I will turn it over to my panel.
Is it safe to say your testimony is for everyone?
Yeah.
That way we don't have to go through each person? No? Okay. Just thought I'd try.
My apologies, and I'm back again. Kaylee Locklear here on behalf of the Maryland Retailers Alliance. We are here in strong support of this legislation, and we do manage the Maryland Consumer Freedom Coalition. So over the past year alone, 70,000 emails and thousands of handwritten postcards have been sent to elected officials, and nearly 1,000 phone calls have been made in this legislative session alone in support of selling beer and wine in grocery stores. Hundreds of community leaders, elected officials, consumer advocates, faith leaders, and Maryland residents have joined our coalition as long-term advocates and endorsers. Polling over many years, and I know you all know this, shows overwhelming public support, often exceeding 80% for expanding consumer choice and convenience. With 46 other states already permitting alcohol sales in food retail settings, we remain, as the delegate said, open to good faith discussions on workable solutions that support Maryland businesses, communities, and our consumers. We've introduced various versions of this legislation over the years. We just welcome the opportunity to address any of those issues here today. And importantly, grocery retailers are not seeking to sell liquor. You just heard that. We do not intend to harm existing liquor stores because we know that both business models can coexist successfully. So we released a brand new updated economic impact study from the University of Baltimore, and that demonstrates that states adopting similar laws have not seen the harms opponents often predict. In fact, it creates new jobs and an estimated $75 million in new revenues. So Pennsylvania, Tennessee, Oklahoma have decades worth of data. I can talk to you about Colorado because that's going to be pointed to, but what they're pointing to are articles, and I welcome that opportunity. We're here in support. Thank you for your time.
Good afternoon, Chair, Vice Chair, members of the committee. My name is Kayla Mock. I'm here with the United Food and Commercial Workers Union Local 400, and I'm here on behalf of our over 10,000 members here in Maryland, many who work in grocery retail. For our members, this bill is not just about consumer convenience or modernizing outdated laws or generating state revenue. They care about all those things too, but it's really about expanding good jobs. Allowing beer and wine in our grocery stores means more sales in the stores, which means more revenue, which means more hours, which means more money in our members' pockets. And so for that reason and more, we urge a favorable report.
Good afternoon, Madam Chair, members of the committee. Michael Adams on behalf of the Maryland Retailers Alliance. This bill represents a careful and overdue modernization of Maryland's alcohol licensing structure. It creates a narrow, controlled pathway for qualifying food retailers to obtain limited Class A beer and wine licenses while preserving local licensing board authority and providing safeguards for existing license holders. Importantly, as Delegate Ampry mentioned, sponsor amendments to HB 1303 would require a food retailer to purchase an existing Class A license at fair market value and would give incumbent license holders standing for judicial review if they believe that offer is unfair. Even if retailer ultimately applies directly for a license, local licensing boards retain traditional discretion and retailers remain limited to beer and wine sales only. This is incremental reform. This is not deregulation. Maryland's current prohibition on grocery-based alcohol sales reflects a retail environment that no longer exists nationwide. Consumers expect to be able to purchase beer or wine in grocery stores. Nearly every state allows some version of this model. However, in Maryland, retailers are placed at a competitive disadvantage and consumers are penalized as a result. Respectfully, the opposition's core arguments are not on the substance of the bill or what has occurred in other states, where overall employment in beer and wine and liquor establishments actually increased after sales in grocery stores were allowed. I'm reading from the report. In all the 3 states where long-term data was available, beer, wine, and liquor retailers' employment in 2024 was above pre-liberalization levels. Their arguments hinge on a sky-is-falling scenario that is not the intent of this bill or its proponents. Reasonable minds acting in good faith can reach a solution that works for Maryland. The retailers are ready, willing, and able to negotiate this bill on the facts and the data to find a thoughtful compromise. This bill is pro-consumer, allows fair and measured competition, and is respectful of Maryland's existing framework. For these reasons, the Maryland Retailers Alliance respectfully requests a favorable report.
Thank you. We're going to start with Delegate Chief, then Rose, then Pippi.
Thank you, Madam Chair, and thank you to my colleague, Delegate Embry, for being thoughtful on this. I know this is a contentious issue with a lot of small businesses deeply concerned about being displaced or disrupted. Kaylee, you mentioned something about Colorado, then the time was up. So I looked up online about what happened. It seemed like they enacted something similar in recent years. Was that exactly as proposed today, which is transfer with no new license? And can you talk about what happened?
Thank you for giving me this opportunity. So I think we've talked about it in committee before, but Colorado's wine and grocery law took effect March 1st of 2023. And you are going to hear a lot from opponents about articles and what's happening there. The information that I'm about to read you is directly from fiscal year 2024 to 25, the annual report from the Colorado Department of Revenue. So I want to be really clear about where sources of information are coming from. So in 2023, the baseline, if you will, the year their law took effect, there was no change there. In 2024, interestingly, there were 3 stores that were added to the amount of stores that existed before that baseline. And then in 2025, and as the delegate talked about, the way that they set their law up there is that for a food retailer to receive a full license, three licenses have to be acquired in order for us to obtain a full license. So in that year, that net change is 32 stores. But then I looked back even further. When I looked at 2026 to 2017 there, they randomly had lost 31 stores. When I looked at 2017 to 2018, Colorado had lost 18 stores. This is all pre-law. And when we average those numbers out, they have a typical 2% line of attrition that occurs. So I just want to make sure when we talk about the losses that are occurring in Colorado, we are very clear that the law is set up in such a way that we must acquire existing licenses for a full license. And even prior to the law passing there, they had a regular average attrition rate of 2%.
Okay, thank you.
Thank you, Madam Chair. And thank you, my friend, for bringing this exciting bill once again.
Exciting is the word.
Okay. So a couple of the things that you brought up today, so you said that you want to see local beer and wine sold outside of Maryland. And you, could we not conceivably pass separate legislation that would allow the shipping of beer and wine to other states and other?
The issue isn't shipping. So I've had an opportunity to talk at length with beer producers and wine producers across the state, and several great beer producers in my district who are actually struggling right now. And the reality is it's really hard to develop relationships and contracts with people out of state. So the reality is when you go up to New Jersey or New York or California and you're trying to sell your local beer, you're competing with all the local beer that's there, number one. But also number two is it's about relationships. Like anything else in business is relationship business. So if we were to allow retailers to sell beer and wine here, our local breweries and wineries would start developing relationships with your national branded stores. So think of like your Aldi's, your Trader Joe's, your, those grocery stores that are everywhere. And what would happen is you'd have a situation where when the sales are doing well, let's say there's a Trader Joe's in Columbia and this certain Maryland beer is just flying off the shelves, that Trader Joe's is gonna notice that and be like, hey, you know what? We have a similar demographic in Ohio. Let's see, are you all interested in bringing this product to Ohio? That's how business happens. I'm a lawyer. I've watched it happen in my day-to-day life. We are stopping that from happening because of our laws. Our local beer and winemakers are not developing relationships with national retailers in order to get their product out of the state in a natural way. They can go to the trade shows, they can try the normal way for sure, and that can work sometimes. But the reality is, it's a relationship, like any other business, it's a relationship business. So it would be an added bonus of the bill to help create those relationships.
I appreciate that answer. However, relationships, when you talk about having important relationships like that, our local liquor stores already have developed very close relationships within communities to promote and sell local products, and they work together and they develop very personal relationships. And I think that taking it out of the local can be different. It's a little bit more clinical when you're talking about shipping to large places. And some of the smaller producers are not going to be able to produce at the level to sell at the bigger stores. So I think that's just one concern I have. And then you were talking about limiting the beer and wine sales to a small footprint within the grocery store.
Mm-hmm.
Well, that kind of goes against what you're trying to do as far as competing with, your Miller Lights and your Coors and your big names. If they're going to have to make decisions, stores are going to sell, the top sellers. So how is this going to help when you're
we have been
competing for the smaller people?
No, I hear you loud and clear, and I really appreciate your passion in thinking about how can we protect our small businesses, because again, the goal of this bill is not to harm small businesses, it's just to figure out to create more opportunities. At the end of the day, what you're asking for there around, how do I answer this question? Well, I can answer the question. Rephrase the question one more time for me, please.
When you say you're going to limit the beer and wine sales to a
yes.
small footprint.
Yes.
Yet you want to, with your argument of selling local.
Yep.
You're not, then the locals are going to then have to compete with Coors, Miller Lite, Bud Light, whatever, the big guys.
Yeah, so.
And so if you have limited space, you're making those decisions.
Right, no, understood. So we worked in the past around creating amendments that would allow for us to put in stipulations that you have to sell certain Maryland-made products with these licenses. We're trying to figure out a way to make it work because we don't want to foul the Commerce Clause. We want to make sure that we do it constitutionally. But there are ways that we're getting there, a creative way to where we can incentivize that stores would have to have a certain amount of shelving space preserved for locally made beer and wine. So that is something that we're working on. And I hope if we can work as a committee on figuring out that amendment, there's ways that we can incentivize to make sure that our small, our locally made breweries and wineries have access to those shelves. We can definitely make that happen.
My concern, though, is that when you say we're going to make this happen, but then you're still talking about limited space. So then you're picking winners and losers. So there's a lot of local, breweries. There's a lot of local winemakers. A lot of people involved in this industry. And when they're trying to break in, again, you're competing for a small amount of space. So my fear is that you would be really hampering some of our very young and starting beer distributors, creators, and winemakers.
Yeah.
So that's to me is a huge concern.
No, I understand your concern there, but I think the other thing we have to make sure we realize is that I think the way you're operating in that question is the premise that the local stores aren't going to still exist, right? So the reality is the entire ecosystem is going to be there. So it's not that the ecosystem is going to be there for them to have access points to continue to sell at the local stores. We're just creating another space where they could possibly sell into the retail store. So it's not a either or, it's a both and, if that makes sense.
Okay, I appreciate that. I'll try to make a few more brief ones. I'll try to be as brief as I can. So obviously, I've talked about this many times, so the other states' argument. My biggest number one issue is what other states are doing, they've been doing for a good amount of time. And we're talking about pulling the rug out from under small established businesses who have built their businesses. A lot of these are family-owned businesses. And you're changing the rules and you're making things much more difficult for them. You talk about, well, it's great because they can sell their license. That's one-time money. Great, they sold their license. That's not comparable to an ongoing stream of income when you have a thriving business that you've built and toiled over to create, then you're taking it away. And then what happens to passing it on to family members? A lot of these stores are family-owned businesses. They want to create family wealth and pass that on to their sons and daughters and future generations. So a one-time sale of a license doesn't, that, to me, that's taking away wealth creation that benefits a small business and a family.
No, I hear you loud and clear, and that's why, again, there's no requirement that you have to sell, right? So the reality is, if a store wants to keep that in the family and wants to maintain that family brand and that name and be successful, and there are stores who have great relationships with the community, I don't think the community is going to turn their back on them once this bill passes, and they have the opportunity to keep that. This is for those who possibly do want to. There are people who possibly wants to sell their business, right? This is not for everybody. If the individual wants to maintain their business, there's no requirement to sell. So I think that, your concern, again, I hear your concerns and your concerns about, and will continue to thank you and praise you for you continue to stick up for our small and local owned stores, for sure.
Okay, and I'll just end with this. Yeah, they can sell it if they want to.
Right.
But what if they don't want to?
They don't have to.
But you're creating a scenario, because it has also been, through research, and we've had this bill a couple years in a row, where a lot of the bigger grocery stores, the Giants, the Safeways, pick a store, a lot of them will not renew, and this has been documented, that they will not renew leases. So as I've used the example of Carroll County, and as as you drive up the road in Carroll County, I know not every community is exactly the same.
Correct.
But the way that it's set up where I live and my constituents has a liquor store, a privately owned small business, close to almost, with the exception of maybe one, has a liquor store next door, 2 doors away. So when you're talking about the convenience, it's really not all that inconvenient, at all, to me. And so if they can't renew their lease, then they're going to be out of business by force in a way. So you're taking away that opportunity. So those are some major issues I have with this. And I just, I have a really hard time with switching rules and pulling the rug out from under thriving businesses that have worked hard to create that.
And we've worked really hard with this bill to be surgical. I think prior forms of this bill were a blanket, just change the law. But we've really been surgical to make sure that we're thinking about all that. And in regards to the distance requirements, we have distance requirements on where you can have the license to have a store in the grocery store. So there's a distance requirements that would help those shopping centers. And given the lease situation, it sounds like maybe you'd be a fan of good cause eviction for commercial leases. That's a joke, but I don't think I'll happen anytime soon.
All right. Thank you, Madam Speaker.
Thank you, Madam Chair. Delegate panel, good to see you again. So I had some clarifying questions just to make sure I completely understand this version of the bill. So are we deleting out page 2, line 4? Is that bracketing chain stores, supermarkets, discount houses, or is that staying in the bill?
Oh, okay.
Page 2, line 4.
Oh, we got a lot of amendments up here. Give me 1 second.
I know, hold on.
Page 2.
Yeah, so you're removing A.
Yeah, we're removing A, yep.
Okay, so we're removing chain store, supermarket, discount house?
Yep.
All right, so this bill, in theory, could apply to Wegmans, Food Lion, Shoppers, Costco.
As long as they qualify under the fresh food
Sheets.
criteria. As long as they qualify under the fresh food criteria.
CVS.
Well, it
Right,
offers
so we
sale
got-
food in five categories, so I don't
can-
necessarily agree that
I mean, look,
those would all qualify.
I can read, right? So I can read. So it shows, grocery stores, yeah, got it. Gas stations.
Yeah, the goal
and
here is
pharmacies.
it needs to be something that's beneficial to the community.
Right.
Something that's very beneficial.
So one thing I wanted just to get some clarification on, because this is the thing I've always brought up, and we've heard this bill many years in a row, you guys know that, is, and I think Delegate Rose kind of alluded to it, it's the impact of a change to our existing small businesses. And I feel like there's some debate about what that impact would be. So here's what I did. So I looked up online using Google search, just while we were sitting here, of the last states to make these changes. And a couple states popped up, Oklahoma and Kansas. And here's what the Google machine came back with while we were talking. It said that the introduction of beer and wine in Oklahoma led to a 7 to 9% decline in monthly liquor store visits, particularly rural stores. And it says grocer revenue gains. Grocery stores experienced a significant increase in traffic, up to 3.6% more, and a 17% rise of complementary products like snacks and produce. So it sounds like a great deal for a grocery store, right? Because what you've got is you're shifting the traffic from the liquor stores right into the grocery store. And so then we have to ask ourselves as policymakers, like, is that in the best interest of our state? You mentioned earlier that this would be a small footprint in a grocery store. Well, probably not big enough to hire any employees. So you're literally taking business out of the adjacent small business and running it into these large big box stores like Costco, Food Lion, CVS, Sheetz, Royal Farms. A lot of these companies, now I did mention a couple of Maryland companies, but most of those aren't even owned in Maryland. They're not even Maryland companies. They're just retailers, chain stores that happen to be in Maryland, whereas I would argue that every single one of these small liquor stores are probably all Maryland companies. Maryland residents working there, right? So, I mean, I think that's the data. You know, and look, and if you were to poll somebody on the street and ask them, hey, so you got a grocery store here, a liquor store here, if we allow all the alcohol to be in the grocery store, do you need to go to the liquor store? I think most people would say probably not, right? You know, and I'm not even getting into the fact that the grocery stores have a major advantage in buying things, right? They can buy things in bulk. Matter of fact, Costco, who is the largest wine seller in America, has the advantage of negotiating what their prices are, which means if I'm the grocery store, I'm going to sell everything cheaper than everybody else, right? All my beer and wine, it's going to be cheaper than every single liquor store in the area, all day long. And what's going to happen is no one's going to go to these liquor stores. And so, you know, and I'll get to the punchline here in a minute, is that because of these blackouts for the grocery stores, the box stores, the discount stores for so long, the decades, we have created this situation where there are Class A stores everywhere, right? Class A stores everywhere. And I feel like if you make using Delegate Rose's point, a knee-jerk reaction, or you pull the rug from under these folks, it's going to have according to what I just pulled up here, a devastating effect on thousands of small businesses in our state. And I just don't think I'm ready to do that. I mean, you know, we're in a committee here that is trying to grow the private sector, retain jobs, you know, and I have yet to hear a compelling argument that making this move is going to somehow better the economy or create more jobs. The only thing it seems like it's going to do is kill a lot of jobs. A lot of small jobs in my district and throughout the state, and I just don't see it. I just don't see how the math is ever going to add up, because the nature of these grocery stores and chain stores is that they don't hire more people. They're going to put a half an aisle in one of their many aisles. They're going to sell alcohol really cheap, and it's just going to close out all their competition. And so, isn't that so?
No, it is not so.
Yeah, thank you, Madam Chair.
So we don't, I guess, can we respond to that real quick, Madam Chair? So I just want to be clear. I mean, thank you, Delegate, for that question, speech. I don't know how to describe it, but I appreciate it. At the end of the day, I think the data, again, we can Google articles online real quick. We can use AI to find things, but we did a deep dive into the data, and the data just says that some of that stuff that you presented wasn't all the way accurate. And I think one thing that we have to be careful of is when you look at other states are also really tricky. So my childhood was spent in Oklahoma, and the reality in Oklahoma is Oklahoma's always sold beer and wine in grocery stores. So the reality is they just changed the alcohol amounts you could sell. And the other reality is spirits will still be solely held by our local owned store. So there still is they will have a direct monopoly on that space. But my colleague here has a more pointed answer on the data piece on employment, because I think you raised a valid concern there.
So speaking as to Oklahoma, there was an increase in employment in beer, wine, and liquor retailer establishments after the change by and this actually was 8% above pre-change levels by 2024. The number of establishments overall in Oklahoma grew and was above pre-change levels in 2023, did fall slightly in 2024, but I hate to use the word recover, but it gained additional stores. In addition, one of the points was talked about undercutting prices. I think we have data in Maryland based on our current structure, which talks about this ability to undercut prices. I think there is a large warehouse-sized liquor store, alcohol store in Laurel that is national and has the ability to negotiate those prices. Within 2 miles of that very large store, there are 11 existing liquor stores. There are 67 liquor stores within Laurel proper. If this was a analysis based purely on the consumer seeking out the lowest price, bar all else, I don't think that would exist in our current format. But there's a lot more driving it. If your local liquor store has a better bourbon selection than another liquor store, you're going to go to that one. If you have a relationship with the owner of your local liquor store, you're going to go to that one. There are many, many factors that add into this, and the simple analysis of additional limited competition will wreck everyone doesn't take in a million other factors, including the math in other states.
Just briefly, so is there another state, I know you mentioned one, is there a state that has allowed what the system, I mean, look, there's only a few states left, right? Maryland's one of like 5, maybe?
One of 4.
4, okay. So what's another state that has allowed this law to be in effect for 3 decades? And what has been the change when you just, you go from banning it to allowing it? I mean, I've yet to hear that specific. It's always been little incremental changes here, there.
Well, Colorado is the most on-point example, which is what Kaylee highlighted in her testimony.
They changed both, which is why we have a lot of conversation. The problem with Colorado at this point is you do not have long-term data. Pennsylvania and Tennessee made wine changes in 2016. Oklahoma made changes in 2018. We point to those states because in the past 2 decades, they're the most recent states that we have to look at.
Yeah, I mean, so that's the challenge, is that there's just, I'll flip it on you. There's not a whole lot of empirical data that shows that this is not going to have detrimental impact on our small businesses, right? I mean, so.
Well, look, I'll give an example in another beverage space. So I had an opportunity to talk with my staff, had an opportunity to talk with some professors, particularly a professor in Connecticut, and there was a lot of fears around the same thing that you're mentioning, Delegate. And the example that he gave that was a great starting example was the Starbucks concept, right? I believe that at one point when Starbucks became this big retailer of coffee, the nation was worried, and a lot of communities were worried that the local coffee shops were not going to be able to be successful. And this kind of points to the data that you've heard thus far, that the actual has been growth in the local package stores in these states where they've changed the law. The reality is when Starbucks introduced that, they created a larger palette for coffee. And what happened was people then started going, as we just mentioned earlier, to find local coffee shops, and local coffee shops actually boomed. You saw growth in local coffee shops. So the reality is there's this concept that if we create a palette, right, a small palette at these grocery stores, you actually can have the reverse effect of what you're worried about, and where people are actually going to seek out, hey, I tried this wine. Oh, I know this store has wine from every country. So now I'm going to go try wine at this local shop. Develop a relationship with that store, you go there more often. So the reality is there's a space and place where what you're worried about, actually the inverse happens, and there's empirical data that shows that in various states, and it's really why you're seeing in other states, why you're seeing that growth happen with local stores.
So Delegate, this is my final point before the chair takes my parking space away. Here's Colorado. You ready? It says, Colorado liquor stores have faced significant revenue losses and closures since grocery stores were permitted to sell full-strength beer 2019 and wine 2023. Many independent retailers have seen up to a 40% in revenue drops, leading to closures and forced adaptation through loyalty programs, while new state legislation in 2025 has blocked new liquor store drug sales. So There you go. There's Colorado. 40% drop, significant revenue losses and closures.
What's the source? I don't.
The internet.
Well.
So, there you go.
We'll have to talk offline
Thank
about
you.
those sources.
All right. Thank you, Madam Speaker.
Your chat. Thank you, Madam Chair. So I guess I want to thank you for making lots of, concessions or changes to make sure that this could fit many models, because I do believe anything we do can't be a one-size-fits-all. And so my county's a little different because we already have our county acting as a wholesaler and a retailer. So anyone else coming in as a big store or something is really going to impact our small businesses who have already set up their model. So I guess my biggest question to that, this is only enabling. We in Montgomery County can say we don't want this at all. Is that within?
So this would open up the opportunity for this to take place everywhere. The reality is, I wouldn't necessarily call it enabling. It would change the laws, but what it would do is the local liquor boards would still have control over who gets licenses, where they are, et cetera. So there wouldn't be a I wouldn't want to call it enabling, because enabling is like you get to choose whether or not this law applies to you at all. Mm-hmm. This is more of, this law is now in application, but you still have the authority on where your liquor, who holds liquor licenses, how they transfer, where they go, the costs, et cetera. For your local liquor board, we still have that control.
And so the distance, I guess the distance impact is to look at those stores that are already co-located with a grocery store or something. Mm-hmm. But you said you were thinking about this idea that it was not a 1-to-1, but maybe a 1-to-3 or something like that. Is that coming from some other model you found somewhere?
Yeah, I think that's
Colorado.
Yeah, but she's the Colorado expert here.
Sorry.
Oh, Colorado was the approach they took?
Colorado, for a full liquor license, you have to acquire 3 existing licenses. So that's where that conversation comes from. It's something that we've never put in the bill, but certainly something we can talk about. Okay.
Yeah, open to that number, whether it's 3, 4, or maybe for a larger store, we require them to have more licenses, smaller store, et cetera.
So I guess my other question around that is, you said it's not enabling. So would the liquor board be able to say, well, if we did do this, we don't want it in gas stations and convenience stores. We just want it in a grocery store.
Local liquor boards would have control over where licenses are.
They would have that control?
The same way that they have it now. Okay. And again, we want to make sure that localities can control their spaces and places and have it how they want.
And has any of the places where this happened, have we done anything to make sure that those small businesses aren't hurt? Is there any sort of incentives or other plans to make sure that they aren't losing their employees or any of that kind of stuff that goes along with that transfer of a license?
I don't know of any specific things, but I just know that the big thing is making sure that the transaction is at a fair price.
So it's just the cost. Yeah. So getting back to Delegate Rose basically saying, hey, it's not just the sale of this body. We may have lost jobs or something like that. There's no broader economic impacts we know about that we get compensated for or can be compensated for.
Generally, the data I was pointing to before, in many cases shows an increase in overall employment in that space post-liberalization. Sometimes there's a decrease in the short term and then recovers in the long term. Okay. What is, I think, important to realize is what this panel wants, one of the themes of this discussion to be, is that these are all really excellent questions that I think can be solved with some work. If the frustration for this table, I think a lot of times has been we have what we believe is sort of a good faith proposal that wants to take into account a lot of different interests, and we continually get met with a no, can't happen, won't happen, no good reason for it. And if that's the case, fine, but I don't know if that's not the best way to get good law made. It's not the best thing for consumers in Maryland and sort of what they want. So we can fix those issues, absolutely, and we'll be at the table. I hope everyone else is there as well when we are.
Okay, just last comment then, Delegate. Anything you want to say of how you think this won't hurt my small businesses in Montgomery County?
Look, I think the example I just gave earlier about dynamic demand, I think there's a world where by putting beer and wine and making it more accessible in certain convenient spaces, people are going to be able to be exposed to those items, right? So, and then they're going to flock to the stores that are specialties in those spaces. So the reality is, I think that the data shows that there is a world where by passing this bill and having beer and wine in more convenient spaces and retail establishments, there's a world where we actually could see a world where the local stores will see a boom because they have a specialty market. And I think that, again, the Starbucks example that I gave earlier is a clear example. Like after Starbucks happened, you literally saw an explosion of local coffee shops. In my neighborhood, there's probably 6 different local coffee shops to one Starbucks. So this is the example of how that dynamic demand can happen. We actually can grow the pie versus the idea of like we're actually losing more pie, if that makes sense.
Chair, thanks for bringing the bill. I didn't have anything else to do today. All kidding aside, you mentioned something, Delegate, that these people, do all counties have the ability to sell their liquor licenses in the state?
I'm sorry, do all?
You mentioned something about selling liquor licenses. They can sell their liquor license.
I'm not an expert on the space, so I'm not sure if all counties have it, but my understanding is most counties do have the ability where you can transfer or sell a license.
Okay, there are some that don't, and that's an issue. So when we talk about this, I think, I know a lot of questions have been asked, but I'm going to focus on a little bit about what I see in this room and stuff like that. What percentage of sales, Kaylee, you mentioned this a little bit, what percentage of sales is beer and wine in a liquor store? Do you know? I think it's somewhere between 20 and 40%, right?
That sounds about right.
Something like that.
I defer to you.
I believe that's what, I got statistics just like you do. I read something that says, so I'm trying to keep moderate. How do you expect a store that's existing today to exist with 20 to 30% of their revenue gone?
20 to 30% of their revenue won't necessarily be gone, and I think that statement alone is an assumption, though. It doesn't mean that every single sale then all of a sudden goes to the food retailer that then has a license. That's not the way that it works at all.
Give me a number you think they're going to lose then.
I don't have that number.
15%, 10%?
It would be contingent on so many factors, it would be hard for me to figure that out.
Yeah, to be realistic, I think we could agree, I think people would sit back and say they're going to lose at least 15 to 20%. That would be my logical guess, because I know how much beer they sell. And I know they do sell a lot of wine, not always high end. So I sit back and I listen to this bill several years now, and I say that, you know, if this were day one of alcohol in Maryland, this bill might be a good idea, but the toothpaste is out of the tube right now. These people have built businesses, we built buildings, we put these people in locations, and I'll go back to something I think the couple other delegates mentioned. These are businesses, these aren't jobs. In a grocery store, you're going to provide some jobs. These are businesses. These guys, these people are in this building right now. They buy these businesses. They build these businesses for their family. And typically, I understand there's probably an average of 5 to 7 people that work in these stores. So those people are now a business. To sit back and say that I'm going to buy your liquor license and you can go on your way, we have 5 to 7 people that don't have a job. Wouldn't you agree? And I talk about this stuff, and then I wouldn't agree.
I'm sorry.
Agree with that statement.
Where do they get a job? They have to go out and find another one?
I think you're making a lot of assumptions.
No. What do they do?
No. I think you're making a lot of assumptions. And at the end of the day, I think the data, the data shows that we literally have reports made by literal economic professors from various prestigious institutions from across the state, not quick search Google articles, talking about deep dive PhD level folks who can break down the data and show you that the inverse is happening in many states. You're seeing new stores pop up after these bills pass. Because the example I just gave a moment ago with Starbucks, you're seeing the inverse happen in a lot of states where more stores are coming online.
They may start up, but not in the same location. I have already built my business. I have it where I have it. Maybe I own the building, maybe I rent the building. But when you're sitting back there, and arguably, again, Googled it, 70% of these stores are within range of a grocery store. They are anchored. The anchor is the grocery store. Yep. So those people just don't go out and go say, okay, I'm going to start a business somewhere else. That's where they've been. That's where they've generated their money.
As the example I gave earlier, in the state of Maryland currently, in my district and other districts in Baltimore City, you already have grandfathered retail stores where this already exists. They've put but if I walk on my jogging route from my home to Eddie's of Roland Park, when I make that jog, I jog by about four liquor stores that are doing great. And at the Eddie's of Roland Park, they sell beer, wine, and spirits. Mm-hmm. So we can talk about, your assumptions. I'm talking about reality. Okay. And the reality is they already coexist here in the state of Maryland. And there's not this sky falling. The stores aren't doing well, and I shop at all of them because each of them have something special. One store has a great tequila collection. One store has a great wine from New Zealand collection that I like to go to. Right. So the reality is, there's a space and place for everyone to coexist, and they already coexist now. So the assumption that they wouldn't be able to after we pass this bill, I don't think is a fair assumption, but I'm happy to talk more about it offline.
Okay. My district isn't your district. My district is
very true.
And again, not all size fits all. It doesn't fit everybody.
Yeah, no, agreed.
My biggest thing, and I know we've touched on this a lot, I just sit back and when I look at this bill holistically, I sit back and say, what are the two biggest problems we have in this country today? We have drugs and we have alcohol issues. And for the life of me, cannot see why we would sit down and say, gee, this is a great idea. I'm going to put alcohol available in more places for more access, for more people to see it, for more theft to happen. And I somehow think that's a good idea in Maryland. I think what we have right now is working. It's providing homes, it's providing jobs, it's doing everything it needs to do. I'm not necessarily real interested on providing Safeway and Food Line and those companies big dollars and taking this thing. I go to get things done for my kids and my community, and every one of these places I can walk up to and say, can you sponsor something? And they do. I can't even say, is that so?
If I may, we were talking about employment numbers, and it just took me a second to actually pull them up.
Well, you're going to do what I did, Kaylee, with all due respect. You're going to pull up what you have, and I pulled up what I have.
Our numbers are from the state, though. So what I'm looking at is not a Google AI search. It is not an article online. Respectfully, the numbers that I have are our codes in our state. So currently selling alcohol, including some of our grandfathered in stores in this state, there are 5,695 people that are employed in that industry. I just want to point out, because for whatever reason, grocery is vilified in this space, but I want you to be very aware that we employ, just on the supermarket and grocery side, 51,000 people. Our convenience retailers employ 7,600 people, and our warehouse clubs and super centers are employing over 16,000 people in the state.
Okay.
We are not trying to eliminate jobs. I want to be very, very clear about that.
My point is, these are business owners. These aren't jobs. Thank you. I'm done. Thank you.
Thank you, Madam Chair. I don't have a Colorado-specific question, but I have a bill-specific question. As delegate sponsor clarified that, this jurisdiction is different. As the only Baltimore County delegates on the committee, I carefully listened, and my county has over 200 liquor stores. I have specifically 3 questions. One is the structural kind of contradiction question. On the bill, on the section 4-205, it allows a retail establishment within, I believe, 3,000 feet to approach a Class A license holder to purchase their license. I believe that we are effectively creating a pressure on small liquor store owners to sell their license to large retailer who have far greater purchasing power. That is not my question. My question is, if the long-standing policy of our state has been to prevent chain store and supermarkets from selling alcohol in order to protect small business and maintain controlled distribution. I'm talking about controlled distribution. What evidence do we have, not the anecdotal, the empirical evidence that do we have this policy has failed for so many years, and why should we dismantle it now with this bill? That's my first question.
Your question presumes that the outcome is zero sum, that somehow the current system is failing, and by passing this bill or some carefully crafted version of this bill that I know this committee is more than capable of, that it will blow up the existing structure. The reality is different. The reality is it's not zero sum. The system isn't unsalvageably broken, but it can be better. It can absolutely be better. And this bill is an attempt at making that system better. So I take umbrage with sort of the premise of the question.
Yeah, my second question.
I think Kaylee has a good answer for the parts where it doesn't necessarily work for our state and region.
If I may, I would just say that Maryland is at a competitive disadvantage here. Residents are regularly crossing over the lines into Delaware, Pennsylvania, Virginia, West Virginia, Washington, D.C., and that's its own. We have a lot of data around that to one-stop shop. But what I want you to think about, too, is they're not doing it just to go buy beer and wine. They're not just going over the line and that it ends there. The entire grocery basket purchase goes with it, too. So that is also an impact of being a border state where almost every surrounding state, you have the ability to go purchase beer or wine at a grocery store and one-stop shop. And there's a lot of Marylanders that live on the borders.
Kelly, can you give me a favor and send me your data and we can talk offline? I have another question about the expansion question. This bill goes beyond grocery stores and includes pharmacies, right? And retail service stations. Can you explain the public policy rationale for allowing alcohol sales in location whose primary purpose is healthcare and fueling vehicles? Like when you play football in a basketball ground, what happened? So, I mean, these are the codified into laws. And what is your rationale here?
So, well, you want to? No, I'll talk to Love. Go ahead.
And I love that I get to have this conversation with you coming from the Health and Government Operations Committee, because I also have the opportunity to represent the Maryland Chain Drug Store Association. And pharmacies have been struggling. You all saw Rite Aid close all over the state. That is not new. That is not going to change. There are major issues going on in pharmacies in general. And that's something we talked about, I think, at length and made a lot of changes with regard to PBMs and issues like that. And one of the reasons we're so interested in expanding into those spaces is to also help retain and stabilize those industries that, just like grocery, have very low profit margins as well.
My last question. I heard a lot that within our state, there are certain counties, they already have this provision. This is a community control question. The bill creates a presumption that issuing these licenses is in the best interest of the community. That's what I've heard.
It's in the bill.
Why should the legislator, we override this local judgment and assume that expanding alcohol access in this retail environment in every jurisdiction is automatically good for every community? And I could see a lot of constituents out here, but their president doesn't say that. Could you elaborate on that?
I would just say, again, this goes back to the local liquor board and how they make decisions. I think that that's pretty standard language, that a license has to be given in the best interest of the community. So it's something that we wanted to replicate and also put in this bill. But I think it's also an opportunity to have another conversation. If there is better language or those decisions in some way, we talk a lot about local authority and we talk about local courtesy, and now we're talking about perhaps something where state would override locality. So that argument goes back and forth.
Okay, I yield, Madam Chair.
Thank you, Chair. Delegate Pippi and I were, I'll be quick. Delegate Pippi and I were just chatting back and forth, and the conversation that I was having with him had to go with cannabis and sort of what's happening with the legalization of cannabis in the state of Maryland. Now, what I'll say to you is that many of the business owners in my community and some of the liquor stores that happen to exist in Wycomico County talk about this world that we're living in now where more people are consuming cannabis at the expense of alcohol. Now, whether it's spirits or whether it's beer or wine, I think the story is the same. And my question for you is, do you have a concern about bringing a bill like this at the same time that we are having what I would deem to be a fairly substantial shift in consumer preference towards other forms of I'm just going to say cannabis, purchasing cannabis at the expense of alcohol. And so that's my question.
No, I hear you. I got a cannabis bill today too. So I understand your question. So no, I think fair question. I think it goes back to what I said earlier about dynamic demand, right? I think that one of the issues that we have is that people are, experimenting with other items to have adult fun. And the reality is that if we were to expose more people to beer and wine in their normal shopping convenience metrics, it could possibly and likely, as data has shown, create more demand for the product. Again, it's the third time I said it. The Starbucks example is a great example, right? If you create a palate for it, people will go try to expand their palate and try other things. So the reality is, I understand your concern that cannabis is becoming another option for people to enjoy themselves socially. But if we can create a world where they have more access to beer and wine as an opportunity in stores or in the convenience store, in stores, in pharmacies, et cetera, there's a world where it would actually increase demand in other spaces. That is shown to be proven in other areas based on the data that we have. But again, it's not a concern that I really have.
Well, it's a concern I have. So that's marketing talk that you're sharing, and I don't disagree with the idea that you're marketing a bill that tends to have to fight against the principle of just consumer behavior. And I'm just saying that consumer behavior at the moment is trying new things at the expense of the tried and true things to have a good time, and that's a real market environment that we're in today. And Mr. Adams, last year, I want to apologize up front. Last year was a tough, rough and tumble back and forth between you and I. So I apologized after the hearing last year. I don't forget it, and I say it on the record just to be full.
No offense taken.
But what I said last year is that that market and economy, that beer and wine and liquor, they're commodities. Okay, delegates talking about niches and Starbucks and these sort of things that consumers sort of attach themselves to as they're looking to buy products. I have a tendency to believe that a bottle of Budweiser is a bottle of Budweiser, whether I buy it from this store or that. And so it's hard for me to accept the principle that a small business can create this market niche against a large, well-financed competitor that can just beat them at the punch because, as I said last year, and I'll say again this year, a grocery store could sell a can of Budweiser at a loss. They're called loss leaders, and do it in a way that's very predatory in practice. And so my question last year, and I'll ask it with a little bit more candor and respect this year, is how can we have an honest conversation about what's happening in the marketplace when this isn't a bill about winners and both sides coming up? This is about somebody's going to win and somebody's going to lose if this bill passes. You have to accept my principle that this is a commodity. You have to accept my principle that a large grocery store can and will act in a predatory fashion to beat their competition. That's what they'll do. But if you accept both of those things, at the minimum, I'm just asking, do you not see this bill as a simple somebody wins and somebody loses?
So I don't see it that way, respectfully. For a couple of reasons, though. The first is there are existing laws in Maryland regarding monopolization and how things can be priced and unfair advantages and that sort of thing. And there's additional conversations we can have about how to protect businesses who may not have the same bargaining power as a large business. The second place I would push back is if, assuming sort of the straw man of tomorrow, every grocery store in Maryland now has a beer and wine license. Assuming that straw man, I agree with you. I think that's an issue that they cannot deal with in the short term. However, I know, and we talked about this last year, That is not the bill that would ever come out of this committee. It's not what this panel is advocating for. We have very, real expectations about what this looks like. So in a world where retailers are allowed to get these licenses in a measured way, there are other bills in this body that there are population caps. There are requirements to buy certain licenses. There's a lot of things we can do to protect that small business. We want to have that conversation because we don't think it does anybody any good to have people go out of business.
But to accept everything you just said, you have to tell me that alcohol is something other than a commodity, and that it comes down to location and convenience, not about, hey, I can do something different than a grocery store. And that's where I think you and I are going to have a pushback, because really, at the end of the day, this bill fights against some basic principles. And Madam Chair, I'm getting ready to hop off the microphone here. I've been trained to understand the three-tiered system for what it is. Okay, it is a protectionist scheme that allows It's a protectionist establishment that keeps the manufacturer, the retailer, and the wholesaler separate for the purpose of making sure, guess what? Small businesses can participate in the marketplace. If we start breaking down the barriers in ways that eliminate the reason why the three-tiered system exists, then you eliminate the reason why we're trying to protect the small businesses. Because without it, all it is just a product to sell, and who cares? Who cares whether we distribute it? Who cares whether we retail it? What we're doing under the system that we have in our state of Maryland, the way we've constructed it, and I'll agree with what Delegate Aaron said, is that this is something the state of Maryland has been working on for far longer than I've been in office, and I've been here for 12 years. And so we're doing it for one reason, in my humble opinion, to protect the small guy. And that's where you and I are going to have, I guess, an honest disagreement of opinion. It's where we were last year, and I think we're here at the same spot. But thank you.
Okay, Delegate Amprey, I will let you respond, only because you're the bill sponsor, but we won't be having this back and forth for every panel. I'm just letting anyone who comes up before us, there won't be banter back and forth, just to whom the question is pointed to.
No, well, I just want to clarify. I think, Delegate Adams, you have a fair concern about fair competition, but this bill does not change the laws that we already have in place regarding fair competition. Maryland law strictly prohibits selling alcohol below wholesale costs. This bill does not change that law, that the comptroller's pricing regulations or to do anything anti-competitive. So, but we can talk offline. We can talk more offline about that statute and how the law works, because I know Madam Chair wants to proceed. We have a lot more bills today, so I don't want to get into the weeds of the law. But we can talk about it offline for sure.
Welcome to Delegate Amprey Day.
Sorry.
So we'll go with Delegate Rose, and then Delegate Howard has the last question.
Okay, I know I had a chance, but I'll be quick. A couple things, just quickly. So you talk about asking if people would support being able to buy it in grocery stores, but we don't ask the question, and I have asked a lot of people, would you want that if it meant your local owned store went out of business? So it's all in how you phrase a question sometimes. It's very easy to do polling and do, even ballot initiatives and things like that. It's all in how you say it. So that's just one point. And I've seen the Facebook ads. There's apparently some truck driving around here today. Here's my problem with that too, is the local small liquor store owners, they don't have that kind of money. I mean, you could put the full out blitz and say, all these people want this, want this, want this, want this. But if you ask them the question that's the reality, that if this happens, you're going to lose your local businesses, that's not really being reflected. So I just felt like that needed to be said, and I'll stop at that. But I just thank you, Madam Chair.
Thank you, Madam Chair. And I just had to testify on a bill real quick. It's a drinking water bill for my constituents, so I'm a little bit, walk me through, like, who decides fair valuation? This is the question I had before I wanted to leave, or before I need to leave. Who decides fair valuation of the business? And how is that calculated? I mean, you're removing technically 2/3 mix, a third mix of product. How is that calculated?
So the bill is currently drafted, allows for the fair market determination to be appealed to this local circuit court, I believe. That said, that is not the be-all, end-all of how, if we were to go that route, how the valuation would be done. Does that answer your question? You're saying who has the, sort of blesses it in the end? I mean, the courts as currently written, but in terms of getting
So
like an
the
economist
business owner-
to evaluate, I mean, you'd have to have expert testimony that would be proffered, 2 dueling experts, and then a judge would pick what they believe is correct.
So a grocery
That's currently
store.
drafted. There's other way, we could draft it other ways to make it more amenable to the committee.
Yeah, because I mean, a business owner has to incur legal costs and go before a court for final valuation of their business that they've had long.
We could draft it so that the cost, the legal fees would be captured by the person.
Yeah, but
So there's a way to.
I appreciate that small offset, but I don't know if that's really getting at the heart of what I'm talking about, right? So they're not allowed to sell liquor. So do you base, the grocery stores aren't allowed to sell liquor, but they buy out a local store. So do they only pay for 2/3 the mix and product, or how does
No.
this work?
It would be the value of the existing business. And the value of the existing business would include beer, wine, liquor, and anything else that's sold within the premises.
Interesting. Okay. Thank you. Thank you, Madam Chair.
Thank you. Thank you, Delegate Amprey and your panel. A couple of more favorables, Kate Sims, John Pica, and Ava Hudson. And if you guys could get seated and begin, that would be great.
Good afternoon. My name is Ava Hodgson. Thank you for the opportunity to testify in support of HB 1303, the Alcoholic Beverages Modernization Act of 2026. I am speaking to you today as a resident and community leader who resides in downtown Baltimore. Grocery stores are more than retail establishments. They are anchors of our local economies and foundations for healthy communities. When a grocery store succeeds, the entire community benefits. Employees earn wages that are spent locally, strengthening small businesses and supporting neighborhood economic activity. Nearby retailers see increased foot traffic. Families maintain convenient access to fresh food and essential goods close to home. Grocery stores often serve as one of the few consistent economic drivers in many communities, particularly in areas like downtown Baltimore, where other retail options can be limited. At the same time, grocery retailers operate on extremely narrow margins, and they are facing sustained increases in labor costs, transportation expenses, and utilities. These pressures make it more difficult to maintain staffing levels, invest in store improvements, and in some cases, even keep locations open. Allowing the responsible sale of beer and wine would provide a carefully regulated additional revenue stream. Over 80% of Marylanders support this issue. HB 1303 is a common-sense proposal that respects Marylanders' ability to choose and aligns our state with national norms. This modernization would not fundamentally change the role of grocery stores in our communities. It would strengthen their ability to remain viable, competitive, and locally rooted. The added revenue would help sustain jobs, preserve employee hours and benefits, and support continued investment in Maryland neighborhoods. With these points in mind, I respectfully urge a favorable report on HB 1303. Thank you for your time and consideration.
Hello, my name is Kate Sims. Thank you very much for the opportunity to come and discuss. I would like to, I support HB 1303 because it reflects practical realities facing many Marylanders. Working parents and Marylanders across the state are managing increasingly busy schedules while also coping with rising costs. In 46 other states across the country, residents can complete their shopping in one location. Allowing beer and wine sales in grocery stores would provide modest but meaningful benefits to Marylanders. I do not see this as a one against the other. I just see this as giving Marylanders an opportunity to have a choice as to where they purchase things. There will still be need for liquor stores. There will still be liquor stores who can provide higher level qualities than you will find in grocery stores. None of that is going away. I do not see how allowing beer and wine in grocery stores will require liquor stores to close or really even reduce business. They will still have the opportunity to sell all of the same products they have been selling. Over 80% of Marylanders support this issue. Many parts of the country have systems that allows grocery stores to carry beer and wine while maintaining a strong local mom and pop presence. We can do that in Maryland as well. What is not acceptable is maintaining the status quo that a majority of Marylanders do not support and where consumer convenience and choice have been limited for decades. Now is the time to change. For these reasons, I respectfully request a favorable report on HB 1303. Thank you for your consideration.
Thank you. Madam Chair, members of the committee, John Pica on behalf of Royal Farms, a Maryland family business with over 180 stores and 4,000 employees in Maryland. The public clearly wants this. And, you know, Delegate, I've heard the question about large grocery chains or stores. Not every proponent of this bill is a large grocery store. So there's a 3,250 square feet limitation in the bill. Royal Farm stores are not going to be able to commit a large space to selling beer and wine. You're not going to get a bottle of Peroni or a can of Peroni, and you're not going to get a good bottle of Italian Red at a convenience store, and you can't sell liquor. So we're in favor of this bill, Madam Chair, and if the committee decides to commit this to a work group, we would hope that we would be a part of it. Thank you.
Thank you. I don't see any questions for your panel. Thank you very much for your testimony this afternoon. We'll now move on to the favorable with amendments, Michael Halloran and Kirk McCauley.
Oh, man. No one.
Of course.
Good afternoon, Madam Chair. For the record, my name is Mike O'Halloran. I'm here today representing the Mid-Atlantic Petroleum Distributors Association, whose members include owners and operators of convenience stores. We certainly appreciate the sponsor's leadership on this. As I just alluded to, our members make their living in the convenience industry, and certainly that's been a topic so far this afternoon about convenience when it comes to these products, beer and wine, and obviously our members know exactly what that means, and they know that our customers do want this. And in many ways, we are perfectly situated, practically and geographically, to offer beer and wine. You know, the reality is that for many communities throughout the state, the convenience store is the primary grocer. So we would certainly hope that should the committee move forward in this, we would have an equal opportunity to offer beer and wine. As our sister stores in Virginia and other places do. And on that, we would ask, as my written testimony mentions, we would ask, should the committee move forward to reconsider the square footage, you know, because at the end of the day, all we're looking for as an industry, as a convenience store industry, is the opportunity to compete. You know, some of the other provisions in the bill with regards to food product categories, SNAP benefits, those things a lot of our stores do already. However, some of our legacy stores, the square footage in the bill that's introduced does create a problem. But again, we're just looking to compete. Obviously, the ultimate authority, quite frankly, probably rests with the local liquor board commissioners. But as the bill is drafted right now, we would ask for that amendment. So, Madam Chair, with that, I know you have a long afternoon, so I'll conclude and appreciate your time.
Madam Chair, members of the committee, my name is Kirk McCauley, and I represent convenience stores, service stations in the state of Maryland. I echo what Mike said, and I live in St. Mary's County. We have beer and wine in gas stations right now, gas stations and convenience stores. No problem. We don't have a problem at all. With Maryland, the laws are chopped up into counties, and that would be a good place to look and study if you want to. But the square footage is way too big. I mean, it's discriminatory, truthfully, towards small business. Yes, the food stores are big, The Costco's are big. They all sell our gas. Now you want to give them something else. So it's, if you're going to do this, make sure everyone's inclusive and included in the bill. And small business needs to be. We're ready to move forward. And I'll leave it at that. You have my written. Thank you.
Thank you. I don't see any questions for you, gentlemen. Thank you very much for your testimony this afternoon.
Thank you, Madam Chair.
We'll now move on to the opposition. Let me see here. I'm calling on Kathy Hoke, Steve Wise, Jack Milani, Kim Lawson, Ashish Parikh.
Any particular order, Madam Chair? Okay. I'll proceed. Steve Wise here today on behalf of the Maryland State Licensed Beverage Association, which is the trade association of alcoholic beverage licensees, many of whom are in the audience today. I thank Delegate Ampry for our conversations about this bill over the course of time before we proceed. There were a lot of things discussed, and I'm just going to try to thread together what I thought were a couple of key things that should be cleared up. The state of Colorado, you heard the proponents say, well, it's only been so many licenses that have really gone away. Whereas we have media stories, which I'm happy to share with you, indicating that as many as 200 or more stores have gone out of business. And you may say, well, which is it? And I think the truth is that both things can be true. Maybe the number of licenses, the different number, is small. But who holds those licenses now that the law was changed out there? And what our industry colleagues tell us is it is no longer the independents, and that's the 200 or so that you've lost. So it's been a displacement, and those have been picked up by the larger stores that came into play. It bears repeating that Colorado attempted to did step in and roll this back. So I think that's evidence that they knew they went too far and made a mistake. The second thing I want to address in my 20 seconds is this process. There may be amendments, Delegate Ampry, I haven't seen them. But no matter how you try to set up this process where the big store is coming to the little store and saying, I want to transfer your license, there is a leverage factor there that you cannot avoid. And it's either through leases or otherwise, or making a low ball offer, but the leverage is there, and there's no way to legislate around that. Thank you.
Hello, members of the committee. My name is Kim Lawson. I represent, my business is Fish Paws Marketplace. We are third-generation alcohol retailer in Arundel County, which dates back to 1935. We employ between 20 and 25 people with employee benefits, paid time off, IRA plan. All employees are paid over minimum wage. We have been in business since 1989. I've been in the business since 1989, 37 years. Why? Because I love the business, the customers, and the community I serve. We donate at a minimum of $10,000 yearly to local charities, plus our annual charity event to benefit Baltimore Washington Medical Center Foundation Corks for a Cause, which raised $41,000 in 2025. We have been experiencing a loss of business in the past few years due to legalization of cannabis, anti-alcohol sentiment, federal job loss, federal shutdowns, and the cost of living in Maryland. Beer and wine sales are approximately about 60% of our business. If a large competitor would come in, we're going to lose something. It's just logical that we would lose some kind of percentage. There's going to be customers that buy at the grocery store versus our store. Unfortunately, we would have to make hard decisions, which may be we have to cut back on our employees or their hours, so that's a real true cost. This bill is about locally owned businesses versus large corporate businesses. Convenience. Every grocery store pretty much has a licensee several doors down. So convenience is really not a factor. It's a matter of walking 2 steps. We all want to get healthy. Let's do some walking. The added employment. Right now, if they add 1 row of beer and wine in the grocery, they're not going to really add any additional employees. I mean, look what they're doing already. Every grocery store, every convenience store is putting in more self-checkouts. So I really don't feel that there's going to be additional employees hired. Oh, gosh, 2 minutes are quick. Thank you for your time. And if anybody wants to reach out to me afterwards, I could give you some more information.
Good afternoon, Madam Chair, members of the committee. I'm Kathy Hoke, a professor at the University of Maryland Carey School of Law, where I teach and practice public health law. I'm here today to give you the public health voice. So the cheese stands alone, I feel, a little bit right now. I just do want to point out, in particular, a focus on the community of people who are in recovery or who are seeking sobriety. And right now, they can go to the grocery store, they can stop on their road trip at a convenience store and pop in to get what they need, fresh fruits and vegetables or the Monster energy drink that I sadly stop and get, without facing down the demon that they have either successfully fought or are continuing to fight. Bringing alcohol into those venues really doesn't help that community at all. It hurts them. Moreover, parents who want to take their children to alcohol-free venues, they choose not to expose their children to alcohol advertising or even the visual of alcohol, will not be able to take their children into those places. So the convenience for some becomes a massive inconvenience for others. And so I think we should respect families and people in recovery and not allow the convenience of some people take precedence over the public health value of protecting our children and people in recovery. So for these reasons, I urge an unfavorable report on this bill. Thank you.
Good afternoon, Madam Chair and the members of the committee. I'm Ashish Parikh here to respectfully request to vote against the bill, House Bill 1303. The main reason I'm here, a lot of other points has been covered, but the main reason I am here today to say is emotional connection with this industry, myself as a small business owner. You guys have done a phenomenal job for keeping us in business. This is my 24th year in this industry. So thank you to all of you who have supported us to stay in this business and live the American dream of making our family live in this country with a nice fashion, giving a good education to our kids. And we have successfully been done that by putting so many hours into these stores to make sure this regulated industry is controlled properly according to the regulations required. We do make sure that our customers are also given some knowledge about the products when they're there to shop. We directly communicate with the customers. We are here ourselves to oppose the bills when needed to make sure that our livelihood or the savings has been protected. So I appreciate that, whatever you have done, and that has made the state of Maryland a great state because of the small business friendly environment. A lot of people from the different states like to move here because of this atmosphere. The other thing which was communicated early about the coffee shop, I would not compare because that was a non-alcoholic product. This is a regulated industry, and we take care a lot of different ways, like sponsoring the local community events, as well as we make sure the following of the liquor board rules and regulations are definitely done by everybody. If you look into that industry, a lot of other big boxes have also put the small businesses out of industry, like Home Depot, Lowe's, and many more. Another comment I heard earlier about people traveling out of state, I'll just take 10 more seconds. Traveling out of state to shop, I would rather advise them to stay local, shop local, keep profit and taxes in Maryland, and make the state great again, and state great. So thank you very much.
Madam Chair, Madam Vice Chair, members of the committee, Jack Milani. I am the legislative co-chair, also own Monahan's Pub in Woodlawn. I threw my testimony out, and I'm just going to respond to some of the things that were said here today. Just for the record, Colorado governor brokered a deal in 2016 which brought full-strength beer to Colorado in 2019. That was the deal they made. They also made a deal that grocery stores with pharmacies could get beer, wine, and liquor if they purchase 2 licenses. All right, there was 36 of those that happened over the years. They added wine in 2023. They did not come to their legislature because they had made that deal that all they were going to take was beer. They went to referendum and they spent about $33 million and they won by 1%. So beer was added in 2023. And as Mr. Wise said, in 2025, the legislature overwhelmingly stopped the beer, wine, and liquor and ceased it. It's dead. Can't do it anymore. So just if we're going to talk about it, let's get the facts right. The other thing I want to talk to you about is on these studies. And Delegate Aarons, I got a kick out of you talking about your figures, her figures, because in our industry, they take the figures from the Class A. As many of you are aware, Ms. Fishpaw has a D. They don't get reported in the Class A's. I have a D in Baltimore County. I do both on and off. Those figures aren't part of any of the studies because when we report them to the IRS, we don't break them down on and off. So all these studies are great, except unless you know the industry, they don't mean anything. All right, the other thing I'm going to tell you is, and I've said this in the past, Maryland was set up for Maryland residents to control the retail. Our kids all go to school together, our customers, we know the kids, we know the families. It's not broken. I'm not apologizing for it. We're fixing something that's not broke, okay? I know the young ones want convenience, and it's most of the young ones, but, you know, most of our guys can deliver to you in their own counties. Can't get any more convenient. Thank you.
Thank you. We'll start with Delegate Pruski and then Delegate Amprey.
Thank you, Madam Chair. I'll just be really brief. Certainly appreciate this panel and the testimony. I think I'm going to go to you, Steve, because I know Kim kind of mentioned it, but it looks like the consequences of this would be streamlining that you would lose leases of sites. There'd be properties that are gone. So my 2 questions, and Kim kind of assessed this, and I've seen this as well versus some of the corporate chains versus local businesses. How much local nonprofits, I know that was mentioned, would lose out on money, number 1. And number 2, what would be the property loss, tax loss? So say, for instance, I represent Anne Arundel County, those stores closed, those leases are gone, then you just have grocery stores. Has there been an analysis on that as well? I know we're talking about the business itself, but what about the property taxes? Because as you know, I served on a county council, that commercial property taxes certainly get more, and certainly in a grocery store if they only have what they have. So I'm just curious, has there been any analysis on that?
I don't know that we've done any. I could say that, you know, the scenario I think you should have in your mind is the supermarket that's there and the liquor store that's next door. So to your example, the liquor store, let's be honest, is going to go away. It might take a little while. It's going to go away. The supermarket tenant is already paying those taxes, but you've lost, you know, the smaller tenant, which, you know, big deal, right? 1 location, but multiply that across your counties and across 1,700 to 2,000 local businesses. I think it's a significant impact. And with that, you know, you're losing not just those property taxes, but the wages that were paid there to Maryland residents, right? We're not talking about Albertsons or anybody located out of state. We're talking about Maryland wages and other Maryland taxes that I like to think now are staying in the state and would not be in a different market.
Thank you.
Thank you, Madam Chair. No, my question is more so for Mr. Wise and the young lady from the University of Maryland. Just wanted, I know our Chair Wilson mentioned last year, and one of the things that, you know, I care deeply about, and again, I appreciate all the testimony thus far, is just on the public health piece, trying to understand. You mentioned the public health piece around people who suffer from addiction and the exposure, et cetera. But I'm trying to understand, where do you stand on the public health piece of, you know, I know we mentioned communities where there's a grocery store and there is a store and there's a grocery store and there's a liquor store next door. That's in certain communities. And I represent West Baltimore. I live in a food, my community is a food desert. And the reality is I have a significantly high density of liquor stores. And based on data, public health data, the high density of liquor stores, there's crime that happens, more crime happens next to those liquor stores. Just want to get an idea on the public health piece that you mentioned. Where is the public health piece on that part of the issue that we have with the proliferation of the high density? Again, not saying it's everywhere in the state, because in many parts of our state, we have, again, the grocery store right next to the local beer and wine store. But I'm thinking about the situations of the places I described earlier where you have to buzz in 2 times to get into the liquor store. You're talking through bulletproof glass because the proliferation of the stores there creates a public health issue. And I'm sure you probably know the data on this public health issue. Just want to get your understanding on there. How would you address that? And would you say that this is an opportunity if it's in grocery stores, doesn't that create a better public health situation? Just want to get your thoughts on that.
Sure. I mean, the short answer to the last part of the question is no, it doesn't make a better situation to allow alcohol to be sold at even more places, right? So that just, I think, is a common sense response there. But with respect, I feel for communities. It is tragic that there are communities where you can far more readily purchase alcohol than you can fresh fruits and vegetables. And I have worked on food desert work, food access, food security, many times. You've considered bills that were designed to tie building or reducing food deserts by allowing grocery stores to sell alcohol, and I oppose those bills because we don't trade public health problems. We don't fix a public health problem of food security, of food access, by allowing more rampant alcohol sales. That's not, there are other ways we can incentivize fresh fruits and vegetables. And to be clear, I am not a public safety expert, but there are other things that need to be done in communities, and it's not just in Baltimore City. I know sometimes it feels like people think that, but it's not. There are places in our communities where we have to come to grips with the fact that we have allowed the proliferation of alcohol outlets that are not safe places. That is not the people in this room. But there are places that are not safe places, and it does contribute to community violence. It contributes, there's an association between alcohol retail density and automobile vehicle crashes caused by drunk driving. So there's a serious public health problem there. We don't solve that by allowing alcohol to be sold in more places, and particularly in places where young people are more likely to be prevalent. The folks here who sell alcohol, it's weird to them when a kid comes in, and they immediately look at that person, you're probably not old enough to be in here. And I think kids are afraid to go into those places. They're not afraid to go into the grocery store, and they're gonna be far more likely to try to buy in a place where their presence, whether it's a Royal Farms or a Wegmans, doesn't seem out of place. And so I just don't think we can marry these two problems together and say, public health should support expanding access to alcohol.
Thank you for that, and we can talk more offline about some of the pieces where we
always
agree and
available.
disagree. And I always say I do think public safety is a public health issue. So
it is.
Yeah, from gun violence is all that is tied to public health. So I do want to get that on the record. Mr. White, I know Delegate Wilson last year, asked, what are we doing, with people you represent to making sure that we're trying to clean up the issues that we presented last year around the issue that I've stated around the issues of some of these stores. Again, not all of them. It's some where it's creating public safety issues, and I guess it's more of a what can we do to fix that problem? And maybe it's an offline conversation, but it is something that I know that we discussed last year in the bill hearing is an issue that as to why some people are in support of these kind of measures. But it's something we can talk about. I don't necessarily, if you want to answer it, but
I know where your office is. I'll come see you.
Madam Chair, as a policymaker, we should definitely balance economic convenience with the potential public health implication. And I have a question. Have any long-term health cost questions? Since I come from a health committee, have any studies evaluated whether increased alcohol availability in retail environment leads to higher long-term public health cost, such as emergency care, addiction treatment, or DUI incident? Do we have any empirical data done?
So, sorry. Thank you for the question. There's a lot of data connecting things like retail outlet density, alcohol retail outlet density, and community violence, like Delegate Ampry was mentioning, with underage access. Excessive drinking, and I know there's data also about, like I said, automobile crashes. There's probably more data that I could pull, and so if I could, I'd love to have frankly, one of my law students, spend a little time pulling the best sources for you. We do have our colleagues at Johns Hopkins who do a lot of work in this space, and so that would be my first tap in to get you kind of just maybe some bullet points with the best data sources. But to be sure, there is a correlation between retail alcohol, density and negative public health outcomes that you all know cost at the end of the day to the state.
Thank you.
Thank you.
Thank you. Seeing no further questions, thank you very much.
Thank you.
From this panel, I'm now calling on Nick Manis, Brad Rifkin, Jenny Anoop Zalavadia.
Thank you, Madam Chairman, members of the committee. My name's Nick Manis, and I'm here representing the Maryland Beer Wholesalers Association. First, I'd like to thank Delegate Amphrey for having continued conversations on this bill this year, last year, the year before that. And also Delegate She had the bill in 1 year, I think, and hopefully we'll have the same conversation next year. With that, we represent 22 family-owned businesses that cover the state of Maryland. We distribute all the products, alcohol products. It's the manufacturer goes to the distributor, and then we hit all the retailers. We do Maryland breweries, small wineries, and large domestic suppliers. We support our locally owned independent retailers. They, along with us, support local communities, nonprofits. They provide a personalized service. They stock a wide variety of assortment of products, and they make their decisions independently, not through a corporate office. If I know your communities, if you want to go in there and get a check for your daughter's lacrosse team, your son's soccer team, 9 times out of 10, you'll get a check right there. You won't have to go to ask a corporate office somewhere outside of the state for those monies. For us at a wholesale level, an increase in stores does not mean an increase in business. Volume is just redistributed among stores. The number of deliveries increase, yet the number of cases delivery decreases. It's really good to hear that beer is so popular and is going to bring grocery stores here. It's going to help the pharmacies that are closing stay in business. Unfortunately, that's not the case. Last year was one of the toughest years ever. Matter of fact, it was the worst decline in U.S. beer history, the second U.S. Decline in U.S. Beer history since Prohibition. So the industry is not thriving. And with that, we ask you to oppose this bill. Thank you, Madam Chair.
Madam Chair, Madam Vice Chair, members of the committee, for the record, Brad Rifkin on behalf of Maryland's breweries, wineries, and distilleries, all the small businesses across your districts here in the state. Here, aligned with the other 2 tiers, I would say this committee is well aware that that's rare, that all 3 tiers are aligned on a bill. But we're aligned because the folks behind me view this bill as an existential threat to their business. And these folks sell my clients seasonal brands, their specialty brands. The smallest of my members are carried in the stores behind me and across the state. So if we lose sales channels, we are not able to grow the brands that Delegate Rose, you care about, and everyone else here cares about. The practical reality is that grocery stores are not going to carry the vast majority of my members. My members don't produce as much as the macro brands. While we loved the opportunity to be carried in grocery stores, we know that's not going to be the case for the majority of folks. And some might be carried, but most won't. There's also a pricing reality in this bill. If you pass this bill, you're allowing macro brands, the producers out of state, these conglomerates, to negotiate with large retailers and drive the price down for macro products. It wedges my clients out of the market. My clients, I heard about thin margins for CVS and other retailers. My clients are on the thinnest of margins. They're closing left and right. Whether it was Brewer's Art in Baltimore City recently, which is one of my favorite breweries, or Idiom in Frederick, that price wedge moves us out of the market. And some might say, oh, well, driving the price down is a good thing for the consumer. What I'd say is, and I've heard it on multiple bills in this committee and throughout the General Assembly over my years down here, driving the price down and having more accessibility, really, really cheap alcohol, accessible alcohol is not in line with the three-tier system. For those reasons, we oppose the bill. Thank you.
Madam Chair and members of the committee, my name is Anoop Salavadia, and I'm the owner of Best Wine and Spirits in Cambridge, Maryland, Dorchester County. I'm starting to learn that in Annapolis, some traditions come back every year, and apparently this bill is one of them. Many years ago, my parents invested their life savings into a small liquor store. There was no safety net, just long hours, risk, in the hope that their hard work would mean something one day. They worked 7 days a week, holidays, late nights, early mornings, and slowly, they built something, not just a business, but a place in the community. Today, I have that privilege of continuing what they started. Our store supports local charities, first responders, and community events throughout Cambridge. And like many independent retailers across Maryland, our success is deeply tied to the community we serve. When there's a fundraiser or a community event in Cambridge, there's a good chance Best Wine and Spirits' name is behind that. House Bill 1303 threatens businesses like mine. Large national chains have resources and buying power that small family-owned stores simply cannot compete with. When alcohol becomes just another product in a national retail strategy, it puts decades of family work at risk. House Bill 1303 is called the Alcohol Beverages Modernization Act of 2026. Modernization should not come at the risk of small independent retailers across Maryland. Modernization should strengthen the businesses that already exist in the communities, the ones that hire locally, give locally, and answer the phone when somebody from the community calls. For many of us, this isn't just a store, it's our family's life's work. For my parents, this store was their American dream. For me, it's the responsibility of protecting what they built. And while some traditions may come back every year in Annapolis, I hope this bill doesn't become one of them. And Madam Chair, if you allow me, I would like to acknowledge the men and women that are sitting behind me and in the hallways who are here in opposition of this bill. If you allow me, I would like to, for them to stand and acknowledge themselves. Madam Chair and the members of the committee, thank you for your time.
Good afternoon, Madam Chair and members of the committee. Thank you for another opportunity to speak today. Delegate Ampry, thank you again for your compliments of our store. It's nice to see you today. Thank you. My name is Jed Jenny, here representing the wine stores in Baltimore City in opposition of your bill, 1303. I began working at the wine source over 20 years ago as a craft beer enthusiast and quickly fell in love with the entire industry. I've taken great pride in being part of such an ambitious, community-focused small business. In October of 2024, as the original owner was retiring, myself and 8 other longtime employees were able to secure a loan and transition the company into an employee-owned cooperative. Last year at this time, we were juggling so much, and the timing of a similar bill was almost comically bad. The idea we could be crushed without even getting started. This year, with a much better grasp of our financial picture, I can say with certainty that House Bill 1303 would be an absolute disaster for the success of our young business and our 40-plus employees in the 40th district, by the way. While grateful for the opportunity to acquire the business, we were not given a sweetheart insider deal, but rather matched the multi-million-dollar price tag the open market demanded. While we're off to a good start, we have a very long way to go on the loan repayment, and we do not have the option of dramatically downsizing. Our store is located just a few blocks from not one, but 2 supermarkets, both of which are already thriving and certainly do not need additional alcohol sales. There are dozens of, there are another dozen grocery stores within a 2-mile radius and dozens of convenience stores. I cannot understand how or why it would be deemed reasonable or fair to take sales from small businesses and gift those to giant out-of-state corporations. The narrative that Maryland's current system is antiquated and limits consumer choice is simply not accurate. It's a script straight from the grocery lobbyist playbook. Maryland's current structure has created one of the strongest independent markets in the country with far more access to unique beer, wine, and spirits from around the world. We regularly have customers visiting from chain grocery states who comment, "I wish I had something like this where I live." And they are driving in from these other neighboring states, actually. Independent retailers like us curate diverse selections with far more customer choice by supporting the smaller and mid-sized importers, distributors, and producers and brewers. Grocery store sales kill this entire ecosystem as they prefer just a handful of giant
If you could
distributors.
summarize, that would be
Yes,
great.
thank you. Thank you. Please continue to embrace and support Maryland's amazing small business community by rejecting this bill. Thank you.
Thank you. Delegate Adams?
Sure. And so, Nick, you were saying at the end about the economy and what's going on in the industry, and I think it's important to just let you finish your thought on that, because what I was saying earlier is I'm talking to some of my business owners in the industry, and there's definitely a challenging economic environment. I think it's worth letting you finish your statement on that, because I believe this kind of bill coming in at this time is probably not a good bill anytime, but certainly at this particular moment, the messaging seems off to me.
Sure. So we would love beer sales to be going in the opposite direction, but they're not. There's a lot of competition out there. The younger of age drinkers aren't drinking alcohol that much anymore. They're energy drinks. Some of them are now drinking the cannabis infused THC drinks, and a lot of them are just not drinking at all. So that's a big factor. Maryland also is 48th in per capita consumption. So it's not like we can have more outlets and you're going to get more alcohol sales. They have to come from somewhere. And so the market's not good. It's not good for the wholesaler, and it's definitely not good for the retailers right now. So I don't know why we would be increasing outlets, especially outlets not owned by Marylanders, right? Not creating more jobs at this time.
Right. And Brad, you brought up the alliance of the 3 different tiers, which my 12 years in office, my first probably week in being in that seat over there was a review of what the 3-tiered system is. And so I say that because I want to just reinforce the point and just share that when I view that system, we view it as fairness, we view it as equity in a lot of different respects. But I always looked at it through the lens of how do we not allow the person with the biggest pockets control the entire industry. And so don't you agree that what we're here today to do is to make sure that we're allowing that 3-tiered system to work as intended, which is to help make sure small businesses who have a passion for entrepreneurship are able to continue operating in a very controlled environment. Let's not lie about it. Alcohol is a heavily regulated industry. There's a reason why after Prohibition we wanted to make sure that the industry was able to stand up and help small businesses. We're here today many, many years later, but I'm happy to hear your testimony and just thought you'd want to get some feedback from that point. But I like the idea that the 3 tiers seem to be an alliance on this particular opposition.
I agree. Yeah.
Dorchester County, I represent you.
Yes.
Now, Delegate, a point of personal privilege. Thank you for coming. Let me just say, as a business owner myself, it's hard to take time out of your day to come up to Annapolis and do what you're doing. It happens fairly rarely, but to have everybody here in this particular setting, thank you for taking time out of your day as a business owner to represent your interests here in Annapolis. We thank you for that.
Appreciate it, Delegate Adams. Thank you.
Seeing no further questions, thank you very much, all of you, for your testimony. I'm now calling on Jimmy Spiropoulos, Julianne Sullivan, and Jaskinder Gill.
Good afternoon, Madam Chair, Vice Chair, members of the committee. My name is Jim Spiropoulos. My family has owned Town Center Market in Riverdale Park in Prince George's County since 1988. We have grown from a small corner store of 3 employees to over 18. All our employees have access to our health care plan. We also have a profit-sharing plan where last year, every eligible employee received 25% of their previous year's salary into a retirement account, something that we're very, very proud of. We offer online ordering, curbside pickup, and home delivery. So I think we pretty much have the convenience part of things covered in our area at least. We're not a minimum wage employer where our lowest payroll employee is over $20 an hour. The rest of my testimony would just be repetitive, and I don't want to do that to all of you. But a couple things that I would like to touch on. I would say that the concern about the bulletproof stores. I have a Whole Foods, a Giant, and a Safeway all within 1.5 miles of my store. I can assure you that I will not be competing with, they will not be competing with the bulletproof store down the street. They will be competing for my customers. And I've said it before, you know, clearly there will be losses. And unlike many of my other peers back here, I'm not going to stick around just to get by. And the state would be losing a very good businessman and family that has invested their entire lives doing what we do and providing the services that we do that we do provide. So just think about that, eliminating Town Center Market, going to Whole Foods, yet the bulletproof still exists down the road. The other thing I would like to touch on is my store brought in $2 million in lottery revenue last year. Many of my peers back here are big-time lottery agents. Where's that money going to be made up? I go in a grocery store, good luck finding a lottery machine. In mine, it's front and center. Thank you.
Good afternoon, Madam Chair, Vice Chair, and committee members. My name is Jaskinder Gill. I own a store in Prince George County last 16 years. I came to this country in 1985, so it's been 41 years. In 41 years, I worked for Pizza Hut 25 years and earn all those my stocks, options, bonuses, work hard over there, earn everything, and invested to open one small business place in Prince George County. So my dream was one day when I retire, so I can maybe sell or pass on to my kids so they can enjoy the rest of their life. But if this has happened, I'm 64-year-old this year, and next year I'll be 65. If this bill passes, so it will destroy my dream, all those 41 years I've been building on it. So I want to mention a couple other things. As you know, the sale is even last year is over 20% is less than in 2024. The reason is, as all we know, the 2.2 million people voluntarily left this country last year, and 685,000 people, they got deported. So all those customers are gone, plus there is other things like we are very close to the line or the DC line. There is a lot of people, they lost 250,000 people, they lost their jobs. So all this revenue and other issues we have, I don't know if this has happened, the grocery stores, where are we going to be standing? Maybe our sale going to be less than maybe 30% less than compared to previous years. So thank you very much for giving me a chance to explain this, and thank you very much.
Hello, my name is Julianne Sullivan, and I'm a Maryland resident and fourth-generation small business owner of Bella's Liquors here in Annapolis. I am here speaking in support of locally owned family businesses and in opposition of House Bill 1303. Every year, legislation is introduced in support of allowing billion-dollar chain stores to sell alcohol under the guise of assisting underserved communities. It's presented as Maryland needs to come in line with all other states that allow the sale of beer and wine in grocery and chain stores for convenience. It's to assist underserved communities or address food deserts, when in reality, all it does is send our tax dollars to out-of-state billion-dollar corporations, make alcohol more accessible and more convenient to underage people, reduce employment, and hurt locally owned small businesses. Allowing a chain store to sell beer and wine will not enrich the lives of Marylanders. They will not employ additional Marylanders. They will not hire a general manager, night manager, or assistant manager, as all these positions are already filled in their current business model. They will not support the local distributors in Maryland. They will focus on the big national brands and use their buying power to hurt and shut out many smaller stores. The majority of the savings they receive from their bulk buying power will not be passed on to the consumer, but rather used to increase their profit margins. They continue to state the only way for them to make a profit is to be able to sell beer and wine. However, we all know this to be false as a quick Google of any of the major companies and see their owners, CEOs, executives' pay scales, bonuses, and stock incentives are far greater than anything I or any of my fellow local owners could ever dream of achieving. I can tell you I have 5 years left on the loan for my store. I have a mortgage on my home. Profits I make are paid out to my employees, reinvested in my store and into our community. Speaking for my business, I employ 11 to 14 employees depending on the season. I'm lucky to say that most of my employees have been with our family business for 10 or more years. I offer them all PTO, insurance, a simple IRA, holiday pay, and bonus potential. My employees are why my customers come and support my business. Instead of focusing on Maryland being one of only a few states that do not allow the sale of beer and wine in big chain stores as a negative, we should celebrate Maryland being one of the few putting small family businesses above big billion-dollar corporations. I would also just like to add, we should also think for the grocery stores, they should look at selling all of the non-alcoholic beverages. That has been a huge growth market in my store and a lot of other stores. And they can sell non-alcoholic beer, wine, and RTDs, and maybe that will help them. But taking beer and wine out of our stores is not the solution. Thank you.
Thank you. Mr. Spropoulos, I've been to your venue. It's a great venue. If each of you could just share with the committee how much you've spent up to this day in your family business, that would be great.
So hard to pin it exactly as you know, we've been around so long. The initial purchase was back in 1988 by my 87-year-old father, who's
Around about, because you've shared it before.
$1.2 million on the build out of the store and $1.25 million on the building.
I bought a store in 2007, $1.2 million. And that's the reason I put all my stock options, my bonuses, my savings, even I mortgaged my home those days. So, and this is what the cost was,
I've put in probably close to just over $1 million in the last 5 years.
Thank you. Thank you very much. I don't see any additional questions for your panel. Thank you very much for testifying before us. I have a couple more unfavorables. Jonathan Garlington, Srinivas Pemaraju,
Good afternoon, Madam Chair and members of the committee. Can I just start off by saying I agree to everything that everybody said and in my testimony, because everybody said everything that I wanted to say. But however, my name is Srini Pemaraju, and I own Magathi Wine and Spirits in Anne Arundel County. I am not just a license holder. I am a husband, a father, an employer, and a small business owner who poured his life savings, sweat, and faith into building a neighborhood liquor store in Maryland. I stand before you today on my own behalf and on behalf of Asian American Retailers Association of Maryland, representing hundreds of independent family-owned retailers across this state in strong opposition to HB 1303. And most of those members are already in this room, ma'am. When my family invested in our liquor store, we did it with faith. Faith in Maryland laws, faith in the stability of the system, and faith that if we worked hard, treated customers with respect, and followed every rule, we could build something lasting. This store is not just a business to me. It is my livelihood. It is my family and children's security. HB 1303 shakes that foundation. If large grocery chains and national retailers begin selling beer and wine, stores like mine and hundreds more could lose more than 50% of their revenue. And to the point, my store sells almost 70% of my sales come from beer and wine. So no small business can survive losing more than half of its revenue. We don't have corporate backing. We don't have shareholders to absorb losses. We have mortgages, payrolls, and families depending on us. This bill says these new licenses are presumed to be in the best interest of the community. With respect, I ask you, how is it the best interest of our communities to replace local family-owned stores with large corporations that can undercut us until we disappear? Well, lastly, I'm going to end by saying Mahatma Gandhi once said, the true measure of any society can be found in how it treats its most vulnerable members. I humbly ask you to think of the small store owners across Maryland, the families who followed the rules and built their lives around this system. I respectfully ask you to give HB 1303 an unfavorable report. Thank you for your time and for considering the human impact behind this bill. Thank you, ma'am.
Thank you. We have a virtual for unfavorable, Angela Rose. Go ahead, Ms. Rose.
Hi, good afternoon. My name is Angela Rose, and I'm the president and CEO of the Harford County Chamber of Commerce. I appreciate your time today, and I know that you've heard quite a few opponents of this bill. I echo a lot of the comments that were made this afternoon. We have several small owner-operator liquor stores in Harford County. One of my friends is a grocery store owner, but also has a liquor store. And a lot of the points that made today, I just want to echo with the fact that this will hurt the local owner operators. And there was a comment made earlier about small margins for grocery stores. Obviously, grocery stores are on small margins. I think a lot of businesses are. And that is no different from our beer, wine, and liquor operators. So with those facts and the fact that this is, in my opinion, an unnecessary bill, as people are already fashioned in a way to go to a liquor store for beer and wine, it's unnecessary, and I hope that this committee votes unfavorable for this bill. Thank you.
Thank you. Mr. Garlington, I apologize. I was on a roll here.
No worries.
So,
I know you got a long day and had a long day yesterday, so I appreciate
yesterday
it.
was almost 9 hours.
Madam Chair and members of the Economic Matters Committee, thank you for the opportunity to testify. My name is Jonathan Garlington, and I'm a Maryland business owner. I'm the majority owner and executive director of Alacrity Hub, which is a credit card processing company. In fact, we processed over $250 million last year for hundreds of fellow Maryland businesses. And I'm here on behalf of my company and those merchants. I'm respectfully asking for an unfavorable report on House Bill 1303 because I believe it will cause real, immediate economic harm, especially to independent package stores and local businesses that depend on them. HB 1303, it's no small tweak. It opens pathways. I mean, let's be honest, it opens a pathway for large retail establishments, including qualifying food retailers, pharmacies, and fuel stations to obtain Class A beer privileges. And that practice shifts sales into high-volume corporate channels. The state's own physical note flags this. It says the bill does not materially affect state finances, which I would argue, but the small business impact is meaningful. And it explicitly says some currently licensed small businesses are likely to lose business if grocery stores begin selling alcohol. That sentence is why I'm here. Because some includes my clients, my neighbors, and vendors who keep Main Street running. Research summarized by the Institute for Local Self-Reliance reports that locally owned retailers return a far higher share of revenue to the local economy chain versus retailers. 52% of the money is retained in the local economy with local independently owned retailers versus 14% by national chains, and specifically identifies mechanisms directly related to my testimony. Independent businesses spend more on local labor, procure locally, rely much more heavily on, 1 second, I'll summarize it up, but more importantly, I'm going to go with the testimony. More importantly, it's not just these independent small businesses that we're talking about, okay? It's companies like mine, financial technology company, the local HVAC guy, the local attorney, the local accountant, the local plumber, the local advertising agency, okay? None of us are ever going to have the opportunity to earn businesses from national chains who procured those accounts nationally and regionally. It's not just one business, it's the entire local business ecosystem that will be affected. Thank you for your time. And I will add one thing. I have real data here from my clients in Colorado that I've processed for. These are not statistics. These are numbers that I can share and have access to a lot of very interesting financial data and what consumers are spending and where. And I'd be happy to share that offline.
Thank you. You can send it to
point.
Delegate Ampry.
I will do. Because of the four liquor stores that I processed for in Colorado as of 2023, only one of them is in business still.
Okay, thank you. We have a question from Delegate Ahrens.
Just briefly, could you share that with us somehow, send it to the committee?
You just send it to the Economic Matters Committee, the email on the site?
Yeah.
I'd be happy to.
Yeah, any one of us will get it to us.
I have to redact client data, but I'd be happy to do that. I can send you the numbers.
Okay, thank you.
I see no further questions. Thank you very much for your testimony,
Thank you.
gentlemen.
You're done.
And last but not least, Bruce Bariano. Here's Brucey.
And I have my flip phone. Thank you, Madam Chair, members of the committee. I'll be very brief. I really will. I personally have just, for so many years, felt so strongly about this issue. I really am just so frustrated and disappointed every time a bill goes in or the governor proposes beer and wine in liquor stores. I mean, in supermarkets. I mean, look at the people that are here. These are Marylanders. You're going to destroy these people if you pass this bill or anything there too. This really is the backbone of the state of Maryland. You're going to leave people behind. Leave it alone. Leave it alone. Right now, liquor stores deliver. If you're really that lazy to go to a liquor store, no, I'm serious. They'll deliver to you. So what's the question? I mean, and it just upsets me. That's why I wanted to testify, Madam Chair. This is so grossly wrong. These are hardworking, independent. I'm a self-employed person. I can appreciate them. It's their heart and their soul. Leave them alone. They're paying the taxes. They're serving the community. Just let it be. You have far more important things to do than to mess around with their lives. Thank you very much.
Okay. Wow. Okay. No questions? Okay, he left already. Seeing... Oh, my God, I'm delirious. Seeing there are no other witnesses, that concludes the bill hearings on House Bill 1303. Colleagues, we're going... Who'd clap? We're going to jump to House Bill 415. I'm just trying to keep them all together, and this will be the last alcohol bill, and then we'll move to cannabis with Delegate Ampry. So House Bill 415, I'll be the one to, it's not my bill, but it's a Prince George's delegation bill, but it's also a beer and wine and grocery in case you members want to listen to it. Whatever, okay. It has, I'll just, for the record, if everyone could just exit or keep the doors closed. This bill is in Prince George's County Law Enforcement Subcommittee. It has not been voted on. It has been heard. But because it's on our docket, I need to present it here in ECM. But it's another beer and wine grocery store bill, basically. So this bill would authorize the Prince George's County Board of License Commissioners to issue inside the Capital Beltway a Class A beer or Class A beer and wine license to an applicant for use in conjunction with or on the premises of a self-service retail establishment that is independently owned or part of a corporation operating a chain of retail establishments. I'll just leave it at that. And so we have those, I don't know if anyone here is from the council to present. Is Jabari Cooper here? Is that Jabari? Jabari Cooper? Okay. All right, so we'll move on to the unfavorables. Steve Wise, Nick Manis, and Jimmy Spropoulos.
Thank you, Madam Chair, members of the committee. Steve Wise on behalf of the Maryland State Licensed Beverage Association. You just heard a bill on this very issue, so I refer you back to our testimony on House Bill 1303. The only thing I will note to you on this bill is that it refers specifically to allowing a Class A store with self-service retail. So this is not even a normal supermarket bill. This is a self-checkout bill. So that's another reason to vote against it. Thank you very much.
Thank you, Madam Chairman. Nick Manis with the Maryland Beer Wholesalers Association. As Steve said, identical in most ways to the bill we just heard. You have my testimony from that bill. That goes to this bill also. We're in opposition.
Madam Chair, Vice Chair, members of the committee, Jimmy Sparopoulos, Town Center Market, Prince George's County. Again, refer to my testimony on House Bill 1303. Thank you for your time.
Thank you, and I'm sorry, Bruce, you're on this list too. Did you just want to repeat what you said on the last bill?
Yes.
Bruce?
Yes, he does.
Yes, he does.
Okay, yes. Thank you. You're. Is that always, or just when Okay, with that said, there are no other witnesses. That concludes the bill hearing on House Bill 415.
Thank you.
Colleagues will now go to House Bill 622. Is there someone here to present for the Maryland Cannabis? Oh. Is she here, or I'm going to skip to the next bill?
Yes.
Oh. House Bill 622.
Good afternoon, Chair Valderrama, Vice Chair Charkoudian, and members of the committee. For the record, my name is Tabitha Robinson. I serve as the Director of the Maryland Cannabis Administration. I'm joined here today by Selena Rowley and several other members of the MCA staff. MCA is favorable with amendments on the agency's departmental HB 622, cannabis licensees, micro-dispensary employees, and cannabis agent training. MCA is grateful to the chair for her leadership in sponsoring this departmental. First, on delivery, as of July 1st, 2026, only micro-dispensaries will be authorized to provide statewide cannabis delivery. However, only a limited number of micro-dispensaries are expected to be operational initially, and they may not have sufficient drivers or staffing to serve rural and low-density areas such as Harford County. To prevent gaps in medical patient access, MCA recommends amending statute to allow standard dispensaries to continue delivery in low market density areas, as determined by the administration using seed-to-sale data for a defined transition period. This targeted approach protects patients without undermining microdispensaries as they come online. Amendment language can be found in our written testimony. Second, as introduced, HB 622 increases the employee cap for microdispensaries from 10 to 20. With only 10 micro licenses authorized statewide, the current cap would severely limit delivery capacity, compliance, staffing, and customer service. Increasing the cap ensures these small businesses can meet demand, maintain security and inventory controls, and reduce the risk that consumers turn to the illicit market. Finally, the bill modernizes responsible vendor training by replacing it with cannabis agent training and allowing MCA to tailor training requirements by license type. Current law requires all cannabis workers to complete a dispensary-focused training even when it is irrelevant to growers and processors. HB 622 allows MCA to implement license-specific, safety-focused training standards while maintaining strong public health and compliance protections. HB 622 is practical, forward-looking, and a measure that strengthens compliance, supports small businesses, and protects patient access. With the amendment, we respectfully request a favorable report. Thank you.
You're just here for questions?
Just here for questions.
Delegate Ahrens.
Just briefly, is there an appreciable difference between the cost of medical marijuana and regular marijuana from the dispensary?
I'm sorry, can you repeat the question, please?
Yeah, is there a difference between the cost of medical marijuana and marijuana from a dispensary?
Yes, there is, Delegate. The state imposes a 12% sales tax on adult use or recreational marijuana sold in dispensaries. Okay. Medical marijuana does not have that sales tax.
Okay, and the medical marijuana, is there does the insurance cover the delivery?
Does the insurance cover the
delivery
of medical marijuana?
Correct.
No, at this time, they do not.
Okay, thank you.
However, we are working on it.
Okay.
Seeing no further questions, thank you, Director.
Thank you.
I'm calling on Taylor Green, Ashley Bagwell, and birthday boy Joe Bryce.
No place I'd rather be, Madam Chair. I curse my parents every year that I was born during session. Here we are. I'm going to do an advanced Me Too, and I agree with everything Ashley is going to say. Joe Bryce on behalf of the Maryland Wholesale Cannabis Trade Association.
Madam Chair, I was going to do the same thing. Good afternoon, Madam Chair, Madam Vice Chair, and members of the committee. I'm Ashley Bagwell here this afternoon on behalf of the Maryland Dispensary Association in support of House Bill 622 with amendments. Training is incredibly important to dispensaries. It's how they effectively serve their patients, caregivers, and customers. Prior to the responsible vendor training requirement, dispensaries had their own internal training programs, really in-depth, robust programs, and often, or now rather, a lot of those dispensaries still supplement the responsible vendor training with their own in-house training. And so one thing we'd like for you to consider is to allow not just dispensaries, but all licensees who have their own in-house training that they use, allow them to get that approved by the MCA and have that serve as the responsible vendor training requirement. Secondly, we would respectfully request that this responsible vendor training only apply to plant touching employees. There are folks like accountants, HR people, IT people who don't work on the service floor and who will never touch a plant. And so we believe that the responsible vendor training shouldn't apply to them. Lastly, and I'm going to do an advance Me Too and say that we also support everything that Ms. Green will say. We appreciate moving from 10 to 20 employees for micro dispensaries, but using the same logic as the non-plant touching folks, HR people, owners, IT people shouldn't count towards that cap. And with that, Madam Chair, we would request a favorable vote with those amendments.
Good afternoon, Madam Chair and Madam Vice Chair and members of the committee. I'm Taylor Green, Vice President of the Maryland Coalition for Cannabis Equity. Thank you for the opportunity to share how these policies affect social equity operators in practice. We appreciate Delegate Ambry's leadership and ongoing engagement, as well as the continued support for regulators and partner offices working with social equity licensees. On HB 622, MCCE is favorable and supports increasing the cap to 20. Micro dispensaries already have a major micro limitation because we are a delivery only with no storefront. Over time, we would prefer that the storefront restriction be the primary limitator, as we already have similar expenses as a standard dispensary, but we recognize that the state may want time to test and refine this framework. Our technical ask is clarity and alignment. The law should cap 20 registered cannabis agents, not 20 employees, and it should only apply to cannabis touching and operational roles The training requirement should also use the same definition, so only those registered agents are covered. MTA has already provided helpful guidance that non-cannabis services like legal and accounting generally do not count as agents, while people who handle cannabis or work in operational areas are registered agents. We simply ask that this be codified for consistency statewide. However, I also just want to kind of piggyback on what Ashley said. HR roles, things like accountants, legal folks, they don't count, but in a micro dispensary's case, our dispatcher might count, who could be completely remote. Also, equity owners also count as well. With that in mind, we also respectfully request that the required cannabis agent training cadence be every 3 to 4 years rather than annually. This is because essentially this adds on additional costs for social equity licensees, and we also would be conducting our own internal training. With that in mind, we respectfully ask this committee to vote favorably on this bill and the amendments we requested today. Thank you.
Thank you. I don't see any questions for your panel. Thank you so much.
Thank you.
Thanks, Madam Chair.
And seeing there are no other witnesses, that concludes the bill hearing on House Bill 622. Is Delegate Young here? Nope. Okay. Since he's not here, we're going to jump to Delegate Ampry. House Bill 1519.
I thought I'd get some more time before my next bill, y'all. I'm sorry. All right, it's the last one. It's still daylight outside. Remember that. It's still daylight outside, all right? Remember that. When I started, it was still daylight outside. All right. Madam Chair, members of the committee, for the record, Delegate Ampry here in support of House Bill 1519, Cannabis Management, Service Agreements, Advertising and Penalties, Alterations, Cannabis Reform, and Opportunity Act. So I brought a bill last year around cannabis advertisement, and that's kind of where this whole entire thing started. If we look at the industry that we created here, I'm really proud of the work this committee did on creating a adult use ecosystem. I'm very proud of the social equity licenses that we were able to get out, and we really did a great job of doing it in a way that didn't run afoul of the Constitution or some of the changes that we've seen happening in Washington, D.C. With that said, I think that there also are some additional changes that we need to make on our laws to ensure that we have an ecosystem that is fair and equitable for our social equity license holders, number one, but also ensuring that we're thinking about, as we move to a world where we really don't know what's going to happen every day in Washington, D.C., we never know what's going to happen, but the reality is there's conversations around the rescheduling of cannabis. And the reality is we want to make sure that our business community in the cannabis space is ready to be successful on day one, whenever that switch flips and it happens. This bill, again, is a starting place for that to happen. I want to get in front of it and say that this bill, I'm not married to the bill as drafted. I've had conversations with people that you'll hear from later today. We've had some really good conversations over the past week and a half where I think there's a lot of places where we agree, some places where we disagree, but I think there's a lot of places where we can actually come together and figure out a way where we can make our cannabis system here a little bit more stronger. I'll walk through just high level, because I know the evening the hour is late. High level things of what we're trying to accomplish with this bill. Changing the definitions around control, adjusting some of the definitions so that it strengthens certain protections, strengthens social equity protections by clearly defining business control to prevent hidden ownership arrangements that could undermine equity licenses while still allowing legitimate investment and management support. The other thing that this bill attempts to try and establish is franchise opportunities in the cannabis space. I think there's a world where once that switch flips, there's going to be opportunities for people who own licenses to do the franchise model where they could be creating more opportunities for themselves. Again, this language, I'm not married to any of it. We can work it out with those you'll hear from later to figure out how we can make that work. But again, the goal with the franchise opportunities is to figure out a way where we can have social equity licenses get online a little bit faster. Because we've had social equity licenses that went out, but based on how many licenses went out and how many are up and running and operational, it's not where it should be, in my opinion. And some people are just really struggling because it's hard to get capital infused into this business. The other thing that this bill attempts to do is also shorten the moratorium. I think that we had a very paternalistic view on how we wanted to regulate this space. As a corporate attorney, you understand that when you have a business, creating an opportunity to either sell that business or a portion of that business is an important way for you to bring in capital, or if you feel like you want to have an exit route, it's an opportunity for you to walk away from the business. But the moratorium that we have in place makes it harder for our social equity licenses and other license holders to be able to be successful. So I think figuring out how we can shorten the moratorium or create different on and off ramps with the moratorium so that we have people getting online faster and more capital being infused. The last two things I'm going to quickly touch on because the hour is late is advertisement. So we understand that we want to make sure that kids are safe, right? We want to make sure that we're not advertising a substance that could possibly harm children. But the reality is, since we went to an adult use model, we pretty much got rid of any type of advertising. And what I've heard horror stories of women-owned businesses, black-owned cannabis stores that have tried to advertise that they are women-owned or that they are black-owned, and they got in trouble for saying that, right? So imagine a veteran-owned company not being able to say, I'm veteran-owned, to entice people to come to the store. So again, what this bill is asking is that we return back to the advertising laws that we previously had in place during the medical usage, where you could do some light advertising, and we put in certain rules and restrictions on distance requirements from schools and churches, and making sure that it's not too bright and colorful, or not making sure that it's not trying to entice children, but it's thoughtfully balanced in how we approach that. And the last thing that I'll talk about that this bill tries to address is some of the penalties. I think right now it's a $10,000 penalty. Forgive me if I'm wrong. It's $5,000. So we want to up it to 10. I've heard other people say let's do 15, let's do 20, because the reality is if we want to make sure, I think one thing that we did agree on with this committee is that we wanted to make sure that we got the illicit market out of the space. We want to make sure if you're buying cannabis in Maryland, that you're buying the product that's been tested, a product that you know is good, a product that you know is creating tax revenue for the state, et cetera. So we need to have some stronger penalties to ensure that those who are in the illicit business trying to sell it at smoke shops and so forth, that we are holding them accountable. So this bill would also strengthen some of those provisions. Again, there's more details in the bill that I would love to get into, but I don't want to spend too much more time talking to you all. You all have heard enough of my voice today. So with that said, I ask for a favorable report on House Bill 1519. I think that you'll hear from some of the other folks who are going to speak today. You hear some other ideas and plans that I think that we can work together. And in the coming weeks before crossover, I think we have a good bill that we can put forward in order to improve our cannabis system here in Maryland. And with that said, I'll ask for a favorable report. Thank you, Madam Chair.
Thank you. I don't see any questions for you, Delegate Ampry. We'll move on to Eric Ross, Wendy Bronfine, Jeff Jacobson, and Obi Chinamir. And Joe Bryce.
Good afternoon, Madam Chair and members of the committee. My name is Obi Chinamir on behalf of Curio Wellness. First, we want to thank the sponsor, Delegate Ampry, for his hard work on this bill for many years, or on this issue for many years. I agree with everything he said. Quite frankly, this industry, you guys did a lot of hard work on trying to make sure that the industry exists. We moved from the medical industry to the adult use industry. And as you've seen over the last couple of years, we're starting to modernize. People are coming online, and all we're asking for is to make sure that the statute continues to modernize as the industry modernizes as well. The proponents in there are good. We're looking forward to continue working with the delegate, with the MCA, with all the other advocates, including the social equity licenses, on making sure we come to a fair agreement. And lastly, I want to say that the most important piece of it is that while there is a market that exists here that is doing work, that is paying taxes and being engaged, there's also an illicit market that exists that is not following any of these rules right now. So our main goal is to make sure that we protect the people who are most vulnerable by making sure that the people who are engaged in the right way, but also respecting the idea that this is a Maryland business that people voted for and wanted to be engaged in. Thank you for your time.
Hi, my name is Jeff Jacobson. Thanks to the committee and the chair and everyone here for listening today. I am a founder of a dispensary in Baltimore called Storehouse, and I want to tell a little real-life story. In 2020, I met Quasi Johnson. I was introduced to him. He was one of the few minority first-round license winners for a dispensary in Prince George's County. And Quasi was, he's a great guy. He was working diligently. He was putting his heart and soul into the business, but the business was not doing well and it was failing. And we entered into a management agreement with Quasi at Jova Wellness Center. And my management team at the time, we had about 12 years of cannabis experience in Colorado and Maryland. And if not for us, Quasi would have been out of business. And we now have a great business in Prince George's County. We've blossomed the sales, and for someone like Quasi and even future social equity or even just regular licensees, and especially the social equity, it's very hard to raise money in this industry, especially under some of the constraints that they have. So what you'll see, people think this industry is a lottery ticket. You get a license, it's a lottery ticket. It's not, and it's a tough business. And what happens is people like Quasi go to friends and family, and they put their life savings into the business, and they get stuck. And without an off-ramp, why would we handcuff all the licensees? If someone's willing to enter a management agreement, if we didn't come and someone said, hey, Quasi, we'll give you a couple $1 million for your license, why would we take that away from him? And this bill allows that to happen. It's a free economy, allows people to exit their business or get a capital injection when they need it. I'm in huge support of this bill.
Madam Chair, Madam Vice Chair, committee members, my name is Eric Ross. I'm the Chief Financial Officer of District Cannabis, and I'm here in support of House Bill 1519. District is an independent cultivator in Hagerstown. We are locally owned. We are not part of a large national multi-state organization. My background is not in cannabis. My background is in capital raising in the capital markets. I spent more than 30 years helping clients as an investment banker raise debt and equity and investing as a principal into companies. I was brought into district in 2018 for my capital markets expertise. We had to raise almost $20 million to open up our grow facility. We support HB 1519 because it contains important provisions that will help the remaining 80+ social equity dispensary licenses of the 92 that were issued 2 years ago actually get open. Ensuring that these social equity licensees successfully open is in all of our interests, including the interests of independent cultivators like District that need to have more customers. It's my personal and professional opinion that the reason these licenses cannot get open is because how the capital markets and capital formation work. Debt lenders and equity investors protect their downside first, and they are not willing to take the risk to invest in inexperienced or undercapitalized operators. They need to have a level of control that will allow them to be willing to take the risk of investing. That's how the capital markets work, and that's where management service agreements come in. Prior to 2023, Maryland allowed for management agreements, and those management agreements allowed licensees who are often new to the industry and undercapitalized to partner with experienced investors and operators who brought the capital and the operating experience that the startup business needed. These agreements were voluntary. Nobody was forced into entering into a management services agreement. Also prior to 2023, a significant number of the original medical cannabis businesses were able to enter into management agreements that allowed them to get open and create generational wealth. I'm sure that will work again. Getting open is the first step in creating generational wealth that the assembly and vision establishing this program.
Thank you. Obi, are you here on behalf of Wendy? Because I called her.
Yes, I am.
Okay. I don't see any questions for your panel. Thank you very much for your testimony this afternoon. Now I'm calling on Joe Bryce, Ashley Bagwell, Taylor Green, Seth Murphy. I pick on Joe Bryce to speak first.
Uh-oh. Thank you, Madam Chairman, members of the committee. My name's Joe Bryce, Maryland Wholesale Cannabis Trade Association. I think we really want to focus on the issues of advertising, which we want clarity, we want to be compliant, we want to know what the rules are. And we think that the provisions in Delegate Amprey's bill help clarify that for the regulator and for the licensee. Right now, people are trying to build brands, trying to build their recognition in the community. People want events sponsored and they want to participate in the community, but don't want that to be seen as advertising in a bad way. So there's many other issues regarding, we certainly support targeting people over 21 who can use the product. And there are provisions in the bill that would make that easier for companies to do. So with that, I think we're happy to work with the committee, work with the sponsor, appreciate him bringing everybody together, and we'll leave further comments for then. Thank you.
Good afternoon, Madam Chair and members of the committee. I'm Ashley Bagwell with the Maryland Dispensary Association in support of House Bill 1519 with amendments. We have submitted written testimony that speak to a number of the issues in this bill. I just want to touch on a couple. Like Mr. Bryce said, I think it's important to speak to advertising. Maryland has some of the strictest cannabis advertising laws in the country. We do not believe that this bill in any way weakens those laws. As Joe said, I think what we are looking for is specificity and clarity in the law so that dispensaries can continue to do advertising on the limited basis that they've been doing it up to this point until within the last year. I think one of the best examples that illustrates why we think this bill is needed is what's happening with business signage, and Delegate Amprey, you spoke to this. Licensees are allowed to have signs, but the law says that that has to be for the limited use or limited purpose of identifying that business. So what that means is that you can't have a woman-owned business sign, you can't have a black-owned business sign. And as Delegate Amprey said, we have had a licensee fined for having a woman-owned business sign and was required to take that sign down. I also want to speak to the appealing to children language. I want to be very clear the Dispensary Association does not in any way support advertising to children. Again, what we're looking for is some clarity and specificity in the law such that there's more objective and less subjective language, because right now anything could be deemed appealing to children. At the end of last year, in fact, a number of licensees received official notice that they should not decorate for the holidays because that might be considered appealing to children and they would be fined. So again, as Joe said, I think we're looking for specificity and clarity so that folks know how to follow the law. Thank you.
Good afternoon, Madam Chair and members of the committee. I'm here again on behalf of the MCCE. My name is Taylor Green, and I'm representing the social equity licensees across Maryland. I want to thank you all again for your willingness to hear us. Even after we submit written testimony, we truly appreciate the opportunity to keep the conversation going. We especially want to recognize Delegate Amprey's leadership again, and we have continued dialogue with Delegate Amprey to find common ground on complex issues that affect social equity operators, such as hemp, advertisements, management agreements, and franchise agreements. We also appreciate the various offices' willingness to engage with this license class. We know there is a genuine desire for social equity licensees to grow, succeed, and operate compliantly. MCCE supports the purpose of HB 1519 and is favorable with amendments. From our perspective, this bill reflects a commitment to building a market where social equity licensees can actually compete, not just be licensed on paper. At the same time, we want to be candid about a real pressure point. Many social equity licensees are still trying to secure capitalization. When legitimate financing is hard to access, it creates spaces for arrangements that can be predatory in effect. In the last hearing, there was a discussion about small businesses against big businesses. That same logic should apply here to ensure that multi-state operators do not push us out of the market or take advantage of small businesses. That is why the guardrails in HB 1519 matter. We support clear, enforceable standards that prevent management agreements and franchise-like structures from becoming workarounds that shift economics and control away from social equity licensees before they have a fair opportunity to stabilize. Finally, MCCE wants to remain a collaborative partner, and we wish to continue to be looped in on policy and regulatory decisions as these frameworks evolve, and we appreciate the opportunity to do so. Last, I would like to just say our lobbyist, Tiffany Harvey, is engaging with members on this. Thank you.
Is that me now? Yep. Sorry. Good afternoon. My name is Seth Murphy. I'm actually the only licensed social equity HB2 cultivator in the state of Maryland. I have a prepared statement, but I'm going to stray from that a little bit. I'm here in support of the amendment with significant changes to the language. I do think it's interesting that there are a lot of people here speaking to my benefit that I've never met before. I love that the impetus is always around how to help HB2 and social equity when it comes from the very people who prevented us from getting into the marketplace in the first place. I think this bill needs substantial help, substantial change, and I would recommend that we examine the language around control, the time spent on the moratorium, and take a more effective approach to language that ensures this bill is equitable across all forms. Thank you.
Okay, seeing no questions for your panel, thank you very much for your testimony this evening.
Thank you.
Thank you.
We do have virtual favorable, Hope Wiseman.
Okay. Hello. Hi, everybody. Good evening, Madam Chair and Vice Chair and members of the committee. My name is Hope Wiseman. I'm the founder and operator of Marion, Maine, a dispensary in Prince George's County. I am also a part of a social equity team that is currently raising upwards of $10 million to build out a cultivation and processing facility. I'm testifying in support of House Bill 1519. Out of 192 conditional social equity licenses awarded, only 20 have become operational. That is a 10% success rate. And the number one reason is capital. Investors look at our current rules and they walk away. Right now, somebody could invest $1 million into a license, and if that licensee decides to take the build out in a completely different direction or spend the money in ways that they never agreed to, the investor has no current recourse. They can have a seat at the table, but they cannot have a meaningful voice in how their own capital is deployed, because under current law, any decision-making authority over operations, marketing, and finances is considered control. No serious investor will accept these terms, so that's why very few of them are writing any checks. I'm living this currently. I'm both raising money for a grow and processing operation, like I said, and I'm also investing my own money in this deal. Even with a strong operating business background and a willing partner, structuring a deal that works for both sides under the current framework has cost me over $100,000 in legal fees and months of negotiation, and I still do not have a result. The bill moves us in the right direction. Whether we get there by narrowing the definition of control or by expanding who can participate in it, what matters is that investors have enough participation in the decision-making to write checks, and that licensees still retain meaningful ownership of their businesses. I believe this committee, the sponsors, and the administration can find that balance, and I urge a favorable report. Thank you.
Thank you, Ms. Wiseman. Seeing no questions, thank you very much. Okay. Our next virtual is Venus Hemachandra.
Good evening, Madam Chair and members of the committee. My name is Venus Hemachandra, and I have been in the Maryland cannabis industry since 2017. I previously held a medical dispensary license. I am now in the process of opening a new social equity dispensary in Parkville, Baltimore County. I also serve as the president of the Maryland Dispensary Association. I'm here today in support of HB 1519 with amendments. In my written testimony, I outline our support for management service agreements and reducing the moratorium to restore reasonable flexibility to licensees while maintaining oversight. During my testimony today, I want to really focus on our strong support for defining therapeutic and medical claims. Members are being cited for standard effect-based language on age-gated websites, such as help promote stress relief, or effects may include relaxation, hunger, or happiness. Product descriptions should be allowed to include general effect-based information so that consumers can make informed choices. Clear definitions will ensure consistent enforcement while prohibiting improper medical claims. I also want to support proposed advertising changes. Dispensaries are effectively limited to a single exterior sign and are prohibited from using basic directional signage or pretty much wayfinding and open signs are not promotional advertisements. They're simply tools that allow adults and patients to locate licensed and regulated businesses. While we support management service agreements and franchising, we strongly oppose any language that would lift or weaken existing license caps, including proposals that exclude MSAs, franchising, or minority ownership interests from cap calculations. Such changes would accelerate consolidation and disproportionately benefit large operations at the expense of independent businesses. Maintaining license caps preserves competition, supports small operators, and protects Maryland market from excessive consolidation. With thoughtful amendments, this bill could provide clarity, fairness, and stability in the Maryland's cannabis industry, and I thank you for your time and consideration.
Thank you, Ms. Hemachandra. There's no questions for you. Thank you for your testimony this evening. We have one more virtual, Malcolm Gillian.
Hey, good evening, everyone. Madam Chair and members of the committee, my name is Malcolm Gillian. My sister and I are social equity licensees, and we hold a standard dispensary license in Anne Arundel County. Like many people entered this program, our vision was to create generational wealth for our family and economic opportunities for people in our community. I also happen to serve as the president of the Maryland Coalition for Cannabis Equity, but today I'm here speaking as a social equity licensee going through this process. I'm here to support HB 1519 with amendments and truly appreciate Delegate Amprey's willingness to engage with social equity operators on this bill. There are many provisions we absolutely support, including stronger enforcement against unlicensed intoxicating hemp sales, clear advertising standards, and greater clarity around management agreements. My comments today focus on ensuring as the market evolves, we do not unintentionally undermine ownership caps or disadvantage social equity operators. First, it's important that MCA retains authority to review all structured and related agreements, including management service agreements, franchise agreements, financing agreements, and any other related contracts to ensure they don't unintentionally or transfer control or circumvent the ownership caps. The caps only work if contractual structures cannot be used to bypass them. Second, timing matters, and right now we think timing is potentially misaligned. Many existing operators have been in this business for more than 3 years. And if the moratorium is shortened without addressing that gap, we believe social equity operators will be disadvantaged and not have the opportunity to stabilize operations and build enterprise value before that. Lastly, the social equity program was designed to create equitable ownership opportunities and pathways for long-term wealth creation. The market structure should continue to honor that commitment as the industry evolves. Thank you for your time.
See no questions, Mr. Gillen. Thank you for your testimony this evening. We'll now move on to the opposition, the unfavorables, Lynn Hatch and George Townsend. Okay, somebody begin.
Sorry. Good afternoon, Madam Chair and members of the committee. My name is Lynn Hatch, here today on behalf of the Public Health Law Clinic at the University of Maryland in opposition to House Bill 1519. This bill would weaken Maryland's public health protections by expanding outdoor cannabis advertising, narrowing safeguards against youth-targeted marketing, and permitting implicitly misleading therapeutic health claims. Research has consistently shown that adolescents exposed to cannabis advertising are more likely to use cannabis, intend to use cannabis, and perceive it as low risk. One study in particular found that youth exposed to cannabis advertising were 7 times more likely to use cannabis and 6 more times likely to exhibit symptoms of cannabis use disorder. Adolescent cannabis use is also associated with anxiety, depression, psychosis, impaired cognitive development, academic underperformance, increased delinquency, and increased risk of substance dependence in adulthood. While HB 1519 would provide a 500-foot buffer from designated areas such as schools and other youth-focused locations, children are not limited to existing only within these zones. And finally, this bill also removes protections against youth-targeted marketing, which would take Maryland out of alignment with 27 states that prohibit indirect or attractive advertising to minors. This bill also limits restrictions on therapeutic medical claims in that explicit does not include implicit or indirect marketing. And for these reasons, we respectfully urge an unfavorable report. Thank you.
Madam Chair, committee members, good evening. My name is George Townsend, and I'm an attorney at the Legal Resource Center for Public Health Policy. I'm here today to testify in opposition to House Bill 1519, and specifically the provisions relating to advertising, the removal of the restriction against publicly visible outdoor advertising, the removal of language prohibiting indirect targeting and appeal to underage individuals, and the narrowing of the definition of therapeutic and medical claims to apply only to explicitly stated claims. Maryland's cannabis law advertising laws reflect a balance between, on one hand, allowing adult consumers to learn about and access cannabis products, while on the other, protecting underage individuals from the harms of exposure to cannabis ads. As Ms. Hatch mentioned, these harms are not merely theoretical. Studies have shown that exposure to cannabis advertising during adolescence is linked to increased likelihood of underage use and the development of cannabis use disorder. Unlike other forms of advertising, publicly visible billboards, signs, and other outdoor ads are necessarily visible to the entire public, which, again, necessarily includes children. This bill does attempt to address this issue by creating 500-foot buffer zones around certain locations like schools, libraries, and parks. And this would be an adequate solution if children lived their entire lives within these narrowly circumscribed bubbles. They do not. I would point out that notably this list excludes the location where children spend the majority of their times, which is their homes. It also leaves out the streets and the sidewalks they use to move between these locations and any businesses they may visit while accompanying a parent who's running errands. I would also just like to quickly say that removal of language prohibiting the indirect targeting and appeal to underage individuals is also a concern for us, as we believe that language is important for putting the burden on the business to ensure their ads are directed at adults. For these reasons, we respectfully request an unfavorable report, and I'm happy to answer any questions you may have.
Thank you. Delegate Ampry?
I promise I'll be brief, Madam Chair, I promise. Thank you all for coming, and you're in law school, right, to the right?
Correct.
Okay, when I didn't come testify on bills when I was in law school, so that's pretty cool. So I just have a question. I guess for me, I understand your concerns, and your concerns are valid. However, I struggle with I think the way we define indirect and direct. That's where I struggle, right? Because what is indirect, right? So I think, and then how do it's hard for companies to figure out how to market to children or what's not marketing to children. So I'll give you an example. The Geico lizard, it's a cartoon. But we know, my 5-year-old is not buying insurance, right? That is targeted to an adult. So like, how would you separate like what's direct and what's indirect? Like, it's a very like gray line. And I think that, while we again, like I said, I'm not married to this language. It's not perfect. But we'd love to hear your thoughts on how do we do that? Because we do want to have businesses able to market that they have a legal tested substance. Because I want people buying legal tested substances, not the illicit stuff. And you can't know about it unless you can see that it's available somewhere where to buy it. So I want to get your thoughts on those two pieces. How do we walk that line carefully? Because I want to make sure that they can thrive, but I also want to make sure that we get people in the right doors, buying stuff legally, and getting those tax dollars that Maryland desperately needs.
Absolutely. I appreciate this question. And especially, I'm also grateful that you've sort of expressed willingness to work on some of the language in this bill. I do think regarding sort of what is considered to be targeting children, whether directly or indirectly, some of that is addressed through regulations. So the Maryland Cannabis Administration, I believe just in the last couple months, adopted sort of a more specific definition of how we define the word cartoon. So they specifically any sort of like a character that is given animal, like a human who's given animal characteristics or an animal that's given human characteristics. So it would potentially include the Geico lizard since that lizard walks and talks. I do think another important part of this language, though, is even though I think it does create a significant burden, but the potential harm in this case is significant. And it's significant enough that I think it justifies the burden. And specifically putting that burden on the business to ensure that they are the ones taking care to make sure their ads are directed at adults. And sort of taking also, I guess to use the word reasonable here, taking reasonable care to ensure that their ads are not harming underage individuals. Thank you.
Seeing no further questions, thank you very much for your testimony this evening. We have someone here in person for informational purposes. Is Selena Raleigh here? Madam Director. Okay.
I'm here for questions only.
Thank you again, Madam Chair, members of the committee. Tabitha Robinson, for the record, Director of the Maryland Cannabis Administration. The MCA respectfully submits a letter of information for HB 1519. Our role under the Cannabis Reform Act is to maintain a transparent, equitable, and well-regulated market. Maryland's adult use market is still within its infancy, and the timing of this bill deserves careful consideration. HB 1519 would authorize cannabis franchising. In other industries, franchise systems centralize control, create layered financial relationships, complicating ownership and transparency, and ultimately function as a tool of market consolidation. Cannabis franchising has not developed at scale in any other state in the country, and introducing franchising too early could jeopardize Maryland's long-term success. The core concern is social equity. Maryland's program was designed to ensure cannabis licensees, especially equity businesses, maintain independent decision-making authority over core operations. This bill does not include guardrails or protections to ensure these licensees retain meaningful independence. HB 1519 narrows the definition of control by carving out the right or authority to make financial, operational, and strategic decisions. MCA holds that the authority to make these decisions is indeed critical to control. The bill also edits the definition of management services agreements and alters compensation thresholds. These changes could shift economic benefit towards larger entities, potentially accelerating market consolidation in a still maturing market. MCA is not opposed to market evolution or improving capital access for operators. However, if the committee moves forward with this legislation, we respectfully recommend adding clear guardrails, mandatory disclosures, and preservation of advertising safeguards. We appreciate the committee's thoughtful consideration and the sponsors' partnership here, and we remain available for technical assistance.
Thank you. Seeing no questions for you ladies, thank you for your testimony this evening. Seeing no other witnesses, that concludes the bill hearing on House Bill 1519. We'll now move on to House Bill 1282. Delegate Young.
Madam Chair, I have two handouts, just some pictures. Would it be all right if I pass one around?
Sure.
Thank you. Julia. Julia. Penny. Is your name Julie? Oh, you look like Julie. No. All right, so what I handed to you all, first off, thank you, Madam Chair, Madam Vice Chair, members of ECM. This is my first time in ECM, I believe, in 4 years being in the House of Delegates, but I'm excited to be here and I think on some important legislation. What I passed to you all, you could just take a look. Don't take it out, but just take a look at them. I'm going to reference them over the next two bills. Madam Chair, can you just remind me? I didn't hear clearly. Which bill did you want me to start with?
1282.
Thank you. So House Bill 1282 has to do with, if you look at those packets, you'll see some pictures on the back side. And those pictures, you'll see a few establishments in my district where we have real concerns about advertising of tobacco as it pertains to children. Specifically, you'll see pictures where I have big marquee signs that say candy and tobacco or tobacco and candy that are prominent on Bel Air Road, one of which is 1 block from a middle school. There's another store that I went to earlier today right off of Bel Air Road in Frankfurt. It's called Jay's Snacks. When you go in Jay's Snacks, you don't see nothing but snacks till you look behind the register. Then you don't see nothing but tobacco. And it's right across the street from Gardenville Elementary School where I went to school. So that's the problem that I'm here to address today with this legislation. In 2019, Maryland did the right thing. We raised the minimum age for purchasing of tobacco products to 21. And the law sent a very clear message that we do not want our young people using tobacco. However, there's a significant gap that we have left in our law, and that's an enforcement gap. Now, the AG does do enforcement under what current federal law is in the master settlement agreement from the old big tobacco litigation that occurred. But what we have here today is an example, what I've given you two, in an atmosphere where there's just not real enforcement happening here in the state of Maryland. And frankly, with the proliferation, if you look at the map that has the little black dots on it, those are all of the tobacco stores in Baltimore City. What you'll find is that there are just short of 1,400 tobacco stores that have now opened in Baltimore City over the last few years. And so we have this challenge of our youth being groomed, in my opinion, where, again, candy is used to bring them in. And the previous litigation from that big tobacco, from those big tobacco settlements made very clear that sugary and sweet items are items that under the law would attract students, young people, to establishments. And that's why some of those laws made it so that way it was harder to advertise to them. So I want to be clear, though, I'm not trying to address 7-Elevens or Royal Farms or your general convenience stores that you see that really are good actors that are, they have, if you go in the store, it's a large market and there's all kinds of different things in there. I'm not attacking those folks. I'm not trying to address those. And there are concerns and folks who are going to oppose the bill who are going to reference that the bill as drafted might rope them in. I'm happy to talk to them. We have been in some conversation to try to right size and narrow what this bill says and does. But again, my goal is to make sure that that overt advertisement that clearly is geared towards bringing children into those establishments and that are positioned very close to our schools, that we address those establishments in a real way. So what the bill does is it talks about cartoons, superheroes, video game imagery and references, packaging image or imagery that mimics food products primarily intended for minors, celebrities and symbols primarily associated with youth audiences, images of individuals who appear to be young. There are some amendments that we're working on. The First Amendment would not just, the bill as drafted doesn't expressly use the word candy. I want the word candy under the law to be expressly defined as advertising to children. There is a constitutional concern about that, but I do believe that that commercial speech, we have a substantial government interest in regulating that commercial speech, and that is a narrow tailoring. By simply making that definition is a narrow tailoring that will pass constitutional muster. I'd like to also, with amendment, prohibit co-advertisement. So you see the candy and tobacco, I want to prohibit that expressly. Because a child is going to see the word candy and they're going to walk into the store. And then they're going to be exposed to the tobacco products. I want to clarify, and the amendments are forthcoming. We're actually workshopping it with the drafters. To clarify that a sign or billboard would include the signs on windows as well as the marquee. And then lastly, or one more, I said that the candy, I want to make sure to define the word candy. And then the last one is the bill as drafted references events and having ATCC to go to various events where it might be youth and to do some enforcement on advertisement at those events. It gets a little bit beyond the scope of what we're trying to do here. So we're going to remove those provisions from it. I've had a good conversation with them. That is the nexus of the fiscal note associated with the bill, is the requirements to do that enforcement. By removing that, that should also eliminate the fiscal note associated with the legislation. And so again, the purpose of this bill is to just make sure that the good actors continue to be protected, but those actors that we find are really targeting our youth, that are positioning themselves, in my opinion, to groom youth, especially on Bel Air Road in Baltimore City, and I'm sure you might be able to pull some examples in your district. We want to address that, and I urge favorable passage, Madam Chair.
Thank you, Delegate. What is that? Thank you, Delegate Young. I don't see any questions for you, so thank you very much for your testimony. I don't even want to touch that. I'm going to call on favorables. Justin Hunt. Is Justin Hunt here? Okay. Calling on unfavorables. Bruce Bariano.
I'll be quiet. It's really Bruce Bariano here doing some work with the tobacco wholesalers. And I'll talk more so on the other bill that's coming up next. But these are really zoning problems. They're not, I mean, where these stores are, with the extent they're proliferating all over the place. I mean, counties and cities control their land. Zoning is the most significant power that they have in the development of the neighborhoods and the character of the areas. And a lot of what the sponsor is referring to really is a result of these establishments being developed and being allowed to exist there. And I just think it's something that zoning is a local issue. It's a local power. I think that's where this matter should be discussed and resolved, and not the state legislature to the extent that it wants to be rectified. So I'd urge an unfavorable report.
Was that the end of your testimony, Bruce?
I'm sorry, what?
I wasn't sure. Was that the end of your? Okay.
I didn't hear you. I'm sorry, Madam
I wasn't sure
Chair.
if you were done, so,
I'm done.
okay.
I'm done. I'm done.
Thank you. Seeing no questions, thank you for your testimony this evening. Seeing there are no other witnesses, that concludes the bill hearing on House Bill 1282. We'll now move on to the final bill of the evening, House Bill 918. Delegate Young.
Thank you, Madam Chair. And colleagues, I want to just share with you also that since you all have had such a long night, I've ordered pizza and it has just been delivered. It is in the bag. So I hope you all enjoy it. Dead serious.
Yes, Delegate Young dropped off 6 pizzas. I was going to text people, but since it's...
That's right. That's East-West love, brother. East-West love. Thank you, Madam Chair, colleagues. Once again, Delegate Young, this time here on behalf of House Bill 918. And so again, this is all a nexus of the same challenges, right? We legalized cannabis, and as a consequence of that, we've just seen a proliferation of smoke shops in the city. And indeed, I'm sure that you've seen them across this state. The challenge is that these smoke shops, again, are placed in challenging places, and they are concentrated in our poorest and most minority communities. We also find that these smoke shops are what I like to call the new liquor stores. In the past, the liquor store is where you had the loitering, it's where you had the violence. And we've closed all our liquor stores in the 45th District at 10 o'clock now. And so we've seen that violence go down. However, the challenge has become these smoke shops have taken their place. We know that not all smoke shops are bad actors, but they are bad actors. They're selling illegal cannabis. They're allowing the negative activities to occur on the outside of their establishment, while the owners sit behind bulletproof glass, not worried about what's going on outside. That's unacceptable. I represent East and Northeast Baltimore, some of the most hardest, most difficult neighborhoods in our state. And these are the neighborhoods where I'm finding this tobacco and candy. These are the neighborhoods where I'm seeing these establishments being propped up all over the place. It costs $300 to get a tobacco license annually and to maintain one of these facilities. $300. I told you earlier, it's 1,400 of them now in Baltimore City. I gave you pictures. I showed you the tobacco and candy, but for this one, you want to have the picture that's mostly red. That's a heat map of all of them in the city. But then you're going to also find this one with light green. This is a map of every red dot is a tobacco shop. The darker the color, the less the income of the community. And then this one, which is based on race. The darker the color, the blacker the community. What you will find is that when you go to the outskirts of the city, less black neighborhoods, yeah, you'll still have some tobacco shops, but they'll be concentrated on the main throughways. They'll be in the shopping centers. But when you get down in East Baltimore, when you get down in the 40th District where Delegate Ampry represents, it's on every other block. We've got blocks where it's 4 and 5 tobacco stores in 2 and 3 block radius. If you go to Monument Street in Baltimore City, you go 6 blocks, it's 13 tobacco shops. And we know, based on my engagement with my community, that there's challenges with regard to how they're operating their business. Now, we are talking to the ATCC about the enforcement arm, and there were some challenges with enforcement, particularly on illegal cannabis, that has been cleared up. And so we're working with them on that. But at the same time, we have a responsibility with regard to the atmosphere that we set to allow for what I deem a tobacco swamp. There are amendments that we are going to send to the committee soon. These amendments hopefully will, again, help right-size the bill. The bill as drafted may be a little bit broader than necessary, may catch up some of the other establishments like grocery stores or the rural farms or those type of establishments that we're not really trying to address. We're trying to address these new types of stores that are popping up all over the place. There's also some pushback that's coming from folks talking about premium cigars. We're not worried about the big fat boy cigars. We're worried about the folks that sell in the backwoods, those type of establishments, and the swishers. There was a comment made on the last bill by a good friend, Mr. Veriano, about zoning. The challenge with zoning is that the Maryland Court of Appeals in 2013 ruled that this body passed legislation in 2011 that preempted all other local laws. It was a Prince George's County law, or a couple ordinances in Prince George's County that was preempted. So yeah, that bill didn't quite speak to zoning, but I think the challenge that we face and the reason that we brought this bill is because my colleagues in the Baltimore City Council had concern as they are bringing legislation right now about whether their legislation will get struck down. And so we wanted to make sure that myself, Delegate Hayes, the senator for the 40th District, we wanted to make sure that we had the state provide the opportunity for the City Council to do the work that they need to do. This is a local bill, by the way. It has been before the Baltimore City delegation. We have not voted on it yet, merely because we want to finalize these amendments. It will be back before us this Friday. Let me go through these amendments briefly. The first one is at request of the City Council, which would set a 6-month moratorium on all new licenses in Baltimore City. Thus, we would have a second amendment that would make this an emergency bill. Third, we would provide for public notice and comment period for all new licenses. We want to adjust the state licensing fee. We haven't set a number yet, but I'm looking at $2,500 annually in Baltimore City. The council is also looking to do a tax on lithium-ion disposable batteries and to require these establishments to take that waste as well if they do sell those. So I just want to lift up again, folks. One of the challenges and some of the challenges in the city over the years has been how certain types of establishments that sell certain types of products, how they are good neighbors or bad neighbors. And we want to make sure that any business is a good neighbor. These businesses are popping up everywhere, and many of them are not good neighbors, and we don't want them to be characteristic of our business districts as they are becoming right now. And with that, I appreciate your time. I hope that you enjoy the pizza that I ordered, and I'm going to get me some too, and I urge favorable on the legislation. Thank you, Madam Chair.
Thank you. We'll start with Delegate Ahrens.
Just a brief question. You don't have a mechanism in Baltimore City to on zoning? Or are you saying you can't zone these out, or at least prevent them from coming in?
So that's the challenge, right? Is one would say that we may have that power, but then when you deal with the court case that I referenced earlier, that court case brings in that ambiguity, and so we want to make sure that we, through legislation, ensure that when the City Council does do zoning and other regulation, that they're not going to get overruled by our courts.
Okay. I just thought that would be a way to address it.
I would agree. It's just a matter of making sure that that state law preempts. That's what this court said. We preempted it because we passed legislation that takes over that entire field. So we just need to make sure that they have the carve out to do the work that they want to do without being preempted if they did it without us.
Okay, thanks.
Thank you, Madam Chair. Thank you for the bill, Delegate. As both a legislator and educator in Baltimore City, I see the impact that nicotine and vaping products can have on young people. Could you explain how this bill helps ensure that tobacco and these vaping companies cannot use youth-oriented marketing tactics to influence minors?
Well, I would actually reference the last bill when it comes to the marketing tactics, House Bill 1282, in particular, where I'm really trying to address the advertising to children. But this bill, I think, also can help address it, again, by enabling the city council to have the authority to do the zoning. I mean, they may have the authority, but to make sure that they are clear on that authority to do all the things they need to do. You know, again, the city council is the body that, like your county councils, are closest to the ground. They meet year round, unlike us, and so they are able to be more responsive in a way that can be tailored to making sure that the neighborhoods are addressed appropriately, where these places are placed, and what the advertising looks like, how bright is the lighting, what can be on the windows. These types of things can be addressed in the city council, but we just need to make sure that state law doesn't preempt it, and that's going to require legislation by this body.
Thank you.
Seeing no further questions, thank you very much, Delegate Young.
Thank you, Madam Chair. Thank you, colleagues.
Call on Laura Hale, Jennifer Martin.
Good evening, Madam Chair, Madam Vice Chair, and honorable members of the committee. My name is Laura Hale. I'm the Director of Government Relations with the American Heart Association, and we stand in strong support of this legislation as drafted. We really, truly feel that localities, and we've seen that localities historically have been an amazing partner with the state in addressing tobacco issues. They have used their public health powers to come up with creative local-based solutions that have helped and strengthened. The 2013 Altatus decision stopped all of that. Places like Baltimore City looked at things like Lucy sales and others important creative solutions in the city that was helping their tobacco use rate. Because of this handcuffing that has happened where they cannot be partners with you all in going stronger than the state at addressing this issue, we've seen this proliferation in Baltimore City. In addition, we know that you all work on many, many bills across the state on this issue. As drafted, this bill would not affect Baltimore City's taxing authority or regulatory or authority on licensing. That would remain at the state level. This would truly look at the public health powers and ways that they can address this as a public health issue in the city. And we urge a favorable report on this legislation. Thank you.
Thank you. Good evening, Chair and members of the committee. My name's Jennifer Martin, and I'm the Assistant Commissioner for the Bureau of Health Promotion and Education at the Baltimore City Health Department. I'm here this evening on behalf of the Baltimore City Administration in support of House Bill 918 and to respectfully request an amendment. This bill authorizes Baltimore City to enact and enforce local laws regulating the sale, distribution, and packaging of tobacco and tobacco-related products. In Baltimore City, the Health Department enforces certain tobacco laws, including the sale of tobacco to individuals under the age of 21. However, the city's ability to enforce and create local laws about the sale, distribution, and packaging of tobacco and tobacco-related products has been hamstrung by the 2013 court decision, Altatus USA versus Prince George's County. The Altatus case struck down two Prince George's County ordinances concerning the packaging, sale, and distribution of cigars. And in short, the court determined that counties were preempted from regulating packaging and sale of tobacco and tobacco-related products. This resulted in two provisions of the city's health code being invalidated, including a provision around the sale of unpackaged cigarettes and one related to flavored tobacco wrappings. This bill will restore that authority that was stripped from Baltimore City by the Altatus decision. We want to do more to curb tobacco use in the city, especially among youth, and this bill will help us do that. I do want to note that we respectfully request a simple amendment to repeal Business Regulation Section 16-308.2, which is a provision that created a carve-out for referring cases of unpackaged cigarette sales to the state. Removing the provision would address what would otherwise become a conflict within the article when this bill passes. Again, on behalf of the city administration, I urge a favorable report on this bill with the amendment. Thank you.
Seeing no questions, thank you very much for your testimony this evening, ladies. We do have a favorable virtual, Alex Casper.
Good evening, Madam Chair and members of the committee. Thank you for the opportunity to make comments. My name is Alex Casper, and I'm the Director of Advocacy for the American Lung Association. We have submitted written comments, so I will be brief. I will reiterate my colleagues in the room. We are here in support of House Bill 918 as drafted, which will give Baltimore City local control to regulate tobacco retailers. As you've heard, Baltimore City had this authority prior to 2013, so this bill is just reinstating the authority they once had. Local governments have a unique position to meet the needs of the people who live in their communities. They see firsthand how effective tobacco control policy can evolve over time and can respond more quickly to local needs and tailor ordinances to meet those needs. That is why it's critically important for Baltimore City to be able to have local control over tobacco policy within the city so that they can determine what's best for the communities they serve. We support House Bill 918 as drafted and ask for a favorable report. Thank you for the opportunity to make comments.
Thank you. There are no questions for you. Thank you for your testimony. We have another favorable virtual, Zach Blanchard.
Good evening, Madam Chair. Councilmember Blanchard had to go pick up his kids and ask that I testify in his stead, if that is acceptable.
I'm sorry, could you repeat that?
Councilmember Blanchard had to go pick up his children from daycare. He asked that I testify.
Yes, go ahead.
Okay,
That's
great.
fine.
Thank you. Madam Chair, members of the committee, my name is Joshua Spokes. I'm Director of Legislative Affairs for Councilmember Blanchard. I am here today to ask you to support House Bill 918 and encourage you to advance the legislation. In the past several years, Baltimore has seen an explosion of smoke shops opening across the city. Proprietors often crowd multiple stores onto a single block, taking advantage of our retail vacancy and capitalizing on a gap in our zoning code. This past fall, Councilmember Blanchard introduced Baltimore City Council Bill 25-0114 to close that gap. With House Bill 918, the state affirms Baltimore's ability to regulate tobacco retailers with its land use authority. We believe that this authority to be critical to protecting the health of our residents and rebuilding the vitality of our main streets. As Baltimore looks to make the best use of the state-funded Vacancy Reinvestment Initiative, we are also thinking about how neighborhood-oriented main streets and contributing businesses will boost the city's return on investment. Smoke shops, which predominantly sell products that damage the health of our residents, are exploitative businesses making use of advertising that deliberately entices young people to try addictive products and attracts antisocial behavior. It's not a coincidence that the proliferation of these stores has been in step with an uptick in youth tobacco use in recent years. For those reasons, Baltimore City Council is establishing sensible but not overreaching zoning rules that give residents the confidence that their block will not be flooded with smoke shops. Delegate Young's bill would provide the city with additional authority necessary to ensure that we are able to protect our residents' health, and Councilmember Blanchard respectfully urges a favorable report.
Seeing no questions, thank you very much for testifying on behalf of the councilman. We have a favorable with amendment, Kathleen Hoke.
Madam Chair, members of the committee, I'm Kathy Hoke, a professor at the University of Maryland Carey School of Law, where I teach and practice public health law. I'm also the executive director of the Legal Resource Center for Public Health Policy, which has been working for 24 years to support state and local efforts to reduce the burden on this state of tobacco use. And so I worked on the Altatus case that has been referenced here, and I'm happy to answer any questions about what its implications are and what the case meant. I do want to point out something here first, that quintessential public health happens at the local level. Baltimore City has the oldest health department in the country, and it does incredible work, the City Council and the City Health Department. All they're asking for in this piece of legislation is to be able to address the unique issues that Baltimore City is facing in the tobacco space, to return that power to them. There's no substantive provision in this bill. So what you might hear from opponents, the sky is going to fall, they're going to shut us down, they're not going to allow us to sell this type of product or that type of product or any products at all. All the city is asking for is the power to consider what legislation makes sense for the city. and they will have to go through this process to get anything passed. They will have to publish their bills, have public hearings where people can come and testify and submit written testimony, and make considered decisions as the city council for what is right for the city on this public health issue. So there's nothing substantive in here. Any sky is falling testimony that you'll hear is speculation and ignores the fact that there will be considered decisions by the Baltimore City Council that frankly also have to comport with the law, right? Secondly, when Baltimore City did have, and all of the counties in the state enjoyed local power prior to the court decision, the sky didn't fall. In fact, reasonable measures that you heard from Jennifer earlier, flavored blunt wraps were banned in the city because they were contributing to youth drug use. Single cigarettes were sales were prohibited, enforceable by the local health department to complement existing federal and state law at that point. The sky didn't fall. They asked to be able to prohibit the sale of cheap flavored cigars that were super popular among kids by having a minimum pack size, just like Prince George's County did. That got struck down in that case. So the sky didn't fall, the sky won't fall, but instead you'll return the public health power where it belongs, and that's to the Baltimore City Council. So for those, the amendment is the Baltimore City amendment about making that one change in the state code that's referenced in my testimony. Thank you, and I urge a favorable report on this bill.
Okay, I see no questions for you, Ms. Hook. Thank you for your testimony this evening. We'll now move on to the unfavorables. Matthew Boley, Mike O'Halloran, Kirk McCauley, Finney Helmuth, Kaylee Locklear.
Good evening, Madam Chair. It pains me to say that part. For the record, my name is Mike O'Halloran. I'm here today representing the Mid-Atlantic Petroleum Distributors Association. Our members are the convenience stores that you know by name, that you trust. We are the stores you go to for gas, for your favorite snacks and sandwiches on your lunch break, medicine in the middle of the night when your child has an earache, and with any luck, your favorite six-pack in the near future. I think, look, I think there's agreement, frankly, on what this bill is aimed towards. However, as it's drafted, it very broadly sets a precedent for local control over the sale and distribution of all tobacco-related products. This authority rests with the General Assembly currently, and we believe that it ensures an organized and predictable regulatory scheme statewide. That said, an option that we did share, because again, the sponsor, talked about the proliferation of these smoke shops in Baltimore City, and as I noted at the beginning of my testimony, we are separate and distinct from them. Their customers are, quite frankly, not our customers. So an option that we urge this committee to consider, and you'll see in my written testimony, is the concept of a product directory. This bill has been before this committee before. In fact, Delegate Rogers had that bill in, I believe it was last year. The idea behind a product directory is being an effective tool to stop illicit activity and prevent the sale of counterfeit and illegal products. Products that you'll more than likely see in some of these shops that the sponsor is referencing. There's also an enforcement mechanism there with our friends at ATCC. And I'll wrap up by saying, the idea of a product directory is not only not new, but it has broad bipartisan support. Our neighbors in Pennsylvania and Virginia have passed product directories. So with that, I'll conclude and do urge an unfavorable report on House Bill 918. Thank you.
Madam Chair, members of the committee, my name is Kirk McCauley. I represent service station convenience stores in the state of Maryland. And Mike is right. I just echo everything he said, but by opening the floodgates in Baltimore, every county in Maryland would want the same thing. Every city in Maryland would want the same thing eventually. It would be an absolute nightmare for enforcement. It would also take certainty away from a dealer. I have a dealer sitting back there that has 3 locations in downtown Baltimore. Very challenging place to do business, truthfully. If he wasn't sure he could be selling a menthol cigarette or tobacco next week, it would be pretty bad. I mean, right now, margins are so thin, it's just tough to make a living down there. But he offers other product beside that. He has food, drinks, what the customers want, and gasoline, of course. So if the intention of this bill is smoke shops, then we need to be written out of the bill, one way or the other, with an amendment or whatever. But Maryland collected $390,444,000 from tobacco last year. By opening up the floodgates, that would jeopardize that money. And as long as it's legal in other states around us, in this case, other counties, even other cities, they're really not accomplishing anything. They just got to go somewhere else and buy it. So we urge you to amend this bill if it were to pass and take convenience stores, service stations out of it. You have my written, and I'll wrap it up there. Thank you, and we're urging unfavorable report.
Good evening, Madam Chair, Vice Chair, members of the committee. I'm Matthew Boley of RWL here on behalf of the Premium Cigar Retailers Association of Maryland, which includes approximately 35 Main Street brick and mortar mom and pop premium cigar pipe retailers. We're here today in opposition. I'll be brief as I know the hour is getting late. Of what we heard earlier today about the 1,400 shops that are in the city, 4 of those are our members and premium cigar retailers. We're an extremely small fraction, of this market. And as it pertains specifically to premium cigars and pipe tobacco, we haven't heard, that they are the problem that this bill is seeking to solve. These are premium cigar stores that, are 21 plus only. No kids are allowed in these stores. They're not selling products that kids are interested in. It's frankly an expensive premium product and market. We do fear ultimately, that this legislation could lead to product bans. It could lead to bans that would exacerbate illicit activity and force Marylanders to travel farther and spend their money in neighboring jurisdictions. So in the name of brevity, echo much of what we heard by, my colleagues on this panel. I'll turn it over to Feeney Helmuth.
Good evening. My name is Feeney Helmuth. I've served as the president of the Premium Cigar Retailers Association of Maryland since 2000. As Matt said, we represent approximately 35 small mom and pop retail stores across the state. I also own and operate the Humidor Cigar Shop located in Cockeysville, Maryland for the last 28 years. We provide our employees with health insurance and retirement benefits. They're not just employees to us, they truly are a part of our family. Retailers are already challenging, particularly for small businesses like mine. This bill will make it even more difficult to operate throughout the state. One of our members, Davidas Cigars, has 13 locations across Maryland, 2 of them located in Baltimore City. And they would be required to comply with a different set of rules and regulations in Baltimore City. It'll create unnecessary expense and administrative burdens on them, pulling focus away from serving their customers and growing their business. We experienced this firsthand during COVID when counties implemented different rules. It created confusion for not only the businesses, but for our customers. The customers quickly gravitated to surrounding counties with fewer restrictions, shifting revenue away from the heavy regulated areas. This bill risks repeating that pattern and could drive business and tax revenue out of Baltimore City into the surrounding counties. For these reasons, we respectfully oppose the bill. Thank you.
See no questions for you, gentlemen and ladies. Thank you for your testimony this evening.
Thank you, Madam Chair.
Thank you, Madam Chair.
Matthew Pica, Bruce Bariano.
Good evening, Madam Chair and members of the committee. For the record, Bruce Bariano here on behalf of the tobacco wholesalers. The only thing I like about this bill are the sponsors. They're nice people. But the bill is very dangerous, very, very dangerous. I'm being very serious. Look at the bill. Look at the language of the bill. And I'm starting at the beginning that other than the issuance of licenses and imposing taxes, which is all state authority, the city may enact and the mayor can enforce local laws that are at least as stringent. So they could increase, if this were passed, they could increase the age of buying the product. They could also increase the taxes. They could ban flavored tobacco, which was done in the District of Columbia, and there was robberies and murders with my tobacco clients in Prince George's County because that's where they were getting it because of the ban in the District of Columbia. There's tremendous consequences with this. Baltimore City never had the power and authority, as was said to you. I was one of the counsel with Tim Maloney in an Al-Qaeda case, and it was very clear to the court that the authority of the regulation of the sale and taxation of tobacco products has always rested with the state legislature, not with local governments. If you pass this, other counties are going to come in and want the same thing, and you are going to indirectly, but very directly, affect the collection. You may not like tobacco products. I've never smoked in my life, the funny stuff or the real stuff, but you're going to affect the taxes. Seriously, you're going to affect the taxes collected on the product. Black markets are going to increase, and so the bill has a lot of statewide fiscal and regulatory consequences that are not evident on its face. I would urge an unfavorable report. Thank you.
Delegate Amprey.
Thank you, Madam Chair. Real quick question, Bruce. You said the black market would, how does the black market increase as a result of this bill?
Well, if this were passed and the city under this authority banned certain flavored tobacco, you'd have a black market of Salem or other products in Baltimore City to sell the product because it would otherwise be banned. I've seen that in other jurisdictions. In other words, I'm trying
to say a lot. So we shouldn't ban things because a legal market would also
this bill would give the authority to the city council to ban certain cigarettes. So if you banned a flavored cigarette and there was still a demand or a use for it, they'd either go to another jurisdiction and buy the product, or they'd be in a legal market. It's been done. I saw it. I saw the consequences of the ban of menthol cigarettes in the District of Columbia. The consequences that occurred in Prince George's County, not only in criminally, but also in terms of taxes being lost.
I'm not sure I follow, but it's late, so we can talk about it later.
Well, it says that the city can enforce local laws that are at least stringent.
I get that part. I just don't understand how a ban, the jump, I don't necessarily follow, and I don't think we should not ban things because if we think it's bad for society or bad, I don't think we should not ban it because they'll do it illegally. Like, that's not always but again, I'm tired.
No, I'm not trying to argue. I'm not trying to argue with you. Thank you very much.
Seeing no further questions, thank you for your testimony. Seeing no other witnesses, that concludes the bill hearing on House Bill 918. That concludes the bill hearings for this evening. Before everyone leaves, Business Reg is meeting immediately following this session, and then Housing is meeting following that meeting. We are adjourned.